firm that helped with this. I know that countless hours went into this, and I appreciate that. And I couldn't do it without my team and what they do. And with that being said, I want to thank one more person, and that person is Sandra Aguilar. I would not be here today doing this if not but for her. And that's how important she is. But more importantly, what we're talking about today is that important to her. And so please give her your attention today and know that we're here because of her today.
I'm gonna get a little emotional after hearing you say that. And I just want to thank everybody for being here. I shared with a couple of y'all that this has been a dream of mine and on my heart for like the last 8 years to put something together where we can educate attorneys, judges, clinicians, parents, and just, you know, all people about both sides of this, because whether you have a target client, favorite client, or whether you're the clinician on the case and you're seeing some of those things come up and rise up, or maybe you're doing an assessment on the family and you're seeing some of those issues, the bottom line is the impact on the children. And that's where my concern is. I do work at the law firm. I love what I do, but I'm a clinician, I'm a therapist, and that's where I start. And that's how I look at cases. And Brian and I and Mr. Grove and Matt Hill and some of the other attorneys and Janice, we have arguments sometimes about how you litigate and how it impacts. And so, but it's a good conversation, and it's the best way to look at a case. And so the purpose for me and the reason for today for me is how it impacts children, and for us to be better educated about how we pick these cases. I think they're the hardest cases when we have them. Whether you are the attorney and you're first interviewing a client that comes in and these are the, you know, my children don't want to go see their dad, and or I haven't seen my children in this many years, or whether you're the clinician and somebody's bringing you the case to do some reunification and you're already like, how do I do this? What do I do? And so on all ends, these cases are difficult. It's not just difficult on one end, they're difficult on all ends. And so anyway, I just want to say thank you for making the time to be here. Thank you for all the people that are watching online. And we're going to have an opportunity to ask questions of Dr. Burnett and Ashish and Mr. Garza. So utilize that time to ask some questions in the Q&A section. Okay, and with that, I want to hand it over to Dr. Bill Burnett.
Hi, good morning. It's nice to see you all. So I'm Bill Burnett. I'm a child psychiatrist and a forensic psychiatrist from Nashville, Tennessee. I've been a professor at Vanderbilt University School of Medicine, and I'm now a retired professor. So I have a lot of time on my hands. I go to a lot of meetings and I do presentations and write articles and book chapters. So as you know, my topic here is called Parental Alienation Theory, Basic Training for Clinicians and Attorneys. So in the next hour, I'm going to give a broad overview of parental alienation. And I'm actually sort of checking the time here. There's a little clock here on my video, so I just want to make sure I can keep an eye on that. So so in this hour, I'm going to go over a number of topics and give you this general overview. And I'm sure later today, some of these topics and other topics are going to be addressed in greater detail. So this is my outline. Whenever I give one of these talks, we really need to start with the definition of parental alienation, because people have different ideas of what that means. I'm going to give you an idea of what it looks like clinically, a little clinical presentation, and then how do you make the diagnosis? Or some people don't like to use the word diagnosis. How do you identify parental alienation? And then I'm going to talk about professional organizations that have recognized alienation. That comes up for attorneys a lot, because sometimes the reality of parental alienation is challenged in court, like in a Daubert hearing or something like that. And so one of the criteria in a Daubert hearing is has this concept been recognized by professional organizations? Then I'm going to talk a little bit about research and a little bit about interventions. So as you can see, we have a pretty good schedule. Okay, here's a definition. This is one thing here I want to read together with you. Parental alienation is when a child, usually one whose parents are engaged in a high conflict separation or divorce, allies strongly with one parent, whom we call the preferred parent, and rejects a relationship with the other parent, whom we call the alienated parent, without a good reason. This is a fairly common definition. Lots of people, even the people who criticize parental alienation theory, I think, accept that this is a reasonable definition of what we're talking about. So a lot of people like, a lot of people like diagrams, you know, family diagrams. And so in this little diagram, you can see that the alienating parent and the alienated parent are in conflict. And of course, they blame each other. The child doesn't want to go see one of the parents, or this is called parent-child contact problem. And each parent blames the other for why that happens. So, whoops. Well, here, this little yellow arrow that blinked for just a moment. Hey, let me see if I can make this happen again. See, there's my little yellow arrow. So that is the parental alienation. In other words, the little yellow arrow is what's in the mind of the child, the mental state of the child, and the child's rejection of the alienated parent. And the big red arrow is what we call alienating behaviors. So the activities of the alienating parent through alienating behaviors influences the child to reject the other parent. Now, I'm kind of dwelling on this because I want to make sure you understand that people have slightly different terms for this. Not everybody uses exactly the same explanation or definition that I just used. For instance, parental alienation, people have different words for what we now call parental alienation. So that creates a little bit of confusion in the literature. And not only that, people use the word parental alienation for other things. For instance, some people use the term parental alienation for the big red arrow, for what the alienating parent is doing. We try not to do that. We try to use parental alienation for what's going on, the mental state of the child, and alienating behaviors for what the alienating parent is doing. But don't worry if somehow you read something and there are slightly different uses of these words. So I want to demonstrate what this condition is like. And I'm going to tell you some little clinical vignettes, and they're different from any clinical vignettes that are usually used. For instance, you know, if you read a textbook or something like that, and you have a little clinical vignette, typically it's a little tiny case history, like this is what the mother did, this is what the father did, and so on, and this is what the child did. So you can do that, but I find it more dramatic to show you some pictures. I'm going to show you some drawings that children have made that illustrate the mental state, the mental condition of the child who is alienated. I got to warn you, some of these are very touching, and some of them are sad. They're almost heartbreaking. Anyway, take a look at this. So here's a drawing that a little girl did. And this is normal. This is prior to becoming alienated. And then at the bottom, she says, "I love you, Mom." And it's a nice picture with hearts and everything. So a couple of years later, the same girl writes the following notes. If you can read this, One of them says, "Go away, you don't belong in this world or house." And the other one says, "No one has loved you. No one ever did or would love you." So this is the same little girl. So what happened to her? This is an extremely hostile message, which is also very, very sad that a little girl has gotten to that point. Here's another example. Okay, so this is another little girl, different person. I'm going to read this for you. It says, "Dear Dad, there is only one person in the world to be my daddy, and that is you." And if you see the little dot, that's kind of cute. It says, "Drum roll, please, love you," and so on. So this is also a normal little note that a child happens to write. I'm not sure what the occasion was that she wrote this note, but I got to warn you, a couple of years later, this child is a totally different person, and she's become severely alienated from her father, and she has an extremely disturbed opinion about her father. So this is what she drew. On one side, it says, "Unsincerely me," and then it says "sword" with blood on it. And then she's cut off his head. It says "you, head unattached." So my point is that children who are severely alienated develop these extremely abnormal opinions about their parent. You know, how does she get there? How does she ever get to the point of contemplating her dad's head being cut off? But that's what happens in these cases. Incidentally, it says severe alienation. I need to tell you, I'm not diagnosing it based on the pictures. I collected these drawings from parents, and I collected little case histories. And so I know from the case histories from the parent what's wrong with the child. So, and these children are alienated, and most of them severely alienated. But I just want to make it clear that you don't diagnose somebody from a picture. Okay, so here's another one. This is a little girl who draws a picture of her family, and she says, "I love," what does she say? I love my mom and dad and my whole family. And then she says something about her sister. Her sister's her BFF, and it's fun to love. And then there's this family picture with the little girl and her mom and her dad. And actually the sister is in the picture too. The sister is behind the blacked out area. So I don't know, whatever. She drew a picture of her family and then she crossed out her sister, which I guess that's interesting. Anyway, this is a normal child at this point. So this is also about the same time. To Daddy from so-and-so, I love you. This is kind of like a Valentine picture or maybe a birthday picture or whatever. So I'm going to show you, though, her scrapbook or her logbook that she later wrote in. And I'm going to read what she wrote. She wrote a little story, and very nicely. It's very nicely printed in this spiral book. And it says, "This story is called He and She and the Kids. She had the kids. She gave the kids to him. The kids didn't want to go. He gave the kids back. She had the kids. She gave the kids to he. The next day, he took the kids. He got shot by a tank. The kids lived happily ever after with she." So this is a kind of gruesome story where this little girl has a fantasy of her father being killed by a tank, a military tank. How would she ever get to that idea? I mean, I'm trying to make the point that children with severe alienation, they have a mental condition. They have an abnormal mental condition. So here's the picture of the tank. Well, on the one side, it says Army people something to attack. And then there's a picture, which I'll show you here. There's a picture of a tank firing a cannon and looks like what do you call this? A troop carrier, anyway, a truck with soldiers in it. So that's an example of a severe alienation, a little child becoming so misled that she's contemplating the horrible death of a parent. Okay, I have a couple more examples. These are self-portraits. This is a picture drawn by a little girl. And for any of you who have ever done work with children, you would immediately say, this is a very abnormal drawing by a 9-year-old girl. The content is abnormal. I hate my life. I mean, there's scars and so on and so on. You can analyze children's drawings by their content and their form. And the form is also abnormal in that this is the see-through form. And it's a stick figure and there are no clothes on it that are noticeable. And anyway, that's a very, very primitive way for a child to draw a picture of herself. So if you happen to be doing counseling with a child and something like this turns up, this is grossly abnormal. And if you ever have that happen, you should try to investigate what's going on with her and in her family. Here's another self-portrait from an older child. This is interesting. This girl is fairly talented as an artist. I don't know if you recognize this picture. I think I've seen this picture or variations of it in magazines where it says, learn how to draw. And there's a picture of a woman, except not weeping. And I think sometimes it's used in drawing classes as a model, but this girl adapted it to her own needs, and she's very unhappy. Once again, I obviously would not diagnose alienation from this picture, but I know that from the history that it was provided to me. Here's one more. This is also a high school student and a picture drawn, and actually we have this because this picture was shown in an art show in her high school. And I think it's well done, but it is sort of interesting. To me, the mouth seems kind of prominent and the features seem prominent, but whatever, but it's a good drawing. But what you don't see yourself are the eyes. I'm going to give you a close-up of the eyes. I don't know if you can read what it says, but the two eyes say, help me. You can see the writing inside the cornea of the eyes. So I think these pictures, my point is to give you a little snapshot of how mentally disturbed these children are. It's kind of like a delusion. These children have a false belief about a parent, and they express it. It's not exactly the same of a regular delusion, but it is a false belief. So those are only little snapshots. What I want to make sure you understand is that this is not the way to diagnose parental alienation. Now I want to tell you how to systematically diagnose. Some people don't like the word diagnose, so you can say identify if you want, how to systematically identify parental alienation. And my friends and I have put together what we call the 5-factor model for the diagnosis of parental alienation. There are some of those are on the table. I think some of you have a copy, but this is going to be available online. Everybody who's here and everybody who's watching the video are going to get sent this article that I'm talking about right now. The 5-factor model for the diagnosis of parental alienation. So what happened was my friends and I Amy Baker, Larry Greenhill, and some other people pulled together what has already been well known about how to identify parental alienation. We didn't dream up anything new. We simply pulled together, and starting with Amy Baker a few years ago, pulled together what has already been established in research as to what should be the definition or the diagnostic criteria for this condition. And I'm going to run down these criteria for you, since this is how, this is probably not the only way, but this is a good way for a clinician to diagnose parental alienation. So the 5 factors are, these are all very basic and very visible. The first one is the child says, I don't want to go see the other parent. The child refuses a relationship with a parent, even though the child had a prior positive relationship with that parent. Also, number 3, absence of abuse, neglect, or seriously deficient parenting by the rejected parent. In other words, what we're saying here, the child's rejection of that parent is not because of anything that parent has done. The parent has not been abusive or neglectful in the past, which would explain the child's rejection. Number 4 are alienating behaviors, multiple alienating behaviors by the favored parent. If you recall, that was the big red arrow in that family diagram that I showed you. Those are the alienating behaviors. You have to find those. If you want to make this diagnosis, you have to find specific alienating behaviors and document them. And 5, the behavioral signs of alienation in the child. So the first 3 are fairly obvious. 4 and 5, I'm going to explain in a little bit more detail. These are the alienating behaviors that have been established by various people in research, by investigating cases and finding out what was it that the alienating parent did to cause this to happen. So there are about 18 or 20 of these altogether, but I just picked out some of the more dramatic ones. Denigrating and criticizing the other parent. So that's something that the alienating parent does incessantly, that he or she makes fun of or criticizes, finds fault with the other parent. No, not just to the child, but to other people, to school personnel, to therapists, to attorneys, to judges, that you can try to do an evaluation of that parent, and the alienating parent will automatically digress to criticizing the other parent in this persistent manner. Another obvious alienating behavior is limiting contact with the other parent. So these parents find ways to keep the child, from going on their visitation or parenting time. Jimmy is sick today, he has to stay home. He can't go see anybody. Or I just learned that Jimmy has a birthday party this afternoon at a friend's house, so he can't go on parenting time. So they find many reasons for limiting contact. Interfering with communication between the child and the parent. That has to do with phone calls or text messages or whatever. The non-custodial parent tries to say hello to the child or send a message, and the alienating parent won't let the message get through. Changing the child's name to remove a connection to the other parent. What happens is when they go to school to register the child for school, the alienating parent will use her own, for instance, her maiden name or the name that she's now using for the child, even though the child's name is actually the dad's name. So these are some common, some of the more dramatic alienating behaviors. I said there are like 17 or 18 or 20 of these. Here's a couple more. This is very common. And the alienating parent does this all the time, and they don't realize that they're not supposed to do this. I mean, so they're oblivious that this is not proper. Allowing the child to choose between his or her parents. In other words, the alienating parent will say, honey, you're supposed to go see your daddy this summer for a week. Do you really want to go? You're 10 years old. You can tell me Do you want to go? Do you not want to go? You can decide. You're old enough to decide. And that parent will tell the evaluator. If you do a custody evaluator, the parent will come right out and say, yes, I told my 10-year-old child that they can decide whether they want to see their daddy this summer. And because the parent doesn't realize that is an absolute inappropriate thing to do with a 10-year-old. I'm kind of dwelling on this because the idea is that identifying these cases and these alienating parents isn't usually hard. Usually what they're doing is obvious, and they even come in and tell the evaluator what they're doing because they have no insight into these behaviors, that this is improper. Here's another one. This is a common one, creating the impression that the other parent is dangerous. Well, they don't come right out and say, you know, your mother is dangerous. They don't do that. What they do is they say, honey, when you go see your mommy this weekend, if anything bad happens, call me immediately and I'll come and pick you up. Or they might even go one step further, honey, if anything bad happens this weekend, call 911. You know how to do that, don't you? Let's practice 911. That's what you should do if your mommy does anything that bothers you this weekend. In other words, it's obviously communicating that the parent is a dangerous person. Another one, asking the child to spy on the other parent. Another one, referring to the other parent by his or her first name. Instead of saying, your mommy is coming to visit, to pick you up, they'll say, oh, Mary Jane is coming to pick you up. You know, they won't use the term mommy and daddy. So anyway, those are some of the most common alienating behaviors. And I'll tell you for the 10th time, to make the diagnosis, you got to find these. You have to document them. You can't just say, oh, the child is alienated because he doesn't want to see his other parent. You have to demonstrate where that's coming from. And it's usually easy to do in the interview with the parent, or in text messages or emails or letters, or even court filings. Sometimes you can see alienating behaviors. So that was factor 4. So this is factor 5, which are the behavioral manifestations in the child. Let's run down these. They also, the first one is also campaign of denigration of the other parent. In other words, the alienating parent manifests a campaign of denigration, and so does the child. The child will come in and say, oh, Dr. Burnett, last time I forgot to tell you some of these things that daddy does, and I just want to make sure I'm telling you today. Or they'll tell the attorney, or they'll tell the judge. Then they'll list, there's a standard list of things that they'll recite. And then they'll have frivolous reasons for having this rejection. I use this example a number of times. A 12-year-old girl lived with her mother and had regular parenting time with her dad and stepmother. And I was evaluating her. And I said, well, I guess you visited your dad last weekend. And she said, yes, we did, I did. And she said, well, and I never want to go there again. I'm through going to visit my dad and stepmother and his house. And I said, okay, well, tell me about it. And she said, well, whatever. And I said, well, why? What's your reason for not wanting to go visit your dad ever again? And she says, I don't like the way he decorated my room. Would you believe it, Dr. Burnett? He decorated my room in a way that I can't stand, and I never want to see him again. So that's a good example of a frivolous rationalization for rejecting that parent. Lack of ambivalence is another characteristic of alienated children. Normal children are ambivalent about other people, like their parents. And what that means is when they think about mom, there are some good things about mom and some not so good things about mom that I don't like. And same thing for dad. That's ambivalence regarding a parent because they have both good and bad feelings about each parent. That's normal. Alienated children lack ambivalence, which means that one parent is totally good and the other parent is totally bad. And that's a very prominent feature. There's nothing new to that. People for 30 years have described that. All sorts of writers, proponents of alienation, critics of alienation, describe this lack of ambivalence. And in a few minutes, I'm going to tell you about my own research on this topic. Another feature of alienation is the independent thinker phenomenon. And the reason why that's in quotes is because the child is pretending to be an independent thinker, but really isn't. And typically the child will volunteer, not upon questioning, but the child will come in and volunteer, I never want to see my mom again, and that's my own opinion, and nobody has suggested that to me. So that's a so-called independent thinker because the child isn't really an independent thinker. Incidentally, these 8 signs of alienation are usually observed in an evaluation. They're not necessarily observed in everyday life, because when these were originally written up by Richard Gardner in 1985, he was describing what happens when you conduct an evaluation of these children. So these 4 and then another 4 are things that he observed and we observed during an evaluation. For instance, lack of ambivalence can be elicited in a perfectly good custody evaluation in these children, but they might not manifest it in the outside world. And so also the independent thinker is something that typically comes up in an evaluation, because the kid comes in and says to the doctor, these are my own ideas. Nobody told me to say that. And that's not something they would typically say in the outside world. So anyway, those are 4 of these 8 signs. Here's the other 4, and this is all factor 5, reflexive support of one parent against the other. So that means, and like if you're having a family meeting, for example, and there's a discussion and one parent has an opinion about something, the child will automatically take the side of the favored parent and automatically reject the opinion of the other parent. So this is also observed in evaluations. Absence of guilt toward the rejected parent. I had one child a boy who said, yeah, we're waiting for dad to die because I know that we have a really good insurance policy on him. So we're looking forward to that. Absence of guilt. Borrowed scenarios means that one parent, the preferred parent, will come in and have various examples of the other parent's misbehavior, so-called misbehavior, and then the next day the child will come in and give the same examples. And sometimes this is blatant. And occasionally the child will come in and say, well, I want to make sure you know that daddy did this, this, and this. And I said, well, tell me about that. Tell me what happened. And the kid would say, well, whatever. Mommy sat me down last night and told me those 3 things. And now I'm telling you. So it's fairly blatant that these are borrowed scenarios. And finally, animosity to the extended family. That means that the child doesn't want to see daddy anymore, but also the child doesn't want to see his grandparents or aunts and uncles. So these 8 things in factor 5 were written about by Richard Gardner in 1985, repeated by him a number of publications, and other people have repeated this dozens of times. And it is interesting that these 8 factors have really borne the test of time, that we use the same 8 factors now that he introduced in 1985, because they've been seen by so many people and they seem so indicative, not one at a time, but certainly all 8 together are indicative of parental alienation. So here's another way to think about this, that children in these situations make these false statements. Daddy did this, daddy did that. And the more often you make false statements, you start to have false beliefs that these things that I'm saying are really true. I think adults do that. They say something over and over again, and they start to think that, oh, that's really true. And then sometimes they have false memories. They start to create false, factitious, fabricated memories of these events that never happened. Side issue, sometimes it happens in abuse allegations, that sexual abuse allegations, sometimes children have different reasons for why they remember these things, and these things never actually happened. Sometimes. Okay, now just to make sure people have the terminology straight, this is a very common distinction between alienation and estrangement. Alienation is when the child rejects a parent without a good reason. The child's rejection is far out of proportion to anything the parent has done. And estrangement is the child rejects a parent for a good reason. And I mentioned that that's factor 3, history of abuse or neglect. These terms, I realize that in the dictionary, these terms mean about the same thing. But in legal settings and in the writings in this field, these have taken on, what's the legal term? They're terms of art. They mean specific things in parental alienation theory. Alienation is without a good reason. Estrangement is rejection for a good reason. And these terms were defined in an important article from it's known by Kelly and Johnston, a famous article that they wrote, and we've been using these terms consistently ever since. At least we try to. Okay, so this all had to do with how do you identify or how do you diagnose alienation? And now let's talk a bit about recognition by professional organizations. And like I said, you might need to know this if you're involved in a Daubert hearing. For instance, I'm giving you just a few examples here. I'm a member of this organization, AACAP, the American Academy of Child and Adolescent Psychiatry. And years ago, in the 1990s, I helped write this document, Practice Parameters for Child Custody Evaluation. So this is a document that tells child psychiatrists how to do a custody evaluation. And this was adopted by the board of directors of AACAP. In other words, this is an official action. This isn't just a random article by some child psychiatrist. And there's a whole paragraph, it's a whole section in this official action with the heading, Parental Alienation. And it describes briefly what happens. And it says the evaluator must assess the apparent alienation and form a hypothesis of its origins and so on. So it's a good example as a formal official statement of an important organization, child psychiatry, in which they recognize the reality, the concept of parental alienation. Now, why do I say this? There's all these people who say no organization, no professional organization in the United States has ever recognized parental alienation. That's false. That's misinformation. That is stated over and over again. And when you were in court, if I'm testifying about this, the opposing expert will get up and say that Dr. Burnett is talking about some concept that has never been accepted by a professional organization. And that is not true. This is a document from 1990s, but there are more recent ones. Many of you might belong to this important organization, AFCC, the Association of Family and Conciliation Courts. They produce standards also for how to do a custody evaluation. And a couple of years ago, they revised it, and this is what it says now. Though the old one said this too, but the new one also mentions alienating behaviors. Custody evaluators should have education and training in various things, including parental alienating behaviors. So this is an extremely influential organization, AFCC. Many judges, attorneys, mental health people belong to this. And they acknowledge the reality of alienation. Here's another one. Oh, this is from the same organization. But a few years ago, we gave in Denver, we gave a talk about this. In fact, it was a panel discussion among various people, pro and con about alienation. And it was a keynote event. And there were maybe 700 or 800 people in the audience. And we took a survey, some of the people took a survey afterwards, and they asked this question. Do you think that some children are manipulated by one parent to irrationally and unjustifiably reject the other parent? And of the people who responded, hundreds of people responded to this survey who attended that event, 98% said yes. does happen that children can be manipulated by one parent and so on. And so that's not an official endorsement by AFCC, but it's a really good indication that the membership of AFCC accepts the concept of alienation. Here's another one of these. The American Psychological Association also creates guidelines for how to conduct a custody evaluation. And they do the same thing. This came out just also only a couple of years ago. And they also talk about alienation. They say down here, these parent-child contact problems are sometimes called various things, including parental alienation. If you actually, you should get a copy. If you don't have it, it's easy to get. The APA website posts the various guidelines and you can download it from 2 years ago. And it mentions the word parental alienation 20 times in these guidelines, in the text and in the bibliography. So I think it's fair to say that the APA, American Psychological Association, endorses the concept of alienation. One more, which is the American Psychiatric Association, which publishes the DSM, the Diagnostic and Statistical Manual of Mental Disorders. And what I like to say about this is that we know that the words are not in the DSM. The words parental alienation are not in the DSM, but the concept is there. The new one, the DSM-5-TR, which came out about a year ago, the concept of alienation is expressed in several, in the descriptions of several diagnoses. For instance, listen to this description of child affected by parental relationship distress. That's a diagnosis with very cumbersome title, CAPRD. And it is negative effects of parental relationship discord, like high conflict and so on, disparagement on a child and the family. So that's a paraphrase of what happens in parental alienation. It's not the words, but it is a paraphrase. Here's another example. Parent-child relational problem. Negative attributions of the other's intentions, hostility toward the other, and unwarranted feelings of estrangement. That's also a paraphrase of parental alienation in the DSM. Now, unfortunately, the writers of this section use the word estrangement when they really meant alienation, because if it's unwarranted feelings of rejection are alienation, and estrangement are actually warranted feelings. So we've tried to get this straightened out. We've written to the DSM people, we've sent in proposals, we've tried to get them to correct this one word. And they write back, and I have all this correspondence, and they say, don't worry, Dr. Burnett, parental alienation is in fact included in this diagnosis, parent-child relational problem. That's included, as you can see in these words. And that means that if a clinician has a condition of alienation, you can use this diagnosis. So this is the people at the DSM actually telling us that they agree that the concept of alienation is in the book, even though the actual words are not. So you might wonder, why aren't the actual words there? I think it has to do with controversy, that they knew that when the DSM was being put together, they knew there was a huge discussion about this concept, and they didn't want to get in the middle of the discussion, of the arguing. So they use paraphrases in 3 different places. Now I know this. I mean, I know the people who wrote this chapter, and we've worked together. So I know that they did this on purpose. But I think the end result is, I think it's correct to say that the concept is in the DSM, even though the actual words are not. This is my Texas bandana here. Okay. So let me give you a little overview of research, because this also comes up, of course, if you have a Daubert hearing. And I already told you the 8 behavioral symptoms of alienation, factor 5. So some of that, see, there's underlying research for factor 4 and factor 5. For instance, for factor 5, Amy Baker and Doug Darnell published a paper in which they interviewed parents who were alienated from their children. And they found out, they created a list of the behaviors of the alienated children. And these are the same things that I just told you. The campaign of denigration, frivolous reasons, the lack of ambivalence, and so on. And the percentages in which the group of parents reported it. So that's fine. In other words, this research by Baker and Darnell is basically reproducing what Richard Gardner said in 1985. And that's what they concluded. In general, these findings support Gardner's observations of the 8 symptoms of PAS and so on. In other words, these 8 symptoms, we didn't just dream this up. They were originally expressed by Gardner after he had done many, many custody evaluations, and then they've been recreated or validated in this type of research. There's also research on alienating behaviors. Amy Baker and Doug Darnell did 2 different kinds of investigations. One is they interviewed alienated parents, and they asked them to describe what are the things that the favored parent did to cause the alienation to happen. And they collected hundreds of examples, and then they boiled it down to 17 or 18. And then they also interviewed children of alienation who are now adults, adult children of alienation. And they asked them, what did your parent do when you were children to cause you to reject a parent? And so it's 2 sources of information. So my point is that factor 4 and factor 5 are not just, dreamed up, that they're actually based on empirical research. So I want to tell you about my own research project. Since I'm giving a talk, I get to talk about my own project. So this has to do with what I said about lack of ambivalence. Lack of ambivalence, many, many people have described that in many articles and book chapters for 30 years. But my friends and I wanted to see if we could measure the lack of ambivalence quantitatively, or it's also called splitting. Can we measure splitting quantitatively? So that's what we try to do in this project. And we had to distinguish, we had some subjects who were alienated, some who were neglected, and so on. So we had different groups. We had 5 groups of subjects. And we used this particular test. This is a questionnaire that's called the PARQ, P-A-R-Q, Parental Acceptance Rejection Questionnaire. And the child is asked questions about mom and also asked questions about dad. I don't know if you can see that, but some of these are positive, like, so-and-so, my father says nice things about me, and the child indicates how much that happens. And some of them are negative. My father does not really love me, and they check off the answer. And by doing this with questions about mom and dad, you can quantitatively determine how much the child thinks mom rejects or accepts them, and how much does dad accept and rejection. No. So what you would predict that normal children would say about equal, that mom mainly is accepting, but might be a little bit rejecting at times. Dad is mainly accepting, but might be a little bit rejecting at times. That is normal. By and large, they see both parents as being accepting. Alienated children, what you would predict is that they would be split, that one parent would be totally accepting in the child's view, and the other parent would be totally rejecting. So that's what we predicted, and that's what turned out. So let me just tell you what this generally means. On the right-hand side are alienated children. And the low bar is acceptance and the high bar is rejection. So the children who are alienated from their father perceive the father as very, very rejecting, and the mother is totally, totally accepting. And the same is true in the reverse, that if the mother is the alienated parent, the father is totally accepting and the mother is totally rejecting. And that's not true of the control groups. In other words, we have other groups of intact families, of divorced parents, even neglected children. This is a very, very dramatic quantitative investigation of splitting. And there's another way to look at that. The difference between the highs and the lows is a gap. So the alienated children have a very big gap between mom and dad. And so we created this new term, which is the gap. So on the right-hand side are the alienated children, and they have very high gaps between the mother score and the father score. And all the children in blue on the left-hand side are non-alienated children, and they have very low gaps, which means they perceive mom and dad almost the same, with 99% accuracy. So see that one little red spot on the left-hand side? That's one child who was severely alienated, but she had a low gap. So that's interesting. I mean, that's common. What happens in research is you don't get 100% success, but 99 is a very high level of success in psychological research. I mean, is there any other psychological test that can give a result with 99% reliability? Now, I need to warn you, this is not a test for parental alienation. This is a test for splitting. And as I said before, splitting or lack of ambivalence is only one of the 8 parts of factor 5. And factor 5 is only one of 5 factors. So we keep telling people, we're not saying this is the test for PA, but it can be used as part of an evaluation. So I'm trying to give you an overview of the research on this topic. And a couple of years ago, a really, really good review article was published by Jennifer Harman and some other people called Developmental Psychology and the Scientific Status of Parental Alienation. If you really need to look up a good overview of, there are more than 200 research projects described in their paper and summarized, and everyone is listed and so on. So this is a review article of PA research, quantitative research, and it's very convincing. And incidentally, see, that's another Dalbert criteria. Has there been research regarding this project published in peer-reviewed journal? So, okay. I want to talk for a minute about what to do about alienation or interventions. But first I have to educate you about one more issue, which is alienation is not all the same. There's mild, moderate, and severe. And that's true of many psychiatric conditions. Depression is mild, moderate, and severe. Schizophrenia can be mild, moderate, and severe. So we've given definitions that we think are good for mild, moderate, and severe. So this has to do with interventions because you have different interventions depending on the severity. So you have to understand this little piece first. Mild. The child says, I don't want to go see daddy, but the child goes anyway and is fine. Once he gets out of the mommy's driveway and to daddy's house, he's fine. He has a good time with daddy. It's PA because the child is saying, I don't want to go see daddy, but it's mild. Moderate, the child says, I don't want to go see daddy, and the child goes and might be okay at moments, but generally is negative and oppositional. So those are very difficult times. The child spends a weekend with daddy and it's difficult on everybody in terms of the child's resistance and negativism. Severe, the child says, I don't want to go see daddy, and is persistent and adamant in the refusal to go. And sometimes they haven't seen daddy for years. Occasionally they do go see daddy with a court order, but even then they're persistently totally negative during the weekend with daddy. For instance, they stay in their bedroom, they get on their phone with mommy and talk the entire time. They refuse to have meals because they claim that daddy is poisoning them, and so on. So that's severe. So what are the interventions? The interventions depend on the level of severity. For instance, in mild cases, sometimes you can just tell the parents to shape up. So I think the legal term is admonish. The judge might admonish the mom and dad to shape up and don't interfere with your child's relationship with the other parent. And if anything, encourage the child's relationship with the other parent. And a judge might do that, or a psychologist or a therapist or a friend might help the parents to stop what they're doing. Moderate is much more complicated. A typical, because in moderate, the kid has adopted these negative feelings more deeply. And typically you have to intervene comprehensively with everybody. And there are several different ways to do that. One is called multimodal family intervention. I mean, I'll tell you this, but you can see how it's unwieldy somewhat. You have a parenting coordinator who meets with the parents and is in charge of the whole thing, and that person reports back to the judge. The judge has to order this whole shebang to be in place. There is a coach for the mother to help her change what she's doing. There's a coach for the dad to help him change what he's doing. Usually there's a therapist for the child. Sometimes it's a family therapist. The attorneys have to be on board. The GAL has to be on board. So it's a very comprehensive program because you have to get the alienating parent to stop doing what he or she is doing. And you have to meet with that parent regularly and monitor the children. And all these therapists have to be in touch with each other. So this is a very complicated, comprehensive way to treat a disorder in a family. But you have to do that if you want change to happen. Now, what's interesting about these programs, sometimes they work and sometimes they don't. If they work, it's therapeutic. If after 2 or 3 months, people shape up and the child is going back and forth and is reasonably happy, you can say that the program was therapeutic. But suppose it doesn't work. It should be diagnostic if it doesn't work. Because after 2 or 3 months of this type of program and all the therapists communicating with each other, you should be able to figure out, why isn't it working? Who is sabotaging the progress? It might be the parent. It conceivably could be a friend of the family. I've had a case where it was a friend of the family, could be a grandparent. But if this kind of comprehensive program doesn't work, usually you can figure out who's interfering. What about severe alienation? So those are cases where the child has avoided the parent for months or years. We consider that child maltreatment. That if an alienating parent is causing a severe level of alienation in the child, we think that parent is engaging in child abuse, child maltreatment, psychological child abuse. What do you do in child abuse? You have to remove the child from that home. So we think that in severe cases, the only remedy is really to remove the child from the home of the alienating parent and get the child into a neutral place. So where do they go? I mean, sometimes they go to the other parent and do fine. Sometimes, in other words, they go to the parent that they have been rejecting and they do fine, but sometimes they need some therapy to kind of get through that initial time with the other parent. Sometimes they go to a neutral place for a while, like a boarding school even, And from there, they get reconnected to the rejected parent. I had one case where the child went to an uncle and he did fine. He eventually reunited with his mother. So anyway, the interventions is not a simple topic. And the answer is, it depends. But there's published research on this. Let me just tell you the article. It says an article about family reflections, which was a program in Canada, in which 95% of the children were successfully reunited with the other parent. There was an article about family bridges by Richard Warshak, in which about 90 to 95% were successfully reunited. He made the point that some children relapse after a period of time and want to go back to the alienating parent. And according to Warshak, that usually is because there is premature contact with that parent. Is usually, in these severe cases, there has to be a suspension of parenting time with the alienating parent in order for the child to remove himself from the power of that person. And thirdly, there is another program that Linda Gottlieb has called Turning Points for Families, and an evaluation was done of that program, and it was also found to be successful. So I just summarize this. My point is that there are 3 intensive programs for severely alienated children: family reflections, family bridges, turning points, and all of them were successful in 90 to 95% of cases. So that's a real quick overview. So thank you for taking part in this. I'm the president of this organization called Parental Alienation Study Group. That's our website, pasg.info. So if you want to learn more, or if you want to stay in touch, come to our website, sign up, become a member. And that's a good way to continue learning about parental alienation. So let's see. I don't know exactly how to turn that off, but I think we're going to have a few minutes for questions and
Yes, sir.
discussion.
Yes, we are. Do you want to continue to
No, why
take the
don't
question
you
from
take
there?
the
I'll be
question?
right here beside you. Does
Oh,
anybody have a question? Yes, ma'am.
The child from the appropriate if the child is not refusing contact and is attending visits.
Okay, so I want to make sure that I understand your question. So at what point is it appropriate for the recommendation to be made to remove the child from the alienating parent or the favored parent and place that child with the alleged target parent, alienating parent? Like, at what point is that? When can you do that if the child is not rejecting? Okay, rejecting or refusing or rejecting. Okay, that's the question.
so these are severe cases. I think you're referring to severe cases of alienation where the child has refused that parent for months or years, has no interest at all. And you can also demonstrate that the favored parent is causing it to happen. In other words, you can demonstrate that there are many alienating behaviors and that parent won't listen to any kind of suggestion of what he or she should be doing. So that's what we consider child abuse. And generally in child abuse, you should remove the child from that family.
So if I understood the question correctly, Dr. Burnett, is that the kids are not, or kid or child is not yet rejecting the parent?
Oh, okay.
And is it appropriate at that point to?
Okay. Oh, okay. So let's rephrase this a bit. So I think what you're saying is there may be alienating behaviors, but the child is not yet alienated. So generally, they should get maybe that multimodal family intervention is you leave the child where he or she is, and you work with the mom, the dad, to try to get everybody to shape up. And if that doesn't work, then you might need to go to something more elaborate. But generally, if the child actually sees both parents and goes back and forth, generally you would not remove the child from the favored parent.
Okay.
There might be reasons to do otherwise. If the favored parent is incessantly alienating and to an extreme degree, and you can just know that this is not going to turn out good, then maybe you can justify it in those cases, removing the child from that parent.
Okay. Yes, ma'am.
History of conflict, but the relationship has been devastating on therapy. Everything's going well, and then all of a sudden a rejection occurs. With that, and despite no setbacks by the rejected parents, would that be considered estrangement, or would that be a different?
Well, what sometimes happens is family violence occurred years ago. Maybe the dad had a drinking problem and he did inappropriate things, or there's abuse, spouse abuse, and everybody got over it, as you said. They've been happily married now for 8 or 9 years. The children get along with everybody, but suddenly the mother starts bringing up this abuse that happened years ago. And it hasn't been a problem for 8 years. Well, if she brings it up and keeps reminding the children of something that happened years ago, or even before the children were born, sometimes those are alienating behaviors. And the mother needs to be told not to do that. And if necessary, have this counseling or intervention. But occasionally, of course, there are both. Occasionally, there is a history of domestic violence and a history of alienating behaviors. So those are called hybrid cases. And generally, those would be handled with this total family intervention, because you would want everybody to improve what they're doing. Generally, a typical hybrid case, unless it's extreme in one way or another, you would try to do this comprehensive approach, which I agree is expensive and it's not very practical because so many therapists are involved, but I'm just saying that that's what seems to be the way to go.
Yes. Yes.
The study sort of, the doctor said that y'all had a study that had favorable results in 4 days. Is that like 4 days of counseling? I mean, that's sort of how usually argued, is like that's a really short time for things to be good and after a long time of alienation.
So in severe cases, the court might order the child removed from the one home and place it with the other parent. Surprisingly, just doing that is therapeutic. Just removing the child from home A and sending the children to parent B, the children are relieved that they're out of this horrible situation. But these 4-day programs are intended to help the child adapt to the new living situation. So it's 4 days, morning, afternoon, and evening, and so it's pretty intensive. And they basically try to help the child give up these false beliefs about the rejected parent. And usually they're able to do that, usually by the end of 4 days. Sometimes they say at the end of the day that the child and the rejected parent are weeping or crying together. They're remembering things that they used to do. These 4 days are not spent blaming the favored parent. They don't spend 4 days rehashing all the things that have happened, all the bad things. And they try not to blame anybody, but they do try to help the child base their relationship on their actual experience rather than on what somebody has told them. Oh, and then the 4 days is followed up. In other words, the dad, say, and the children need to have some sort of follow-up counseling after the children return home. And the mother in this setting has to have her own follow-up counseling to help her shape up and change what she's been doing. And then they go back to court in 2 or 3 months and decide what to do from there.
Yes, and I'm really glad that you asked that question because later on, we're going to have more discussion about how the interventions work and how do you get there. And I know that one of the things in my experience, that's one of the hardest things often for judges to do, or even for therapists to recommend, because we always are a little bit concerned about what are the other potential things that could happen or occur. And having seen these families transition from going to, I don't want to see my mom, to then having some time with that parent and being taken out of that loyalty bind, it's like literally turning a light on and off, because the child then says, okay, I have to be here. And that's kind of their out. Like if the other parent is upset at me, well, that's okay because I have to do this now. Somebody with more authority has made me do this and I've got to do this. And then part of what they do at the intensives, and we'll talk a little bit more about it, but is they wake up those relationships with the children by doing a whole, list of things that they do. But that's how that works. And it does happen that quickly. And it's kind of like, we've been trying to do this for months and it's like literally a light switch goes on and off. So anyway.
As a litigator, I have to go in and have to tell the court, hey, I want you to take the kid from the favorite parent, give it to the alienated parent, right? And I could presume there'd be a judge that may say, well, that might cause more problems to the kid than help. Have you seen in your research that by removing the child there, it's had a negative effect on the child as opposed to a positive effect in regards to alienation?
So that is, of course, an issue. One answer is, what do you do if the child is being sexually abused by a parent that they love, or physically abused or beaten? Do you leave the child there because you think the child might be harmed by removing the child from the sexual abuse? No, of course you remove the child. So that seems like an underlying premise. Now, PA comes under attack, and there have been anecdotal reports of children who were removed from a parent and placed with the other parent and who didn't like it, and later returned to the alienating parent. So there have been anecdotal reports in social media and in one or two newspaper articles about cases like that. There have not been any peer-reviewed publications documenting that a child has been harmed by this removal. I mean, maybe there needs to be, obviously, further studies, but it appears that the vast majority of children adapt or even delight in the change of households.
Ashish, did you have a comment you wanted to make?
That's a good question, Brian. I often encounter that. I think, first of all, there's a great peer-reviewed article by Richard Worsham on top 10 embarrassings and parental alienation that compromise decisions for a parent. He talks about the very issue. What I like to do is to educate the judge about the difference between trauma and anxiety. The research tells us that separating a kid from an alienating parent is not traumatic. It certainly causes anxiety. It certainly causes the child to sadly jump out the window, I'm going to run away, and all of that. But you have to still do it, otherwise you're leaving the child and abuse it and deal with it. And once you try to get the court to understand the difference between trauma and anxiety, I think most judges start seeing it in a different light.
Okay.
I have one question, and mine is more centered around documentation. What is your opinion about documentation that's obtained through supervised visitation and comments that children may gain during their explanation, which is unsolicited or can be portrayed as being alienating comments?
So about supervised visitation? Yeah, no, sometimes that's very helpful. It helps the two get together. I have found it very helpful to read the descriptions and the record of the supervisor, because frequently they hear things and see things that are very, very helpful. Sometimes the parent is totally appropriate, and that's good, and the child tunes in. Sometimes the parent is not appropriate. Sometimes the child says things that don't make sense. So I think it's really helpful to have that information.
I want to follow on that. Just on a litigation standpoint, as an attorney, if you've got a case like this, oftentimes there's a delusion. You're drinking from a fire hydrant as far as you've got coming from the other side. OC's telling you your client is terrible, they're abusive, child cannot be around this person. Getting all these things. Got your client saying, I've done nothing wrong. And it's all where it's all dad within the parent. You've got professionals, guardian ad litem, you've got therapists saying the kid said this, or I saw that. But to your point, what's interesting is all these different touch points create data points. And it's extremely important, at least for what we do as litigators, to have those data points. And so I want supervisors that are doing supervised visitation, I want them to take notes. I want them to write down, little Johnny and little Susie said, Daddy's a terrible person. And by the way, no one prompted them. I want therapists to take notes. Man, that is upsetting as a therapist. I apologize to those in this room. But if you've ever had a case with me, you'll know that I will call you and tell you that I intend to call you as a witness. More importantly, I will depose you and I will seek your notes.
Mhm.
Did not take notes, but you cannot avoid a deposition. And it's not me questioning you as a therapist. And I don't think that's what this is.
No.
What this is I'm trying to collect the data. So you have the data, and I need the data. And I can't get it if you don't give it to me. And I can't do my job without it, but you're involved. And so as a supervised visitation, a therapist, guardian ad litem, an amicus, therapist, counselor, we need that data. Because as Dr. Brent said, as we go through this, we have factor 4, which is manifestations, 17, 18, 20 of these. We have 8 behaviors. And I can't just walk in and say, hey, parental alienation. Get that one go with mom or dad. I've got to say, hey, here's the 17, 18, 20 factors. And I got to be able to point to it. I got to be able to say, here's why. And I can't say, because my client said so. Because we're just back to he said, she said. Yep. It's a very complicated case. And the more data points that we get, the better. And I think as a litigator, just so you know, telling the professionals ahead of time, I'm going to need this. So there's not an expectation. They're not blindsided all of a sudden because no one ever asked for their notes. Right? I've never in 20 years had to give my notes. Congratulations.
All right. Oh, can we write them down and then we'll go to a quick break and then we'll pick those up, if that's okay. All right. So everybody can have a little bit of a break, but Dr. Allen has something and then Shara has something. Okay. Thank you. We'll go to a little break and then we'll pick back up with Ashish. All righty. I get the privilege and the honor to also introduce Ashish Yoshi, has an amazing book. For those of y'all who have not read his book, he does have a great book, and it's called Litigating Parental Alienation. It is a book that I've read, and anyway, I'm just the privilege to have both Bill and Ashish here is, anyway, a dream of mine. So thank you. Go ahead.
Thank you, Sandra.
Yes, sir.
Good morning, everyone. So I'm not a doctor or a psychiatrist or a psychologist, although sometimes I play one at the conferences. I'm an attorney. I'm licensed in New York, Michigan, and Washington, D.C. I'm based in Ann Arbor, Michigan, and my practice focuses on family violence, of which parental alienation is simply one part. I also do cases involving international child abduction cases, where children are taken across the nation borders, and it's often almost sometimes impossible to get them back, even through the Hague Convention. Today, I have decided to talk about various inflection points that arise in litigating cases involving parental alienation. So I'm going to share with you my experiences in litigating these cases across the United States and internationally. I have been privileged enough to have trials in different venues across the country, not just in the states I'm licensed in. And that has given me somewhat of a unique window in how judges and juries see parental alienation as a phenomenon and different types of intervention that they have. So let's talk about the term, first of all. Parental alienation, what's in a name? When you look at the cases from across the country, you see different terms being used by judges. Some use parental alienation, some use the DSM term, child affected by parental relationship distress. And sometimes you see terms like brainwashing, programming, pathogenic parenting, enmeshment, pathological enmeshment, and all of it. But the basic premise is the same once you dive deep into the facts of a case, is one parent has engaged in certain behaviors that has resulted the child into rejecting the other parent. So the first question that typically arises when an allegation of parental alienation is made is it admissible? Is evidence of parental alienation, expert testimony regarding parental alienation, admissible in court of law? And then we go into Daubert and Frye different standards. My recollection is that Texas is a Daubert state. So you look at the Daubert standard, and the answer is absolutely yes. It is admissible, and there are scores and hundreds of opinions from courts all around the country where the courts have taken testimony regarding alienation and acknowledged the phenomenon as well. But here's the thing. Daubert hearings sometimes end up taking a life of their own, and it's a trial within a trial. So, for example, parent A makes an allegation in the court that parent B is trying to engage in parental alienation. Parent B's attorney comes over and tells the judge, Your Honor, this is junk science. There is no such thing as parental alienation. It's a hoax. The whole thing was created by this guy called Richard Gardner. And he created this whole thing because abusive men simply wanted to get away with their abuse. And it's anti-women, it's sexist, it doesn't really exist. Let's have a whole trial about it. And before you know, there's a battle of experts. Legal fees start piling up. Lawyers go to war on alienation, whether it exists or not. And months go by, which is the precious time where a proper intervention could have been made. So it almost borders sometimes to litigation abuse. And here's the key thing. Daubert requires scientific validity and reliability and a fit analysis. Daubert doesn't mean that whatever expert evidence you are trying to propose to the court has to be without any disagreement whatsoever. Daubert doesn't mean that everyone on this planet, all scientists, all experts have to have a uniform opinion about that phenomenon. All you need to do is to show to the court that the concept of alienation has sufficient scientific reliability and validity. And that's where you can look at the actual cases. So let's take a look at this definition of parental alienation as it was put forward by a Texas court. Parental alienation occurs when one parent systematically attempts to exclude the other parent from a child's life, either physically or emotionally. Now, it's interesting to note here that in this case, the court is focused on the parental alienating behavior. The behaviors of parent A, which resulted in the child rejecting the other parent. And other definitions sometimes focus on the state of affairs as such, the phenomenon of alienation where the child has rejected a parent. Sometimes it's a combination of both. But there's plenty of scientific literature that you can use in the Daubert hearing, and sometimes to even avoid having a Daubert hearing, because all the judge is required to do is to do a gatekeeping analysis. So for example, if I want to put Dr. Burnett on the stand to talk about parental alienation, the trial judge could conduct a Daubert gatekeeping analysis in the trial itself for the custody. You do not need a second trial just for the Daubert hearing. And by putting Dr. Burnett on the stand, I could go through the scientific validity and reliability concepts in a matter of 30 minutes or 1 hour, rather than having months go by to schedule a whole separate Daubert hearing. And when you look at the peer-reviewed research, it is clear that there's plenty of peer-reviewed studies, research literature, and cases, more importantly, that clearly satisfy the Daubert requirement. One of the best articles, if you don't have it already or haven't read, you should get your hands on, is this article by my mentor and former law partner, Demosthenes Lorandos. It's a survey of parental alienation cases from across the country from 1985 to 2018. And it touches on several key issues as to whether the courts acknowledge and endorse the concept of parental alienation. What evidence have the courts looked at? What has persuaded certain courts to find alienation? What has caused skepticism sometimes and have the courts reject the allegation of alienation? It's a really great article, and it's peer-reviewed, published in the AFCC journal, Family Court Review, that you should absolutely get your hands on. It's important to note that some of the best peer-reviewed research articles that have come across on parental alienation have come since just about 4 years. Since 2020, we have about 213 plus peer-reviewed scientific articles that have come through, not just in the United States, but from internationally. And these are reputed scientific journals. We are not talking about OpenEd or opinions or trade journals. These are proper scientific journals having stringent standards of peer review. Which, by the way, is an interesting point. You know, sometimes when you are a litigator and you are trying to use peer-reviewed literature, it is important to take time and educate your judge about the difference between a peer-reviewed article and a non-peer-reviewed article. Often the opposing counsel might come and cross-examine Dr. Burnett about some internet article or Wikipedia or someone wrote in a legal journal, which is not peer-reviewed. And so, well, Dr. Burnett, you're talking about alienation, but here's an article that says it's a hoax. Well, first of all, let's find out who wrote that article and was it peer-reviewed. So apples and oranges, have to be careful about it. The important point about this peer-reviewed article is that the detractors of alienation theory keep on using the same old arguments. They use the same old articles that are published in 1980s, 1990s, which criticize the parental alienation syndrome, which is no longer used or taught by courts at all. They ignore the cutting edge research. They ignore the new peer-reviewed articles that come through and keep on going back to the old arguments. And it's important to remind the court about, let's look at the new science in the field and not just get distracted by the old stuff. One of the good books, Parental Alienation, Science and Law, has a detailed appendix at the end about cases involving parental alienation from every state in the country, including Texas. So for example, I put a slide here. These are the cases from Texas where the courts found parental alienation to exist. And some of the cases that I have also highlighted where the courts engaged in an analysis but refused to find parental alienation to exist. And it's equally important to look at cases where the courts refuse to find or make a finding of parental alienation, because you will see that mere allegation doesn't work. Just because the child has rejected a parent does not mean that you have a case of alienation. You have to demonstrate what did the other parent do, the favored parent, in order to make the child reject the other parent. We're going to talk about the 5-factor model, but when you go through the cases where PA was not found, you will see that the court did an analysis and came to a conclusion that there was some legitimate reason behind the child's refusal to see the other parent. Could be deficient parenting, could be abusive parenting, neglect, some other reason, but simply alleging alienation the moment there is a problem in visitation or rejection doesn't work. In fact, the term parental alienation is in the overkill zone. And part of the reason is because of the social media, where people start joining parental alienation groups and other groups, and every man wants to be Johnny Depp, and every woman wants to be someone else. So the worst possible thing as a litigator, as a lawyer representing a client you could do is to go to court and use the term parental alienation prematurely or without scientific and evidentiary support. Because all you are doing is to desensitize your trier of fact, your judge, who will keep on seeing the motion after motion and just roll his or her eyes and say, here we go again. So it's important to do your diligence. I'm not saying that you wait until parental alienation sets in and then go to the court. Early intervention absolutely is important. But don't argue parental alienation unless you have evidence of alienating behaviors. This is one of the greatest books written ever. So in this book, I have several appendices which talks about where the courts have found alienating behaviors. And I have all different jurisdictions, Alabama, Texas, Michigan, New York, and where the courts have documented the signs of alienation in the children. So for example, what Texas courts or court decisions have found certain behaviors to be alienating? And what symptoms in a child has persuaded a trier of fact to find parental alienation? And it's important to shape your case so that the evidence is in front of the trier of fact, not just use the term. By the way, going back to the previous slide, these cases are also important to rebut an argument that is often made in litigation, that parental alienation is misused by litigants, typically men, but sometimes also women. And the moment the argument of parental alienation is used, judges somehow roll over and give the custody to the other parent. And that's absolutely nonsense. There are articles published about how the courts have engaged in fact-finding, in weighing evidence, and then making a decision about alienation. If anything, just by anecdotal experience, which is not scientific, I know, but it's extremely difficult to prove parental alienation in a court of law and get custodial change because of that. So there are arguments made or by some professionals or experts that alienation causes judges to simply change custody at the drop of hat is not true. And these cases are proof of that. Let's look at the definition which Dr. Burnett went through. So this definition, if you contrast with the definition used by the Texas court, This focuses on the phenomenon and the state of affairs as to how alienation sets in. But there are different definitions which one can look at. But the key here is early intervention, no matter which term you look at and how it's defined. In one of the foreword to my book was written by the then Chief Justice of Michigan Supreme Court, Justice McCormick. And she makes a point about how difficult these cases are for family court judges. And what is important is early intervention. One other thing that you may want to get your hands on is the joint statement that was released in 2021 between AFCC and the National Council for Juvenile and Family Court Judges. There was a lot of debate and there was a lot of work being put into what family court judges should be concerned about when facing a child custody trial or allegations of abuse and whatnot. And these organizations came together and released a statement, which is very important because family court judges are attending conferences by AFCC. They go to the judicial conferences, they learn from these conferences, and the joint statement clearly mentions the words parental alienating behaviors. It doesn't use the term parental alienation, but it uses the term parental alienating behaviors, because in 9 cases out of 10, that's what's going to pursue in your trial of fact. In my experience, the last thing a judge wants is a battle of experts. The last thing a judge wants is to sit there and listen to a lecture about how the term came about, whether it's in DSM or not, what did Richard Gardner say 30 years ago, and what did so-and-so expert counter with. What they want to look at is, how can I help this family? How can I make sure that the child has a healthy relationship with both parents? How do I stop one parent from coming to the court every other week and complain about alienation? How do I make sure that court orders are followed? Visitation is complied with. And you have to shape your case in a manner of result-oriented advocacy. By all means, you'll have to deal with the alienation argument in the science, but you have to go back with some solutions, some suggested resolutions, and explain to the judge what will work in a particular case and what will not. So this is the term that typically comes in family court cases, and it's used more and more: resist, refuse dynamics. Some professionals prefer to use the term RRD rather than parental alienation because perhaps they believe that let's avoid the controversy, let's use a different term. But the problem is that it's not an alternative term. The term RRD only talks about what I consider to be the factor 1 of parental alienation, 5-factor model. RRD tells you that the child has engaged in some behaviors that can be classified as resist, refuse dynamics. The child's resisting a parent, or the child is refusing to go and see the parent. So we have some warning flags, and that's all right, but you can't stop the analysis at that point in time, because the RRD could be caused by alienation. It could be caused because of estrangement. It could be a hybrid case. It could be loyalty conflict. It could be several different things, but you have to dig deeper. If you stop your inquiry at the RRD stage, then you rush into therapy. And that could be the worst possible thing. We'll talk about it. So one of the red flags in these cases is visitation conflict. The child refuses to see the parent. And that's sometimes the first red flag. And if there's no early intervention at that stage, the case starts getting toxic. You have more and more visitation refusal. You have more violation of court orders. And by the time you go to court 9 months down the road, you have a new normal. The kid hasn't seen the parent for months.
And then the judge looks at you and says, well, I'm not going to enforce parenting time because I need to know what's going on. So after you go to evaluation, after you go to therapy, and different things are tried, and the precious time is lost. Dr. Burnett went through this, so I'm not gonna talk about the difference between alienation and estrangement. But basically, for estrangement to be the case, there has to be genuine, legitimate reason for the child's rejection of a parent. It can't be a parenting style that the kid doesn't like. For example, mom makes me put my phone away at the dinner table, so I never want to see mom again. Or dad makes me want to do my homework, clean my room. You might have a case, which is pretty common, that one parent has an authoritative parenting style, other parent has permissive. But if that was the case and the kids were allowed to pick a parent, I mean, family court we don't need the judges for that, you know? So it has to be some genuine reason. There could be findings of abusive parenting, physical abuse. There could be concerns about alcoholism, substance abuse. And if those things are present, then we obviously need to hit pause and go deeper, because you might not have a case of alienation. One important thing, the McLean case. Now, this is not a Texas case, but nonetheless, I think you guys should read that case. It's a case out of Tennessee. It's a Court of Appeals opinion, and it's amazingly well-written opinion. The opinion goes into detail as to the alienating behaviors, in that case by the father, and how those behaviors brainwash the child. The Court of Appeals goes into detail about how the trial court had done everything possible for the past several years. Therapy, change of lawyer for the child, guardian ad litem, modification of parenting time. But nothing worked because the father continued to brainwash and poison the child against the mother. And it goes into the detailed evidence, the text messages that the father sent to the kid, the duplicitous behavior by the father, where he told the court, I'm all for a healthy relationship. Of course, I want my son to see his mother. But then when the kid went to see the mom, he would send these messages. He would call the kid and tell him to do certain things. So that tells you the evidence that the court is looking for and what you should be ready to do. Let's skip certain things because I don't want to repeat what Dr. Burnett said. Okay, so a different topic. One of the things that comes across in litigating cases of alienation is somehow this simplistic attitude that some professionals have about either it's alienation or it's estrangement. And that's not the case in 9 cases out of 10. You usually have cases involving shades of gray. You have alienating behaviors present in a case, but then some behaviors by the rejected parent that often makes the case worse because it's painful to be rejected by your child. So you might have, for example, the father engaging in interference, brainwashing, denigrating the mom, bad mouthing. And when the child starts rejecting the mother lashes out by putting things on social media, calling the dad narcissist, telling the kid you are being brainwashed by your dad, and sending negative text messages. So that causes a toxic spiral. But people, especially lawyers, like simplistic solutions. So binary trap means that you are walking into a case of alienation with a mindset that it's either A or B. Either it's alienation or it's estrangement. And when you walk into a case with that mindset, you often end up falling in the binary trap. And you ignore certain other issues that might be really important in the case, but will only come across in proper cross-examination of your expert. So your expert, if he or she is going into the assessment with a binary mindset, be careful of that. I've seen sometimes cases which, in doing this analysis, ignored sometimes the elephant in the room. For example, looking at the 5-factor model, looking at the alienating behaviors or the signs of alienation in the child, I've seen the case evaluator completely ignore the fact that the child is autistic. The child has been diagnosed with the ASD, and the kid's behaviors, what were called dysregulation or tantrums, were because of a cognitive or behavioral, like medical reason behind it. The kid wasn't rejecting a parent because of alienating behaviors, which were present, but there were other reasons that need to be looked at and explained. So if you have someone conducting an assessment and simply focus on whether it's alienation or estrangement, you might have issues down the road. Another thing to note when you look at Texas cases, and in fact, from every jurisdiction, is parental alienating behaviors do not equal parental alienation. You might have evidence of bad behavior. You may have plenty of evidence of alienating behaviors as well, but it does not mean that you have a case of parental alienation, because what's missing in that equation is evidence of the child rejecting the parent because of those behaviors. So the cases that I earlier gave you about where the courts refused to make a finding of parental alienation include those cases where the courts say, yes, we agree that the father's or the mother's behaviors were not appropriate. We agree that these behaviors could also be seen as alienating behaviors. However, there is no evidence of alienation. The child continues to see the parent. The child shows fondness, affinity for the parent. The child has some concerns or some complaints, but it's not the case of an alienated child. Now, does that mean that we sit back and wait until the child gets alienated? No. But that's where, as a litigator, you have to realize as to what intervention you want to ask for. In those cases, perhaps it would not be wise to ask for removal of the child, intensive programs, 90-day or 100-day no contact orders, because that's overreaching. And you have to realize what intervention would be effective. Not all children become alienated. I've seen several cases, and the research talks about several cases where even in the same family subset, you might have a situation where the older child is alienated or very resistant to having contact with the targeted parent, but the younger child appears to be fine. So alienating behaviors do not affect each child in the same manner. And it's important to shape your intervention relief depending on the facts, depending on the case you have, and go to the trial of fact with a proper request. So that's the judge's dilemma. You know, what to do? Should I remove the kid? Should I send the dad or mom to jail for contempt? Should I order attorney fees? Should I appoint a lawyer for the child? I mean, what exactly am I required to do? Because these cases get toxic, they get extremely hostile, they get aggressive litigation, and there are experts on each side. And sometimes the judges, I mean, it's difficult to be a family court judge in that situation. I mean, this is a case from Texas where the judge was simply frustrated. And the court actually found that everyone in this family needs some therapy. There were allegations of alienation, allegations of abuse, allegation of deficient parenting, allegation of bad mouthing, all of it together. And the court was struggling to find a resolution as to how to help the family without labeling one parent as an alienator and another parent as a targeted parent, because the labels just did not fit nicely. Now, one tool the court can use is the 5-factor model. But keep in mind that is one way of doing it, not the only way. It certainly makes sense if you have evidence to put in those different buckets as I see it. You have evidence of the child showing some resistance, put that in bucket of factor 1. You have evidence of a prior positive relationship where you can show videos, you can show photographs, you can have witness testimony to educate the court about what the relationship was like before the child began rejecting the parent. You have evidence of alienating behaviors, evidence of signs of alienation in the child, and most importantly, you should not have a finding of the parent being abusive or severe alcoholism or things like that, which could mean that a child may have legitimate reason to reject that parent. But that's an interesting thing because you could have a case that is a hybrid case. And a hybrid case is a case where you do have evidence of some deficiencies on the part of the parent who's being rejected. You might have a case where the Child Protective Services have done some investigation and found the abuse allegations to be substantiated. The parent who is being rejected may have engaged in some bad behavior. But you also have evidence of the other parent clearly engaging in alienating behaviors, denigrating the other parent, driving the wedge further, causing more rift in the relationship than otherwise would have been. And in those cases, the courts have to make a decision about what sort of intervention would be appropriate. One case that comes to my mind is the case from Michigan, Martin versus Martin, published opinion, you can look it up, where the court conducted a trial and found the dad to have engaged in domestic violence and some other behaviors that were concerning, but mom to have engaged in alienating behaviors as well. And the court found the hybrid dynamic to exist at that point in time. Some interventions were put in, years go by, father goes for therapy, father goes for counseling, anger management, and all of it, tries to turn a new leaf here. The mom continues down the road of alienation, continues to behave in the same way, no change whatsoever. And the second trial, which happened 4 or 5 years thereafter, the court found, the same judge found, this is a different case now. We no longer have the hybrid case. The father has worked with the professionals. He has tried to make amends. He has tried to apologize for his behavior. The mom continues with her methods that the father is unsafe, dangerous, not fit to be a father, and all of that. And now we have a case more on the lines of alienation, and we need to do something and engage in some other measures. So, interesting case. Let's talk about Texas. Texas courts, from what I have seen, do engage in the 5-factor analysis. They simply don't use that label, at least not right away that I found. But when you look at these cases, this is what the courts found in deciding whether a case of alienation or not. So look at the court statements on factor 4, the alienating behavior evidence. The father was alienating, the mother had been coaching, evidence of denigration, bad mouthing, withdrawal of love, another alienating tactic. And on the other hand, the court looked at the signs of alienation in the child, which is essentially factor 5, and found that the kid was acting as a robot. The kid was acting as a spy, as a messenger for the mother. The child was polarized, black and white thinking, no ambivalence, independent thinker phenomenon, where the child says, oh, I remember what I need to tell you. And by the way, no one told me to tell you this. So the courts are looking at the factors that's part of the 5-factor analysis. Just because the courts don't use the label doesn't mean that that analysis is not done. Texas courts clearly acknowledge the harm that is caused by parental alienation and how it's abuse, psychological abuse and emotional abuse. But before you run off and start talking about the 5-factor model, and get an expert to talk about it, you need to do your diligence as a litigator. So there is some criticism about the five-factor model, which is also published in peer-reviewed journals. And you need to be aware of those articles, which are part of the references at the end of my PowerPoint to get them. But when you look at this criticism, I'm paraphrasing, of course, and it's simplistic, but the criticism is that the five-factor model has confirmatory bias. It's too simplistic. It ignores the other avenues or other reasons by which a child could be rejecting a parent and other issues. But again, it creates a straw man. The criticism is that the five-factor model simply assumes that the child has rejected a parent. I'm sorry, the five-factor model assumes alienation simply because the child has rejected a parent. No, it doesn't. The five-factor makes no such assumptions whatsoever. In fact, it invites the assessor or evaluator to do an analysis as to what behaviors are present, which could lead to parental alienation. But nevertheless, you should be aware of this criticism of the five-factor model and ensure that what you are trying to do in pursuing the code doesn't engage in simplistic analysis, that you indeed have evidence of that. Oh, this is my favorite topic, therapy. The first thing that comes to mind often when you go before a judge or when you have a guardian ad litem appointed, or as New York sometimes has attorneys for minor children, is let's go to therapy. And they appoint a therapist, sometimes from a list of the local therapists available to the court that the judges are familiar with, and off we go to therapy. The problem is this: what is the problem that we are trying to treat in therapy? Are we trying to treat alienation or alienating behaviors? Or are we trying to help a parent who is not engaging in appropriate parenting, who is abusive, and who needs help in bonding with the kid? Because therapy for alienating behaviors and therapy for a child who has gone through abusive parenting are totally different. So we need to have the problem assessed first before we run off into therapy. There's plenty of literature that talks about how traditional therapy, if provided in a case of alienation, can make it far worse. That these are actually cases that get more and more toxic if traditional therapy is provided to the child. Let's look at a typical vignette, which was present in a case of mine, but it's not that uncommon. Child leaves a phone message for the mother. "Mommy, I love you, but I won't be seeing you for a very long time." A therapist is appointed to figure out what's wrong here. Days and days go by. The child keeps on making complaints about the mother with no specification. Doesn't say what happened, what did the mother do to justify complete rejection. The sessions keep on piling up. And when you look at the session notes in depositions, which I love to do as well, and get the notes, it's basically just writing down what the child says in sessions. "Mommy's mean, I don't want to see mommy, I have nightmares," and the therapist simply keeps on writing down. And the therapist keeps on sending letters to the guardian ad litem and to the court about how the child should not be forced, the child is traumatized, and the mom should not be having any parenting whatsoever. And we have 187 days that go by with zero contact. And by this time, the story keeps on getting embellished, it keeps on getting rewritten. And what has this therapy achieved? So often we lawyers have this gut reaction about trying to resolve a situation by stipulating certain terms, by avoiding litigation, by trying to get out of the court and not do things that could be seen as hostile or aggressive. But it's important to have a finding of fact made by either a judge or by a custody evaluator or by someone who can wrestle with the allegations and find out what exactly is the reason behind the child's refusal. Because that finding is critical for the intervention you're trying to seek. When you're trying to seek an intervention, you need to first decide whether you need the court to intervene. If so, what kind of intervention, what steps need to be taken? And different kinds of intervention are available for different cases. There are myths about interventions as well. And this is again the article that I earlier talked about, the Warshak article about fallacies regarding alienation. The children can be treated by who continue to live with alienating parent. Therapy is appropriate. Thriving children need no intervention. And this is one of the things that often comes across. Where the judge, when you go to the court and say, well, judge, we want the kid and the rejected parent to go to this intervention program. We want some make-up parenting time. We want temporary no contact for reunification. And the judge and the guardian ad litem or the attorney for the child says, well, little John is getting straight A's in the school. He's the captain of the tennis team. All the teachers love the kid. The kid's thriving. Yes, the kid doesn't see the dad or the mom, as the case may be, but let's not rock the boat here because the kid appears to be thriving. And that's the fallacy that Dr. Warshak talks about, that the results and the long-term and short-term consequences of alienation are severe. Just because the child appears to be doing well on some superficial levels does not mean the kid needs no intervention. I've seen cases where the child is absolutely perfect in school, very respectful to the teachers, other adults, and the family members, but sends horribly toxic, insulting, and denigrating messages to the targeted parent, calling the parent names, calling them horrible things in emails, in voicemails. That's clearly a maladjusted child. That child needs help. It doesn't matter if he or she gets straight A's in school. To leave that child in that atmosphere with that mindset and with that perception of the targeted parent is allowing the abuse to continue. On the other hand, not every case of alienation or where alienating behaviors are present requires removal of the child and going off to an intensive program. You need to have a severe case of alienation to ask for a removal, to ask for no contact order, to ask for specialized programs which are meant for moderate to severe cases. Which brings us to reunification. Reunification is different from therapy. If you go down the path of therapy in a case involving alienation, it gets worse, and here's why it gets worse. Traditional therapists are trained to validate their clients' beliefs, perceptions, emotions. So let's take an example. Because of alienating behaviors and because of alienation, the kid says, I don't want to see my father. He's mean, he's abusive, I'm afraid of him. I'd rather kill myself than go and see him. Everyone goes off to therapy. The first session, the therapist meets with the kid talks about these things, therapist writes it down. The therapist validates those perceptions. The therapist ends up validating those emotions that the child has without assessing whether those emotions and perceptions and thoughts are based in reality or are a product of influence and alienation or coaching. And as sessions go by, the same story is repeated, alienation gets worse, those false beliefs and irrational thoughts are further entrenched. And when the targeted parent, the parent who's being rejected, is invited to join these sessions, they sit and listen to these complaints which have no basis in reality. They sit there and listen to the child talk about how you locked me in a closet when I was 2 years old, how you were not present for my birthday party, how you have been mean to me. And if they try to speak up, the therapist says, you are not allowed to argue with the child. You have to show empathy, you have to show love, you have to show forgiveness, and this thing continues and continues and continues. And then the therapist is supposed to advise the court as to when the child is ready to see the parent, and that day never comes by, which is an ethical violation of its own. If you are providing treatment, you shouldn't be providing recommendations on visitation or custody issues. But that's a different point. So be careful when you ask for reunification. The myth of spontaneous reconciliation. Often, one of the ideas that are put forward by guardian ad litem or attorneys for children, sometimes judges and referees, is let's give child some space. If the kid's refusing and is adamant about the refusal to go and see the parent, let's have some cooling off period. And this is people talk about how the kids will come around, just give them some rope, don't force a visitation, don't go to court. There is no published research. There is no peer-reviewed research that talks about how spontaneous reunification or reconciliation happens. It's purely speculation. It's purely anecdotal. In my experience, from the cases that I have seen and the research that I have read, in cases of alienation, cooling off period makes it worse. Because then the child is left with the alienator and the propaganda of alienation with no experience to be had with the other parent. And those cases take far more effort down the road to litigate and to come back with it. So what should I do? Well, first of all, when you have a case, you take a look at the evidence that is out there of negative consequences regarding alienation, the psychosocial problems, the psychological problems that are related to irrational rejection of a parent. You are prepared to do that. You should be aware of the ACEs studies, adverse childhood experiences, and how that plays into severe cases of alienation. But in terms of litigation planning, first, find out, is it parental alienation? Your client comes to you and says, this is classic case of alienation. You haven't seen a worse case, I guarantee you. I need to go to court and get custody. Well, okay, let's talk about evidence. Show me why you think that the other parent is alienating the child. What evidence do you have? Do you have text messages? Do you have voicemails? Do you have witnesses who have observed the alienating parent badmouth you in front of the child? And this evidence can be obtained, should be obtained, and should be used in litigation. One of the case that I did, and again, it's a published opinion, so it should be shareable, is the mom engaged in an extramarital affair, but then shared the reasons as to why she went outside of the marriage to find the man of her dreams and love that she did not get in a marriage with the children. She sends emails after emails to the father, copying the kids who are teenagers and telling the father everything that was wrong in the marriage and why she was forced to seek love outside. And she was proud about it. During the cross-examination, she talked about how I'm not going to lie to the child. The kids need to know the truth. And the judge found that to be a very disturbing violation of healthy boundaries between the parent and the child. And the mom refused to do reunification. She refused to do anything to help the child rebond with the other parent. And basically the attitude was, I'm going to walk away. I did nothing wrong. They can come and find me when they want to. So it's important to understand that you might be dealing with someone who has undiagnosed personality disorders. And that's why in cases of severe alienation, the rush to find a simplistic solution where everyone agrees to do something and you dismiss a case and you walk away never works, because you're going to be back in the court a few weeks down the road. So if you do have a case of alienation, gauge the severity. Is it mild? Is it moderate? Is it severe in terms of what are the behaviors? Is the child completely refusing to have any contact with the parent? Do you have some bad behaviors or alienating behaviors? Or do you have a toxic pattern of these behaviors that have lasted for several months? Excuse me, if not years. So you have to weigh the evidence before asking for intervention. Review what has been attempted before, like the McLean case. If you have been engaging in a particular form of therapy, if the parents have been going to a therapist for months or for years and nothing has worked, it's time to think about something else. You need to assess what has been attempted and what has not been done thus far. For example, if the court has never tried to enforce parenting time violations, why not? If the custody reversal or parenting time modification has never been attempted, you need to ask why. Because that leads into figuring out compliance. At the end of the day, nothing works like accountability. Some of the best judges that I have seen who address alienation early on with proper intervention is the one who looks at the parent and says, if you can't make your child go and see the other parent, as ordered by me, I'm going to make sure that the other parent gets makeup parenting time. If the parent is going to lose out on the weekend visitation, that parent gets 2 visitations in a row. If you can make your child to go to school, go and see the dentist, go to a medical appointment, you as a competent parent should be able to make the child go and see the other parent. And those cases take a different route compared to their attitude that, well, let's see why the kid says no. Let's not force the kid. Kids 12, kids 14, they have a voice in the matter. Having a voice is different from having a choice. And again, we are talking about cases where alienation is present. We are not talking about cases where there are substantiated allegations of abuse. Those are different cases, and that's where we need to pump the brakes and do an analysis to protect the child and make sure the child is safe. One of the great resources, Parental Alienation, How to Prevent, Manage, and Remedy It. The chapter by Dr. Warshak, where he talks about different levels of alienation, different remedies, what works, what doesn't work. And I'm going to skip through some of the mild, medium cases because that's nothing to talk about. Moderate cases, severe. Let's go to this one. Oh, this is the article that I mentioned. 10 parental alienation fallacies that compromise decisions in court and in therapy. And that's the one, Brian, I was talking about earlier, where Dr. Warshak talks about the difference between trauma and anxiety, and how research tells us that it's not traumatic to separate a child from the favorite parent or the alienating parent. It could be prone to anxiety. The child could have anxiety about a separation, but it's not traumatic. The articles and the peer review research that Dr. Burnett mentioned, I'm not going to go into it regarding interventions, but you should have this handy if you're asking for specialized intervention program in a no contact order, because that has some efficacy. I think structured intervention is something that we might discuss later in the afternoon during our panel presentation. But the idea is, in cases of severe alienation or moderate to severe, the court often puts together a structure. And here the court's basically acting as the super parent. There's a overall coordinator who makes sure that the therapist for mom, the therapist for the father, and the reunification therapist are all pulling in the same direction. Because you don't want silos. You don't want the reunification therapist working with the kid and the rejected parent, and the individual therapist working with the kid and the lack of communication. Because then you end up in silos and it creates more problems than solves it. This is one of the most critical things, review hearings. In alienation cases, there is nothing such as set and forget setting. There is no remedy, there is nothing that the court can order which is going to solve it forever. You have to show vigilance and you have to ensure that your judge is going to schedule review hearings to make sure the court orders are being complied with, that everyone is doing the work they were supposed to do. It could be a 10-minute hearing by Zoom or by phone. It could be in person. It could be a detailed evidentiary hearing if required. But you have to make sure those hearings are placed on the docket in advance so that there is accountability. The targeted parent knows what he or she has to do. The hopefully previously alienating parent or favored parent knows what he or she has to do. The therapist knows that the work is going to be explained to the court. There's no expectancy of confidentiality because this is court-ordered intervention. And those review hearings make a lot of difference. If there are no review hearings, things go okay for the first week or 2 weeks, and things start getting spiraling downwards. And by the time you get a hearing on the docket and file a motion, months go by. So it's essential to have those hearings set up in advance so the court and your judge has the opportunity to address any regression, address any slip, address anything that's not going as per the plan. In extreme cases of alienation, you may have to look for some creative situations. I've had cases where there were allegations of false sexual abuse against a parent, both mothers and fathers. Now, in those situations, you have to be careful before asking for a full change in custody and flipping the custody, because be careful what you ask for. You might inadvertently put your client in a situation which makes those allegations far worse, and there are more calls to the police, more calls to 911, more calls to the CPS, because the alienated child in that situation is basically a child who has been brainwashed into believing that the other parent is unsafe and dangerous. So before you go down that path and ask for full change in custody, you have to ensure the proper intervention is done. And in some situations, the targeted parent is just not in that situation, who cannot take that risk of another false complaint, who cannot take a risk because he or she may have a license to protect, a healthcare license, for example, where they can't afford a finding of child abuse. In that situation, you may have to ask for placement with a temporary third party, placement with the family members, placement with the friends of the family, or sometimes I've asked for placement in a boarding school where the kid gets out of the toxic, alienating environment. It's not with the targeted parent right away, but goes to a third place where there is proper intervention, an opportunity to do proper intervention, and it could be a boarding school. We have seen recently some cases where litigants have not gotten anywhere in family courts, but have gotten somewhere with some good relief in front of a jury. This is one of my cases where the mom was a targeted parent, and the dad was alleged to have orchestrated a conspiracy to frame the mother and the mother's boyfriend for sex abuse allegations. And the family court kept on just circling the thing about that it's important to look at the kid's reality, doesn't matter whether it's right or wrong. And the jury in a civil lawsuit saw it differently. The jury saw through alienation, the jury saw through orchestration of false allegations, the jury saw defamation, the jury saw intention, infliction of emotional distress and the pain that the mother had to go through. And they awarded $20+ million in damages after a full-fledged trial. So alienation is also litigated in courts in a civil setting with a claim of IIED or sometimes negligent infliction of emotional distress, if not intentional. And there are other ways to resolve that as well. Not right for every case, but sometimes that's no other way out. You can look at other litigation solutions. And sometimes it's important to do that because you are prevented from getting discovery in a family case, which you might be able to obtain in a corollary civil case. So that's the end of it. The only message I would like to underscore before we move to question and answer is accountability is the key. Unless there is accountability for bad behavior, for alienating behavior, and there are sanctions, attorney fees, make-up parenting time, anything to address those behaviors, situations rarely change. We can open the floor for question and answer.
Thank you, Ashish, I appreciate that. Senator, come up and do the Q&A.
Do you want Dr. Burnett and I both be here for this Q&A?
Just we're going to do it a little bit differently this time as well. And when you go to ask the questions, raise your hand. Senator, I'll bring the mics to the people that are on Zoom to hear what's going on. Apparently, we can do that. Any questions for Ashish? Thank you, sir.
I have 3 questions for you. Can you hear me?
Yes.
How often are you finding, or do you always find that judge juries buy in or accept parental alienation nowadays?
You mean the concept of alienation? Overwhelmingly, yes. What I used to see about 8-10 years ago was skepticism on the part of judges regarding parental alienation syndrome and whether the syndrome exists or not, whether it's in DSM-5 or not. But when you analyze the court decisions for the past 8 to 10 years, you see a dramatic shift from the judges moving away from their argument regarding syndrome and focusing on behaviors. So several cases have this footnote where the court says the parent who was accused of alienation argued that parental alienation syndrome is not real or doesn't have validity or whatnot. And that's a moot argument because the trial court focused on the behaviors of the parent. The trial court did not intervene based upon parental alienation syndrome, rather the evidence of bad behavior, which the court classified as alienating behaviors. And that's the difference.
Okay, can you make some recommendations? Because it seems to me that the alienating parent is the one that has all the money, and the alienated parent can't afford therapists, ad litems, etc. So they end up losing out in the long run. Can you make some recommendations how to possibly help the alienated parent to be able to fight this battle so their children aren't alienated from them forever and ever?
Sure, and that's the common lament that many judges have. I'll give you an example. A few years ago, I was teaching a workshop at Virginia Judicial Conference, and we had about 300 to 400 judges from juvenile and probate and family court. And the number one complaint was that the litigants in front of me cannot afford attorneys. They're pro se litigants. Forget about experts. What can I as a judge do to make the situation better or at least not make it worse? And things that have worked in my experience and what research supports as well is more time with the targeted parent. If it's a case of alienation, then it seems to be intuitive to not force the child to go and see the other parent. Because people think that's going to make it worse. The child is going to resent the other parent, resent the court, and actually that's what sometimes needs to happen. The child needs to have more time with the targeted parent so that the kid's away from the propaganda of alienation and gets to experience that parent in reality. But even more important than that, you have to hold the alienating parent accountable. If there are violations of court order, there needs to be some sort of sanction, some award of attorney fees, some penalty for bad behavior. If those things are not addressed, cases will not resolve.
Just real fast, Coach, too, that speaks to what you said earlier, is the judges need to understand respectfully, there's a difference between anxiety and trauma.
Absolutely.
That anxiety is okay to induce by making it go to the target, making the kid go to the target, right? That I'm following all that.
Yes, absolutely.
And my other question is a little bit more Texas oriented. You know, each legislative session, the definition of abuse and neglect in Texas gets tweaked, maybe in a good way, maybe in a bad way. And you might not be able to answer this, but are you finding that CPS can ever find a reason to believe on any type of parental alienation is actually occurring based on, you know, the abuse and neglect definition that requires immediate danger to the child? Does that question make sense?
I don't think I follow the question. Are you asking me whether the CPS can make a substantiated finding of abuse because of alienating behaviors?
Yes.
I've seen CPS do that. Social workers who work as CPS investigators are typically not trained in psychological abuse dynamics. They are mainly seeing hard-hitting cases of physical or sexual abuse, bruises, and other things. But more and more, we see social workers coming down who have been trained with the psychological maltreatment model. And if you look at the APSAC, American Professional Society Against Abuse of Children, and you look at what APSAC defined as child psychological maltreatment, they talk about alienation without using the term. They talk about the very same behaviors that the child is subjected to, and that's considered child psychological maltreatment. Now, in a rarest of the rare case, I've seen the CPS advocate removal. What the CPS does, even if it finds evidence of child psychological maltreatment, is come up with a safety plan and go for family counseling, go for some sort of group therapy, joint counseling, reunification. And that helps if the alienating behavior ceases and you have a proper counselor who is trained in the alienation dynamics working on the case. Otherwise, it spirals into therapy, as we have talked about, and makes it worse.
Thank you.
Thank you. Anybody else have a question?
You know, it's never good for me to stand between the audience and the lunch.
Sorry.
Okay, thank you. So on your slide about the binary trap, do you have any suggestions for litigators on how we can avoid falling into that?
Sure. The first one would be holding your client accountable. When a client comes to you and speaks of parental alienation, stop, pause, and educate the client about what alienation is and what it's not. So if the client says, well, my kid comes in, calls me these horrible names, or refuses to do what I tell him to do, and says, well, because mommy told me I don't need to do that, well, that in and of itself is not alienation. You gotta dig deeper than that. You may want some other remedy, you may want some other relief in place. So it's to Also ask the client to show you the evidence. But if you do have evidence of alienating behaviors, then you can ask for an assessment. In some jurisdictions, they have custodial assessment, forensic psychological evaluations, and people rush to ask for psychological evaluations as if that's a panacea for everything. That holds the key. It doesn't. Sometimes all this NMPI2 or testing or whatever is done doesn't really show or throw any light on alienating behaviors. So if you're going to ask the court for any kind of assessment or evaluation, you have to ensure that the order says what exactly needs to be done. So instead of saying psychological evaluation or custodial assessment, it can be specified to seek or to rule out alienation, estrangement, or other family dynamics. You could pinpoint the assessor or the evaluator or give him or her heads up as to what are the issues, so that that person knows that, okay, these are some of the red flags walking into the case. Sure.
That kind of goes off of something else you said about those alienating behaviors not necessarily equaling parental alienation. Could you give an example or examples of an instance where, yes, there's acknowledgement that these alienating behaviors are happening, but a court wouldn't find that to be actual parental alienation?
Absolutely. So in the slide where I cited those Texas cases, I tried to break it down, and there are 3 cases under the heading no PA found. If you look at those 3 cases, the court goes into detail as to how the court did find certain behaviors were alienating, certain behaviors were harmful, it was not appropriate parenting. However, it did not meet the burden to prove parental alienation. The proponent of alienation argument did not show to the court that children need to be removed from the other parent's custody because alienation is set in, or there will be substantial impairment to the children unless they are removed. That did not mean that the court ignored those behaviors. The court put other interventions in place, but the court refused to make a finding that parental alienation as a family dynamic exists in this case.
And we have a question from the chat, and they want to know, how imperative is it for the court to intervene or step in early in the process if you suspect or you have enough evidence for parental alienation?
Very important. I think that's a key, early intervention, because if you have a mild case where because of separation, parents are acting out, they're behaving badly, there's some sort of denigration going on, psychosocial education can go a long way to cool the temperature, to help the parent understand maintaining boundaries, to help them understand how visitation orders need to be complied with, to help them understand that it's not okay to put the kid in the middle and tell little Susie, of course I want you to go and see your mom or dad if you want to. You know, and that education and that kind of intervention helps some parents. In some cases it doesn't, but at least you have tried that. So when you go back to the court, you can tell the judge, well, we checked this box, judge, it did not work. We've been doing this for the past 3 months. We need to take it to the next level.
Okay, and then we have another question. If, as a clinician, you suspect that it's parental alienation, or some of the evidence, the behaviors and the manifestations are there, are you, as a clinician, then ethically responsible to file a CPS report?
Well, that depends on the jurisdiction. In most jurisdictions, if you have a reasonable suspicion of child abuse, and child abuse could be physical, sexual, emotional, psychological, then you as a mandated reporter are required to file a report. So I would say yes, if there's evidence that one parent is engaging in psychological abuse, then you would have to report that.
Okay, any other questions? Yes. That's okay.
Sorry, you talk a lot about the evidence. What evidence? Oh, sorry, a little bit louder. what evidence have you seen as the most compelling in court?
What evidence in terms of alienating behaviors? Generally, I've seen the courts take urgent notice of text messages exchanged between the alienating parent and the child. Because judges often see lawyers and the litigants come before the judge and say, Your Honor, I'm doing everything I can to encourage a relationship. Johnny refuses to get in the car. What do you want me to do? To hit him, to force him? I'm not the one keeping him from his dad. It's the father's behavior that's causing him to reject the father, blah, blah, blah. And then when you have those text messages, are you safe? Call 911 if you need to. Take pictures of daddy's cabinet where he hides his marijuana. Is he drinking? Is the girlfriend around? Call me from the bathroom if you need to. The constant message being sent to the kid that the other parent is dangerous, unsafe. And that also may cross over into sometimes criminal cases as well. If it turns out that it's custodial interference, because a lot of states have the statute of criminal interference as well. So that evidence shows to a judge that not only we have a mentally unfit parent violating the boundaries with the child, but using the child as a weapon. So when the child is with the other parent, he or she is constantly under the pressure to collect evidence for their favorite parent, taking a screenshot of the laptop, going to the bank statements, videotaping and things around. So those things I'm seeing judges take notice right away, and in fact, enter some sort of interim relief even before the trial.
Well, and this is just kind of touching on that. One of the things I did one time as an ad litem, I had a case and wasn't sure what was there, but what I did was not just look at the messages. I asked to see the photo on the phone, because on like an iPhone, you can click it, and if they took it live, you get those few seconds ahead of time of what is really being said and what was captured in those, and the resistance of not wanting me to see those, you know, or have that information, because it's, you know, you could then hear say this, you know, because it's just that quick. But if they take those live photos, you can capture some of that. So I think that's an important thing, whether whichever client you have, that if just because they provide it to you doesn't mean that that's exactly what it is.
Right.
So.
And things are gonna get far worse with the artificial intelligence.
Yes. Anybody have another question? No. Okay. I think we'll take a break and go to lunch. Is that what we're doing next? Yes. Okay. Thank you.
Thank you.
All righty. I hope everybody enjoyed their lunch. I know I did. So anyway, we are going to hear from Dr. Burnett again, and about, he's calling it the echo chamber, places where individuals who are looking at the cases potentially maybe aren't looking at it correctly, or maybe entertaining other ways to look at it. So is that better? Okay. So anyway, I'm looking forward to hearing this portion of it, because I think as a clinician, you know, I always want to look to get better. I always want to improve what I'm doing. And as many of y'all know, I get to write questions for a lot of clinicians. So I really like this part also. Just enjoying the information and what we can do better every day. All right. Thank you, Dr. Burnett.
Thank you. Okay, so this afternoon, the name of this is Misinformation Echo Chamber, False Statements about Parental Alienation Theory. So I'm going to explain in a few minutes, make sure everybody kind of understands how this fits into the big picture. So if you think about the entire scope of parental alienation theory, there are a number of different topics that might be addressed. These topics have been developed over for the last 20 years by different people have different interests. But let me just run down the list. The history of PA theory, how to identify PA, and I mentioned that already, the 5-factor model. The prevention of PA, we haven't talked about that very much, but that's very important. Interventions, both Ashish and I mentioned those. Causation, prevention, and consequences, that really refers to research. There's research on all sorts of aspects of parental alienation, including those ideas. Legal issues regarding PA, so obviously you all have an interest in that. Education of mental health and legal professionals, and advocacy with legislators that you're going to hear more about this afternoon from Robert Gaza. So in the last few years, there's a new thing to add to this list, which is what I'm now talking about today, which is counteracting misinformation regarding parental alienation. So I have to admit that I'm really interested in this topic, and for maybe the last 10 years, I've been obsessed with the things that are published and stated in conferences that are false regarding what we believe in. In other words, people will talk about parental alienation or PA theory and make false statements that I've been collecting and I've tried to study, and that I'm going to tell you about it now. So, you know, there's lots of misinformation floating around these days. And there are other examples of misinformation in psychology and medicine. A few years ago, there was this whole thing about that vaccinations cause autism, which they don't, but that went on for years. There's another thing in psychology about autism called facilitated communication, which is a bogus form of dialogue with autistic children, which is still being published about, but the whole thing is nonsense. And I don't want to explain it right now, but you can look it up, facilitated communication. So there are, my shtick here about misinformation and parental alienation, this is the only example of this. There are many, many examples. So the way I'm going to present this, I'm going to give you some examples of misstatements, and I'm going to give you ones that have happened over and over again, since they're more interesting to think about how does a given misstatement gets adopted and said by somebody else, and some recent research that I've gotten involved in, and what to do about it, strategies for addressing misinformation. So there are many examples. I'm just going to give you a few highlights of misstatements about PA theory. So here's one, an article that occurred in a journal that I like and I subscribe to, the Journal of the American Academy of Psychiatry and the Law. So there are different ways to respond to this misinformation. One is the original article will be published in a journal, and then later we'll publish a rebuttal. And that's what Amy Baker and I did in this case. And for example, the original article was called The PA Debate Belongs in the Courtroom, not by DSM-5. So this was written by somebody I know, Timothy Hochin and his colleagues, and it has false information in it. This was back when we were trying to get PA in the DSM-5. And so, you know, we created a rebuttal, which was this. Amy and I wrote a response. So that's one way to deal with misinformation. Of course, you have to have the cooperation of the editor of the journal to do that. Here's another way. In this case, this is a book published, of all people, by the American Psychological Association. And chapter 1 of that book has a number of false statements, misstatements, misinformation about parental alienation. And in that case, we complained directly to the APA. We eventually got to the general counsel of the APA and the executive director, and they agreed to make a correction. Now, they didn't correct everything in chapter 1, but they did correct the most egregious error in chapter 1. And they changed the you know, the book is sold in hard copy and it's also sold in digital format. And they did in fact change the digital format. So I don't know, I feel I'm losing this every so often, but I think we're okay. So that's another way to correct misinformation is you get the original book or article to be corrected. Here's another simple example. This was an article in a journal, Journal of Youth Services Review, which is a good journal, has lots of articles about children and adolescents and treatment programs. And they had a very big article that had one sentence that was wrong. And they were very cooperative. The author and the editors were very cooperative, and they changed that sentence. And so now, if you look up that article, you get the correct version online. Okay, here's one more example. A lot of you may read the Family Court Review, which is the journal of the AFCC. So they've published articles that have errors that I'm about to describe. And they agreed, I never got around to writing a clarification, but they agreed that they would publish a new article by me if I wanted to write in and explain where these different errors happen. So those are different things. Well, here's an article that I couldn't get anywhere with, and it's a very serious misinformation regarding PA theory. And you all might read this journal, the Journal of the American Academy of Matrimonial Lawyers, which is a very nice organization. And it's a very nice journal. But a few years ago, they published an extremely problematic article by an attorney in Boston named Kimberly Joyce. And it's called Under the Microscope. So in that case, I tried really hard to get them to either correct it or to remove the article, withdraw the article from publication. And I wrote to the author, to Ms. Joyce, to the editors, to the president of the organization, and none of them wanted to talk about this. I mean, they wrote back and said, oh, they think the article is fine. You know, we're not going to do anything. So in that case, we tried really hard, but we were not able to accomplish any kind of correction. Here's one more example. I don't know if you guys are aware, but one of the components of the United Nations is the Human Rights Council of the United Nations. And they have an article that they have on their website, which is a horrible document, which is called Custody Violence Against Women and Children, or something like that. It's written by a consultant. The UN has different consultants and they write articles. And this is a horrible article that has all sorts of false information. And we've tried to get it corrected or removed. I think we were about half successful. My colleagues and I wrote a comprehensive critique of this article. And we then sent it to all the members of the Human Rights Council and a number of other people. And I think we were 1/2 successful in that the original problematic article was never officially adopted by the Human Rights Council, but it also was not rejected. So it's still sitting up there on their website. But that's an example of what we've tried to do to correct information. So this problem goes back for years, this misinformation problem. And way back to Richard Gardner, a year or so before he died, he wrote this article about misinformation versus facts about the contributions of Richard A. Gardner. Because even in his lifetime, there was all sorts of false statements made about him and about parental alienation. So Gardner itemized these misstatements and tried to refute them. Some of them are very basic, like he was accused over and over again of being a pedophile or having pedophilic interests. And he comes right out in this article and he says, I am not a pedophile, ladies and gentlemen. He did talk about pedophilia in some of his writings, but he never endorsed it. And in fact, in this article, he says pedophiles should be in prison. So that's part of what he was trying to fight back 20 years ago when he was still alive. So anyway, those are several examples of misinformation and what to do about it, different things to do about it. But I want to tell you about my own. See, I've gotten really obsessed with this topic, and I started to study it intensively, and I'm going to tell you about what I have found out in my own research. So some of this has already been published. In fact, this is my article right here. See all those circles and so on. I was on the cover of this journal. Now the cover is very confusing. You can look at that and you cannot really figure out exactly what it's about. Well, that's on purpose. In other words, I selected the image to go on the cover, and I purposely edited it down so that I could just publish, a little piece of it. And because I wanted it to be a little bit confusing so that people would open the journal and read my article. So this right here is the article that we published. It's called Scholarly Rumors, Citation Analysis of Vast Misinformation Regarding Parental Alienation Theory. So what I did, I found a particular piece of misinformation that was said over and over and over again. This is really interesting. It's not just an isolated little paragraph, but it's repeated dozens of times, the same misinformation. So how does that happen? How would that even happen? Well, first of all, let me make sure you understand what I'm talking about. The false information is that critics of parental alienation say that PA theory assumes that the favored parent caused parental alienation in the child simply because the child refuses to have a relationship with the rejected parent without identifying or proving alienating behaviors. I think this was mentioned this morning a little bit, that we would say that if a child is rejecting a parent, there are a number of possible explanations for that, only one of which is parental alienation. We're accused of saying every time a child rejects a parent, the reason is parental alienation. And we don't say that. Nobody says that. That would be a stupid thing to say. So we are accused of saying that, but we don't say that. So this is really a serious misrepresentation of parental alienation theory, because that's not the only reason why a child might reject a parent. There are many reasons. So do you follow me? As to my fundamental complaint here is that our theory is being misrepresented by claiming that we're saying something really stupid when we're not. Well, we wrote, and then more recently, so I did that one article that was in the cover of the magazine, and now I've continued it, and today I'm going to tell you about the next step in this research. And the name of this is Misinformation Echo Chamber. So that's the title of my talk, and it's the title of this new paper that I hope to get published in the next month or so. It's under peer review. So, you write an article and you send it in for peer review, and that's gone on for months. But I'm hopeful that that's a good sign that they're taking it seriously and that it will be published. But I'm about to tell you about the details of the new article, and I got to tell you, it's hard hitting. We name names, we cite references, we cite specific journals that propagate this misinformation. And I'm hopeful, what I would like to see is for that journal to be put out of business. And let me, I'm going to tell you, that's a big statement to make, but let me tell you why we think that. So I'm going to explain how this research works. Do you see all these dots? Every dot up here that has different sizes is a journal article or a presentation. The big dots mean that particular article was quoted more frequently, and the little dots mean that it might have only been quoted a few times. So how many did I figure? Do you know how many dots there are? There are 110 dots. of articles that have the same misinformation. You know, the thing I read to you a couple minutes ago, the idea that PA theory claims that every example of child rejection, parental rejection, is a result of parental alienation, which is a serious misstatement of what we believe in. Every single one of those 110 articles say that. And I have them, they're all in a database. You can look them up. The citation is there, the little quotation is there, and so on. But what's interesting, see, that's one project in itself to find out all these articles, which took me months to dig all this stuff up. What's interesting is how are they connected to each other? How does the information or the misinformation flow from one article to the next to the next? Do you follow me? How are they connected? Or is there a connection? Yes, the answer is yes, they're connected. So see all these lines? These lines represent, well, here, let me make sure you have the right thing. I think you do. This is without the lines. This is with the lines. I don't know if you, oh yeah, you can see, there are very, very faint blue lines here. There are hundreds of blue lines. I'm sorry that they're not clearer, but there are hundreds of blue lines going from the left side, which is chronologically the earliest, to the right-hand side. But here I have a close-up, which might be clearer. Here, I think you can see a little bit. This is at the earliest stage. The very first article to have this misinformation only has outgoing quotations because it didn't quote anybody, but several people quoted it. And as you can see, in the beginning, there are only a few of these articles with the bad information. So, hold on a second. Let's try that. Is that okay? Wait, now, turned on. Is that pretty good right now? Okay, thank you. So that's in the early stage. Maybe you can see very faint blue lines. I'll have to fix this for future use. So over here on the more recent, this is flooded with articles because, you know, as time goes on, more and more articles quote the earlier articles. And so there are many more at this stage of the discussion, going up to the year 2022. Now, what this diagram so far does not show you is that these articles, this misinformation, is not randomly distributed among legal and mental health journals. It occurs with very great frequency in specific journals, and in fact, one specific journal. There's one specific journal that is responsible for more than half of these examples. Do you follow me? It's not random. It's all comes from the same place. That's why this is called an echo chamber, because the same people quote each other erroneously over and over again. So I want to prove this to you. These are the articles that all are related to a specific journal, and maybe you can't see the lines, but there are little lines going in between. They'll show up better when we get it published in a journal, I hope. So altogether, there were 110. Here, connected to this journal, there's 60. 60 articles in the last few years all have the same misinformation, and they all have some connection to this journal. I haven't given you the name of the journal yet, have I? They're not all in the journal. Some of them are, 17 of them were actually in that journal. 57 of them were written by editors of the journal, the editorial board. And in many times, in about 15 of those cases, it was editorial board members working together. In other words, that's another indication of an echo chamber where the same people work together and then they propagate the same misinformation. So I think I'm onto something here. And as you can see from that big spread, There's only a few in the beginning, and it gradually increased. And in fact, I can show you exactly how that works. This is over the years. That very first article was in 1994, and the most recent ones in this study are in 2022. And as you can see, they've increased over time. That's because the misinformation spreads. And the red items are from the journal that I'm complaining about, and then the blue are from other places. So people study misinformation. That's an interesting, at Harvard, I think it's a Harvard School of Public Policy or something like that, has a whole journal of misinformation. And they publish research on how does it work. And one of the many things that they found is that on social media, misinformation or false statements spread faster and wider than true statements. Well, I don't know why that is. Maybe it's because false statements may be a little bit more interesting or provocative or whatever. But people have actually studied this by studying situations that involve hundreds of thousands of postings on social media, and it shows how this happens. So why is this journal so preoccupied with this? Well, the editors is because the editors are setting the tone. Here's a statement from the editors of this journal, and I give you a hint, it actually says who they are, Shaw and Geffner. And they don't like PA theory. Now, I can try to get into that if you want as to why don't they like PA theory. I'll see how much time I have. But this is one of the many things they say that are derogatory, that Gardner made up the label without any research and so on, and no known mechanisms exist explaining how such indoctrination of children who supposedly have a good, strong relationship with a parent leads the child to resist or refuse contact. So they're saying there's no known mechanism how a child could be indoctrinated to be afraid of somebody. Does that seem weird to you? I mean, to me, that seems totally ridiculous. There's tons of research. There are whole books written. And in fact, one of them is called Influence. And it's about the many different ways that more dominant people can influence less dominant people, how adults can influence children, how parents can influence their own children. And in the entire field of education is based on that, on the idea that the grown-ups, the teachers, inculcate certain information into the children. And it's especially true in religious education, that children can be influenced to believe things based on what they're told, not based on their everyday life. They don't have an experience of geography on different continents. I mean, that's why they're taught that, and so on. So to me, it seems incredulous that they would say that there's no known mechanism to explain how a parent can indoctrinate a child to have a false belief. I mean, that just seems ridiculous to have that as a criticism of parental alienation theory. So I'll tell you the name of the journal. In fact, I'll show you a picture of it. It's called the Journal of Child Custody. The editor is Robert Geffner. Now, that journal ended 2 or 3 years ago, and it now has a new name. And Dr. Geffner has opposed PA for years. I mean, he's written articles and editorials. This journal has had 3 different special issues. He's organized 3 different special issues of discussion of parental alienation. That's why in that graph of over time, that's why there are certain bulges. There are certain areas that there's a large number. That's because a special issue occurred of this journal. So that was the name of the journal a few years ago. And now it has a new name, Journal of Family Trauma, and so on, which is okay. So this is published by Taylor and Francis, which is a subdivision of a big company called Rutledge, or maybe it's the other way around, I'm not sure. But they're a big company, publishing company in the United Kingdom. And this is their disclaimer that appears in every issue of their hundreds of journals. The part that's interesting, it says, any opinions expressed in this publication are the opinions and views of the authors. Well, that's okay. But then it says, the accuracy of the content should not be relied upon. Well, I agree with that. And should be independently verified with primary sources of information. Well, of course that's true. So that's the current research project which is underway, which I hope gets accepted for publication. And when it does, I'm going to send an article to the editors of this journal and to the publishers at this big company called Taylor and Francis. And I'm going to encourage them to do something about all the false information in their journal. So we'll see what happens with that. So you guys are the first to know about this. This article has not been published. I hope it will be accepted and get published. So what can we do about misinformation? So I'm going to just mention a number of ideas, some of which I've mentioned. Make a complaint to the publisher. Well, I'm going to do that. And I did that with that book by the American Psychological Association. Publish a rebuttal. Well, I did that. I gave you an example of that forensic psychiatry journal. Write a book. Well, I've done that, and Ashish has done that, about misinformation. Write a letter to the editor. Make a video. Videos are more powerful these days. And in fact, one of my colleagues has in fact made a video of this topic, which is kind of clever, which is on YouTube. Team up, have a campaign. And mainly, if you're a reader, don't believe everything you see. And in fact, that's my message when I talk to attorneys and to legislators, that they're going to hear lots of information, and you can't simply take for granted that what you're reading is truthful. So the way to find out usually is to go back to the original sources. For instance, in my complaint, if you go back to the original sources, material written by parental alienation writers, we don't say that. We don't say that every example of contact refusal is due to parental alienation. And nowhere, in hundreds of articles, we don't say that. So when people claim we say that, you can go back to the original source and see whether or not that's true. So I mentioned some books. So a little advertising, that this book that Demosthenes Lorandos and I did a few years ago, it's organized around misinformation, and that each chapter we present a topic, and at the end of the chapter, we have some discussion of misinformation related to that topic, for example. And not only that, but Ashish Joshi wrote a book a couple years ago, and he has a whole chapter, a whole separate chapter on misinformation. So that's one thing you can do. Now, I want to try to move past this troubling phenomenon. And I want to wonder, can we do anything by engaging in discussion with the people that we don't agree with? So that's a whole other way to address misinformation, is you try to work out the differences with the people who are saying things that are incorrect. So we have started to do that, and not just me, but AFCC, the Association of Family and Conciliation Courts, has a project underway, which is called Peace Talks. And we have meetings together. There are about 6 or 7 of us. Some of us are kind of believers in PA. Some of us are more believers in domestic violence, since that's where a lot of the friction is. The people who are extremely concerned about domestic violence versus the people. I mean, both of those problems are problems, but sometimes there's friction. And so the idea was to convene a meeting of these people, try to explain how do we agree and how do we disagree. If we disagree, what research would it take? How would you do research to clarify the disagreement? So just a simple example is there's some disagreement about what to do about parental alienation, especially severe cases. Almost everybody agrees it happens, but should you remove the child from that household for a while and in an attempt to correct the problem? So that's, there's disagreement about that, but that's open to research. I mean, theoretically, you could have children and some of them are treated in one way, some in another way, or there are different ways to do that kind of study. And so that's an example of identifying research that might sort out the differences. And then my idea is we need to publish all this. So this is a simple example of how we agree on some things. I think we agree that domestic violence is a serious problem that affects many families, but sometimes there are false allegations of domestic violence. Parental alienation is a serious problem that affects many families, but sometimes there are false allegations of parental alienation. I think both sides of this argument or this debate agree with those general principles. But so let's not put our energy into arguing about it. Why don't we put our energy into how do you tell the difference? How do you tell the difference between a true allegation of parental alienation and a false allegation? So that seems like to me would be a good thing to try to figure out. So I mentioned the AFCC peace talks. So if you go to the meeting, or if you went to the meeting in Boston a couple of months ago, that's what we talked about. The AFCC peace talks actually had their two major presentations at that meeting having to do with the peace talks. And one of them, this is one of them was a big plenary session, and the entire 900 people who attended the conference attended that. And the name of it was Depolarizing by Example, AFCC Peace Talks on Parent-Child Contact Problems. And as you can see, the people who are listed there, I'm listed there, I'm the PA person. Peter Jaffe is the domestic violence person. And then there's another psychologist, there's a judge, a retired judge, there's an attorney, and so on. And that was very productive. We did this big presentation, and we're continuing. We're going to continue on for another year to see if we can actually arrive at results that are more substantive. So that happened in Boston a few months ago. There was another one that Ashish and I were involved with that also happened in Boston. This was called Moving Toward Consensus on Parent-Child Contact Problems, a Discussion. And then this was the abstract that was in the program. And then this is our handout, but you can, listed on the handout are the people who were involved. And Ashish and I were on one side, the PA side, and Robert Simon and Benjamin Garber were kind of on the PA critics side. And if you know them, they're nice guys, Benjamin and Robert, but they don't agree with everything we say about parental alienation. And so we attempted to, we met with them a number of times. We met with them in Nashville. That's why we even have a logo that says the Nashville Group. And Ginger Griffin Donnell was the moderator of that. So anyway, that was kind of cool. I guess what I'm trying to say is that I think this misinformation is a really serious problem. Some of it we're never going to be able to correct. We just have to kind of overpower the literature with the true information and drown out the false information. But we're also addressing this by trying to communicate and have dialogue with people that we don't always agree with. So I think that's if that helps, I hope that works. This is a little tiny follow-up. I don't know if you know Robert Simon's a psychologist in California. And he was on the opposite side at this thing at the AFCC meetings. Well, he's coming to our convention. Robert is coming to the PASG convention in Norway in a couple of months, and he's going to make a presentation there. So I think that's neat. I think we're trying to reach out to listen to people that we don't always agree with, and hope the hope and the end result is to have less polarization in this field. So, as I said before, well, I have a couple of minutes. Let me make sure you understand why there is this polarization. there are domestic violence people who are really, really concerned about parents, mothers especially, who are victims of domestic violence. And they don't like parental alienation because they feel that some fathers fabricate allegations of parental alienation as a way to protect themselves from accusations of domestic violence. You follow me that one parent in court will raise domestic violence and the other parent will say, oh no, that's not why the children don't want to come see me. They don't want to come see me not because I'm abusive, but because the mother is alienating. So these two theories can be seen as opposing each other. But as I said a minute ago, everybody agrees domestic violence is a problem, and almost everybody agrees that parental alienation is a problem. So let's not argue that point. Let's try to figure out how to tell the difference. But anyway, that's a simple explanation of why there is so much misinformation in this field. So, as I said before, if you're interested in this, you're welcome to join Parental Alienation Study Group. That's our website. It's easy to join. You go on and then there's a thing that says membership and you click on that and then you see what it says. So thank you for your attention, and I think we have time for a few questions.
Thank you. Oh, I see. Okay. Dr. Burnett, could you go back to the diagram where you had the misinformation, the dots, the nodes?
This one?
No, keep going.
These are the dots
Right, so-
specifically from that journal.
It would be helpful for you to explain what does the size of the node mean? Why are some bigger than the other ones?
Right. The bigger they are, the more often they were quoted in a subsequent article. So some of them in the very beginning are very big because many, many articles quoted them that quoted and also had the same misinformation. So on the right-hand side, the more recent little dots, because they have not had time, they were only published a year or so ago. So they haven't had time to be quoted by other people. So the big dots tend to be on the left-hand side and the little dots on the right-hand side.
I have a question. It's for both you, Dr. Burnett, as well as you, Ashish, if you don't mind. I appreciate the misinformation, and I believe both of you touched on this earlier, particularly in the litigation lens. You have two competing experts in court, and one comes in and says PA is ridiculous or doesn't exist. The other says there's parental alienation and there's these things. From both of you, any suggestions on how to address this with the court in trying to advance a PA case in the litigation lens?
Yeah. If I'm supporting the concept of PA theory somehow, and the other attorney or the other expert finds fault with it, I look for very specific things. What is the specific criticism? And sometimes the criticism is Richard Garner was a pedophile. I mean, that people actually testify to that in court. And so my response to the attorney to say, ask him, where does that information come from? I mean, that's an extremely provocative thing to say. What is in the world is your evidence that Richard Garner promoted or advocated for pedophilia? In other words, I try to get them to focus on very specific statements that I consider false.
So I enjoy cross-examining experts. I mean, I really get a kick out of it. And I have never had an expert in my career who got on the stand and say parental alienation doesn't exist, period. What they do is to try to argue, well, we need more research, or it's not widely accepted. there's some disagreement. What I try to do thereafter is to find consensus. For example, Dr. John Doe, do you agree that parental alienation as a phenomenon exists? It is possible for someone, for a parent, to influence a child to reject the other parent? Yes or no? Well, yes. Okay. In your career as a forensic psychologist, have you found alienation as a family dynamic? Yes or no? Yes. What behaviors did you find by parent A that gave you concern about parental alienation? And Brian, you won't believe, but they give us the same behaviors, the 17 alienating behavior, just use different labels. And then the judge asks some question as well, that if you believe these behaviors are harmful, your problem is with the term parental alienation. And they concede. I mean, one of the most recent propaganda that's coming out is this new label called CAMS, Child and Mother Sabotage. And domestic violence groups are advocating to use for using this label instead of parental alienation. When you look at it, they complain about the same behaviors. So is the assumption that these behaviors don't work if the father happens to be the targeted parent? They only work in some gender specific cases? That's nonsense.
Yeah. Let me mention one other strategy. As you know, my colleague Demosthenes Lorandos, an attorney and psychologist, he had a certain amount of drama when he examined people in court. And in one case, the opposing expert took an extreme view that PA is a hoax, that PA doesn't exist, and it should not even be admitted in court. So Demos wanted to prove that this witness was totally uninformed, totally ignorant regarding this topic. So Demos brought a stack of books and reprints about this high, and he methodically went through them, and he would raise them up, and he says, see this book? And he'd give the title, you know, by Amy Baker, or by Douglas Darnell, or by me, or by she. And he would say, have you read this book? Tell us the title, have you read this book? And the expert would say, no, I haven't. And then he would do another one, have you read this book? And you know, he was kind of a showman. So that was one method of critiquing a hardcore critic, somebody who says this is a hoax.
Ashish, we have a question. What was the abbreviation you gave? Child, mother?
I think it's a CAMS, Child and Mother Sabotage. I think it is put forward, if I remember correctly, by a researcher out of the UK, who is a bona fide good researcher in the area of domestic violence and intimate partner abuse and violence. But it's been misused by some groups as if it only applies to women or mothers when alienation exists. But somehow when fathers are involved, you have a problem with the term parental alienation, and this term can be applied, which makes no sense to me.
So Mr. Eggleston stole half my question. So, of course, so I'll say it in another way also. So, sir, you're talking about these PhDs and other people are saying, you know, saying misinformation. Are y'all actually finding that there are therapists that are coming to court saying no such thing as PA?
Yeah, most therapists agree that PA exists. There might be a few who are somehow 20 years behind, but most of them agree it exists. There might be disagreements about what to do about it. Like old traditional therapists say, well, we have to have the kid and the rejected parent meet together, and everybody should share their feelings, and the child should explain how horrible the parent is, and the parent should apologize for things he's never done, and so on. So I think there are some therapists who are really out of date, but I don't think they would. I think almost everybody agrees that it happens. This morning I gave that research from the AFCC meeting in which they asked that question, and 98% of the people in the room agreed that it happens. I can tell you somebody who didn't agree. I can tell it because she came up and met with me after the meeting. And I tell you who it was. I mean, this is not confidential or anything. It was Joan Mayer, who is an extremely powerful opponent of PA theory. And she was one of the 2% who felt that that parents do not brainwash their children.
Well, Bill, I find that interesting because Joan Meyer was on the stand in a Colorado case, and I have a transcript to prove that. And she conceded on the stand that, of course, alienation exists, and of course, it's possible for some parents to turn the child against the other parent.
Yes.
But it doesn't happen as frequently as some people claim it to be. And that was the end of the discussion.
Yes.
The judge moved on afterwards.
Yeah, good.
That case name.
For a practical, practice standpoint, is there anything specific that we need to be looking for when we're looking for an expert to come testify about parental alienation for cases that we're in versus just, somebody who's in the field in general, in psychology or therapy?
Well, every expert tends to focus on certain areas and is strong in some areas and maybe not so much in others. And if you want an alienation expert, you should look at his or her reference bibliography. What have they written? What presentations have they given? Do they seem to accept a reasonable explanation in both directions? In other words, you don't want a person who's fanatically supports PA theory, because that doesn't make sense either. That's no better than denying PA theory. So I think you can partly tell from looking at the person's experience and references, but you can partly tell by interviewing the person, asking, what do you know about parental alienation? Where does it come from? How would you recognize it? If you found it, what would you do about it? So that's another way to vet the person.
I'll say this too, just real fast. What we typically will do is we will take an opportunity to have someone on our team reach out to that person, interview that person, ask for examples of reports, evaluations, whatever it is, so you see what they've done. And I think that's where you get to a better understanding of who you're dealing with when talking about that expert, right? And what role they're going to play, and make sure that they match the role in which you are trying to hire them for. Earlier, they talked a little bit about the therapy aspect, right? And saying, okay, well, what's the actual issue? What's the purpose of the therapy? And I think a lot of times as litigators, we say, hey, we need a therapist. Oh, this person's online and this person says, oh, they're a therapist. Well, great. Hire them, get them on, let's go. I think you have to first understand what it is you're trying to solve for with the expert. And then you need to go to that expert directly and have those conversations and have that level of communication with them. And I think you also need to see their work in order to make that evaluation. That's just my 2 cents.
Another question.
Why does Dr. Geffner so strongly oppose PA theory?
So Robert Geffner is a psychologist in California. He's done lots and lots of work on domestic violence. He started some kind of center for domestic violence, I think, at one of the universities in California. That's his thing. That's what he's an expert in it. I think to the point where I think it blinds him because he doesn't see that there's some wisdom also in parental alienation. I think he's gone so far to that side that he doesn't have an open mind. But he does know a lot about domestic violence.
What we're going to do now is go ahead and take a quick break, about 10 minutes. I think is what we're going to do.
Yes.
And And, go ahead, Ashish, I think that's something to say real fast.
Rod, to your question, I think that's a great question. A few years ago, I wrote a two-part article in Michigan Family Law Journal about domestic violence and parental alienation, two parts of the same coin. And I think this goes back to the false binary I was talking about, as if people think it's either domestic violence or parental alienation. It's ultimately abuse. Even coercive controlling behaviors are considered domestic violence by most jurisdictions now. You don't have to have bruises, you don't have to show blood. Emotional abuse is considered domestic violence as well. And I consider alienation to be part of the domestic violence umbrella under family violence.
Thank you, Ashish. I appreciate that. We're gonna take a break now, 10 minutes, come back. We'll come back, then we'll get set up. I think we'll do the panel.
No, we're doing Robert.
Oh, Robert Garza, I apologize. It's my fault. You actually get to hear from Robert Garza.
My pleasure to introduce another individual that I have just recently in the last 2 weeks gotten to know, but I've learned a lot about him and what he has done. And I don't want to spoil his story because it's phenomenal, yet it's sad, yet it's why we're all here today, and just the things that he has accomplished as a father and as an advocate and just as an individual. So my pleasure to introduce Robert Garza.
Thank you. This bill fixes a fundamental liberty and a parental right. It brings healing and allows the child-parent relationship bond to be rebuilt from the lost time that was taken only on precaution by the court. As it was written now, it puts the burden of proof on the accused parent to prove why they should have that time back, which also requires another hearing or filing, which could cost thousands of more dollars and more delays and more lost time to get that hearing. It shouldn't cost in Texas a fit, willing, and able parent $700,000, 12 years in court, over 43 false CPS allegations. I could have been jailed, imprisoned at any point. I was never charged, arrested, jailed, or convicted. All allegations were false. We had 2 home studies, 2 psych evals, 2 parent facilitators, 2 amicus attorneys, several therapists, several judges. In the 12 years that our children and I have been in court, we have lost, my children and I have lost together about 2.5 to 3 years of that time that was only taken by precaution. The longest I went without seeing our children was about 3 months with just 1 false allegation. The court always gave the children back to me. We always asked for the time back. The court would say, let's just move forward. Let's just hit the reset button. When my attorney pushed the issue, the judge ruled that we would save it for final trial. Final trial came 10 years later with all the games that opposing counsel and my exes were able to play. 2 to 3 times, final trial was delayed due to new CPS report being opened. CPS had to have their case closed to go into final trial. CPS would take 30 to 60 days. Then opposing counsel would have to supposedly open dates. This pushed it back for months. So it would be pushed out for longer. By that time, the psych eval and home study would have to be updated due to Texas rules. Psych eval update took 1.5 years just for one update. The biggest travesty in my case, besides what was done to our children and I, was my ex was able to abuse CPS resources, the district attorney's office, in 2 different counties, 43 plus times. All of these false allegations were all done by proxy. My ex abused the system by making statements to mandatory reporters. Then she would run to court and get an emergency protective order, restraining order, telling the court there was an open CPS report. 100% of the time, the court would grant the protective order to take the kids away. Not once did my ex make a CPS report directly herself. It was all done by proxy every time. I have joint custody of our children. Now, this bill will not affect me, but it will affect the children and parents being hurt after me. Now these agencies can get the children to children faster by not having to investigate false allegations. I promised my family that once I got out of court a year and a half ago, that I was going to do something. Sorry. That I was going to do something to change the system. So no other children and families have to experience what mine did. I stand before you today, and I hold true to that promise. This bill man, that was hard. So that was a speech that I gave in front of the Texas Senate to testify to this bill. So this bill, it returns the resources back to CPS where they can investigate children that are really being hurt. If there were 43 times that I was being investigated, it wasted a lot of resources, not only for CPS, for the district attorney's office, for the court system, all with false allegations. And I'm just one person. I can't imagine multiplying that over how many hundreds of thousands of cases that y'all have to hear. I can tell you that when a child and a parent are separated, it's not like, if you've never experienced it, you know, I hear the professionals talk about parental alienation. It's one thing to, I guess, study it. It's a whole nother thing to go through it. Because they're amazing. Don't get me wrong, I love both of them. Everything they said is true. But when you experience this, it's when that child gets taken from you, it feels like you're grieving the loss of a living child. It is that much hurt and trauma, and I'm a grown adult. I can't even imagine what my children had to go through when you separate them like that. I've been studying this for a long time and going through it. I can tell you that the effects that it has on the children are lasting, not only for them, but for their next generation. So when you're doing these protective orders, restraining orders, knowing that the parent probably has issues, just be mindful that it does have a ripple effect on the children and the families, and even after they're out of court. I hope judges understand that temporary orders are not temporary orders for the most part, because most people run out of money. They don't have the privilege of going through psych evals, home studies, amicus attorneys, guardian ad litems, parent facilitators. I went through that because I was just like, I can do this. It's my children. They're more important than anything. Sold everything. I'm pro se now. Not because I want to, because I had to. What are you going to do when you have no more funds to be there for your children? So I found another way, and I was able to amend the Texas Family Code. I went to Angela Paxton. Actually, let me back up. So I knew nothing about legislation. I figured out, okay, who's the top brass that I need to get to that could help me with this? I ended up going to Trump twice, President Trump twice, Ted Cruz, our governor, our attorney general, they all pointed me back down to, we can't do anything for you. You have to do this through the Senate and the House. Went back down, found out who my legislator was. It was Senator Angela Paxton. Showed her that this I came up with a solution for a problem. Now, let me tell everybody before you start running to your state senators and your House reps, if you do not have a solution to a problem, don't do it. You will waste those resources also. They already know what the problems are. They know. They get emails, they get everything. So when I went to her, I showed her the solution and she thought it was amazing because it actually shifts the burden of proof. And if you read, it says, except provided in subsection 1A. I amended, my bill was 1A. Unless a party shows good cause why the order should not be rendered, a court shall order additional periods of possession or access to a child to compensate for the denial of a court-ordered possession or access that resulted from an investigation by the Department of Family and Protective Services that did not result in a finding of abuse or neglect. This one piece deters people from making false allegations. It will not deter someone from making a real allegation. My ex did this by proxy 43 times. Never once did it directly. Me as a parent, if I thought someone was hurting my child, I would directly go to CPS no matter what the fine was or anything else. A lot of people were upset when I did this because they wanted whoever made the false allegation to be reprimanded. I didn't, believe me, I think they should be reprimanded. But when you're passing legislation like this, you have to be very careful. And when I was doing this, I could have retroed it. I could have had it do my case and I would have got 2.5, 3 years back. That wasn't the point. It was to fix the problem. And if I would have retroed it, it would have made more of a problem. They would have had to come, stop up the court system, getting all the time back and everything else. Hopefully, this will remedy it. Now, move forward a little bit. Well, I'll read a little bit more of this because some people had some questions about it. You get back the same type of time and the same duration of time. So a lot of people read like, well, I didn't see my kid for 30 days, so I get 30 days back. No, it doesn't work that way. You didn't have your child for 30 days. You had them every 1st, 3rd, and 5th for those 30 days. So you get back your 1st, 3rd, and 5th. So let's just say the 30 days. So now with the time back, you end up getting 1st, 2nd, 3rd, 4th, 5th, 1st, 2nd, 3rd. So you get those weekends from the other parent and not just a whole gap of 30 days. Now, if they hijack your Christmas, it also says include holidays, summer possession and access. So if they do hijack your 30 days, of course you get it back. And it's to repair the parental bond that was taken by precaution by the court. A lot of parents get upset with this, but hopefully it fixes it. The child, if they're alienated, since that's what this is about, they're always looking for the behaviors when they come back. So when my children left and they came back after being gone 3 months, they were alienated. They were scared, everything. So I hadn't read any books. As a parent, I needed to learn how to fix this. And I thought about it before they came back. And so I took them to the places. I was lucky enough to have a relationship with my children before a lot of this started. And so my kids were in the system since they were 1 and 3, and they're 15 and 17. We're still in the system because in family court, you can, if you don't like what you got, you can keep refiling. And that's what my ex does. She sold her company for about 100 million 3 years ago. And so now this is just, you can play the game. When my children came back, I was able to take them to places we already had memories at, the zoo, the arboretum. And I'm telling you this because a lot of clients don't know how to fix it, and you don't know what to tell your clients because when you do get the children back, they're alienated. When I took them to the places that we already had memories at, their memories overwrote the alienation. One was hanging on my arm, the other one was on my back by the time we left the zoo. They're like, oh, Dad, don't you remember this? Don't you remember that? Their own memories flooded them and they came back. It was the most amazing thing to see. especially going through this. So hopefully you can give them that. But the child's always looking for the behaviors even after, and I don't know if this happens because I hadn't talked to the professionals about it, but they're always looking for the behaviors no matter what. So if your ex convinced them that you were abusive, do not raise your voice. If you do, it triggers them and all of a sudden they're back to where they were. If they say that, you know, well, you can imagine the different things, you know, if whatever it is, they look for the behaviors that your ex are doing and that triggers them. So just be normal. Do not talk to your children about this. Like, tell your clients, absolutely not. Do not talk to your kids about it. Even if they bring it up, act normal, be like, you know, just, well, you know, that's not true. Or don't even address it. Just be like, well, what do you think? Or, you know, like, we're not going to talk about that today. Kind of just play it off and move on. When the courts stair-step things, this is my own opinion, they took your children. I think they should return the children as fast as they took them. Children are very resilient. You need, in my opinion, this fix the children within 2 hours. I bet they were back to like 80% within 2 hours. When you should have seen them, they were crying, screaming, didn't want to go. A lot of people, so I've also been to about 43 states and testified in front of judiciary committees on these same things. I had a legislator one time be like, well, why would a child say that a parent is abusive when they're not? Well, when you take a child out of when you take a parent out of the home that could, you know, and say that he was abusive or she was abusive, you left the parent with that alienator. And if you don't understand what brainwashing is, who taught the children about the Easter Bunny, the Tooth Fairy, Santa Claus? Those aren't real. How did they convince them? Well, you took the only person out of there. I had 2 minutes to talk, and this is why I get very fast with different subjects all the time, is because you only have 2 minutes to talk to these things. That speech I gave, the gravity of doing that was the hardest, well, one of the hardest things I've ever done. Going through parental alienation and the family court system was bigger. But you only have 2 minutes. I'm in Texas. And the reason I don't throw the judge under the bus, opposing counsel, or anything like that, because it's not about them. They did their job, right? And God will take care of whatever that is. So I did my job and amended this to where it doesn't happen. And that was one bill that I passed. And another bill that's coming is interference with child custody when a parent does this. So now my ex is not making false allegations. Now she's interfering. So I'm like, seriously? Like, I just did that and now here I go again. But I'm not glad that she did, but I wouldn't, had I not went through this or experienced it, I wouldn't understand how to fix it. So interference with child custody is a state jail felony in every state. Prosecutors don't prosecute for it because who wants to give a parent a felony the first time or second or whatever it is. So I'm going to propose a bill that's called 3 Strikes, You're Out, and it has to do criminally, not civilly. And so when a policeman comes out, he's going to give you a $500 fine for interfering. And the second time it's $500. The third time it becomes a state jail felony, what it is now. So I'm just going to try to amend it, and hopefully it'll stop the games before they start. A lot of people talk about parental alienation. Parental alienation can only stick, in my opinion, and I've experienced it if you can separate the child for more than 30 days. At 30 days, it's almost to me that the child gives up hope and they have to almost submit to whatever the narrative is because you put that child in that home. And so with constant contact, that won't happen. And the only way an alienator can do it is with a protective order, restraining order through a false allegation. Hopefully I solved that one. and, or that they can separate with interference with child custody, because they know by the time that you file a, into court, and then it takes days to get in there, they've already separated that child and brainwashed them and whatever else. So hopefully the 3 strikes you're out will disrupt that, to be able to not have the alienation stick. The other thing is, you could tell your people is, before the alienation sticks, or if they're going through the divorce, you can actually go volunteer at the school. It's free, even on either parent's time. That was the most amazing thing that I did, even though the mom said, oh, well, you can't do that. I have, rights and duties, or, temporary orders, whatever. I'm exclusive this, and tried to explain that she could control the school or whatever. Exclusive rights to school doesn't mean, well, y'all already know this, but for people not seeing this, is that it just means that you could pick the school. It doesn't mean that you have exclusive rights over everything. And so it doesn't mean you could say who can and can't come to the school. That little 30 minutes will disrupt the alienation also. So if they don't have a protective order, restraining order, give them that. Another thing is, when they do return home, get cameras in their home. My children hated it. They're like, why do we have cameras in the house? I'm like, I mean, I didn't explain to them. I was just like, it was just oblivious. They didn't like it, but it protects them. It protects your client. At the same time, you could put them on 30-minute or 30-second bursts of motion. Only put them in the common rooms, not the bedrooms, not the bathrooms. I don't know why you have to explain it to people, but hey, some people you have to explain it to. The other thing is, a lot of, when I'm going through family court, I've been doing this for about 14 years in family court, and I never once did this part of it, because I didn't want to explain how my ex was able to play this game until I found a fix. I fixed it. Now I can explain it, because now nobody else can play this game. Had this law been enacted before I went through this, my ex probably would have done it once or twice, not 43 times. And everyone thought that they were doing the right thing. The mandatory reporter that she went to thought they were doing the right thing. CPS thought they were doing the right thing. The judge thought they were doing the right thing, not knowing what threw that rock into the pond to cause that whole disruption. And hopefully you will think about me and my family when you leave, and how this came about, because she had 2 or 3 attorneys before that quit. They were like, absolutely not, after she started playing games. They even put on some of the things, some not nice things, but threw under the bus on their, when they got out of the case. But in the end, you can file anything you want. Let me see. Standard possession. I do have a thing one time too. So standard possession, now, in Texas, we have expanded standard under certain mileage. So standard possessions, 27 to 30% possession time to one parent. Expanded standards, 39 to 40 something, depending on what school districts you're in and what summers you have. At 40%, anything less than 40% is putting our children at risk for alcoholism, teen pregnancy, high school dropout, incarceration. When I looked at these stats, my opinion again, is that the family court has been sentencing our children to be at risk for the last 50 years because of what standard possession was. If we really want to fix this, in my opinion, is a new start at equality. If you're fit, willing, and able. A lot of people don't understand what fit parent is. If you're a joint managing conservator in Texas, you've already been considered a fit parent by the court. Willing is willing to do it, and able is able to do it. And so I think that's about it for most of my stuff. New legislation. I came up with a quote. New legislation must be proposed in such a way that no one can oppose it. When I did my time taken, time back bill, who wants to oppose when you say that the court took your parental rights on a precaution, and when you return that child, when all the allegations have been ruled out, that child gets the time back with the parent to repair the parental bond? You right now, if I said that, who's going to raise your hand to say, I don't think that a child should have that time back with the parent after it's ruled out? You can't. The bill passed unopposed and bipartisan, and Governor Abbott signed off on it on Father's Day, and it went into effect September 2023. I hope when you use this bill and the courts do it. Oh, by the way, the bill has, or the law has been being used. I have heard from other litigants and attorneys that they have used it. Judges are adhering to it, and for a good reason. I mean, you're returning that time to repair that parental bond. So.
Thank you, Robert. I appreciate it, everybody. I want to take a moment, and I want to piggyback on two things. We'll open it up for questions, then we'll take a small break, then we'll do the case study in the panel. But I had a distinct pleasure last night of having a conversation with Robert, and he was very transparent with me. And he's used a word today that I think is very important. I think it's very important for litigants. I think it's very important for the professionals, for the attorneys, and the judges. And he used the word precaution. And I asked him last night, I said, hey, did the court come up with that word? Where did that word come from? He said he's sort of developed the use of that particular word, right? He articulated it that way. And I think it makes a lot of sense, because as a litigator, I can't tell you how many times I've been inside a courtroom and sat and watched the judge tell me, out of precaution, Mr. Eggleston, we're going to do this. Out of precaution, Mr. Eggleston, we're going to say this parent isn't going to get any time with the kid. You heard earlier, Dr. Burnett and both Ashish talk about, you know, we kind of, there's this sense that if you just give the kids some space, this will get better. Everything will calm down. You have these allegations that Mr. Garza talked about. You hear this word being used, and maybe not specifically, but I think it really encapsulates what I hear as a litigator, is we're going to do this out of precaution. And I think that's a problem. I think it's a problem because I get we have to be cautious. But I think we have to start being more mindful of taking those precautions in light of this in particular. And that leads me to the second part, which is, as litigators, it is your job to tell the court about this. I have had conversations in the last 2 months with professionals, including judges, that did not know this existed. I know advanced family law is coming up, so I don't want to steal their thunder. And everyone will learn about it there, hopefully. But it's your job as a litigator to go into court and tell them this is why. I think it's also important that you tell CPS about this. Because, see, sometimes they forget that their actions have consequences. And I think it's important as a litigator, when you've got your client, to not just go to court and make the argument, but help everyone understand what the consequences of their actions are inside that courtroom and how it affects, as Mr. Garza said, not just the litigants, not just the court, but the kids, and not just in that moment, but throughout the duration of it. So with that being said, I wanted to piggyback on that. Please give Mr. Garza another round of applause.
I remembered one thing that I was going to tell you before. So when the courts take away your parental right on a precaution, they're actually violating your First Amendment right, your Fifth Amendment right for due process and your 14th Amendment right for care, custody, and control. They can't do that. according to your constitutional rights. But if they're going to, That's why I came up with this, because if you're going to violate my Fifth Amendment right, my 14th Amendment right, on a precaution, you're gonna return it to.
Thank you, Robert, for that wonderful presentation, and kudos for getting this achieved. It's a magnificent achievement. And I don't say that lightly. You should be proud of doing this. I have a comment about your comment when you say that you don't want to name the judges and opposing counsel, or don't want to throw them under the bus because they were doing their job. For the opposing counsel, I have a comment, and sometimes they're not doing their job. And I've been in a situation where the lawyer that I have worked with previously in a case, who argued parental alienation, argued to the court how parental alienation is child abuse, got the judge to rely on the research of alienation and change custody, only to find the same lawyer a few months down the road argue before a different judge that parental alienation is junk science and a hoax and doesn't exist. And I have filed motion for sanctions. I have tried to argue the judge that the lawyer should be disqualified, because I personally believe it's a violation of the rules of professional conduct. A lawyer has to be forthright and honest and show candor towards the tribunal. It's one thing to argue that parental alienation doesn't exist in this case because of the fact pattern. But I believe that as an officer of court, you can't possibly argue to a judge in one case about PA being child abuse, and another case it being a hoax.
Yep.
That's my opinion.
So I ran into that in the 14 years, had lawyers come and argue something, and even know that they shouldn't be arguing something like attorney's fees as child support. You know you can't do that in Texas. Why would you even argue it? And then if the judge, if we wouldn't have brought it up that you can't do that, the judge probably would have done it. How can you know the law and try something with a judge because you know that they may not know yet because they're a new judge or they were a criminal judge before and not a family law judge? I mean, you have rules and standards that you should go by in ethics. And if you know that you're trying something that you shouldn't, to me, that's just, it doesn't help this problem. It perpetuates it. Anyway, so do you have any questions?
Yeah.
I have a question. I'm curious, just real fast, and you have probably about 4 minutes, so I want to give you a time frame. Can you walk us through just a little bit, because I think Ashish made a very good point. And no offense to everybody in this room, I think y'all are all great people, but there's no way any of y'all get this done. All right? I mean that sincerely. You're just not going to get this done. I couldn't do it myself if I even tried, wouldn't even know where to start. I'm just curious if you just tell us a little bit about how you went from being a litigant to doing this.
Yeah. So I understood what the problem was, and I wanted to find the root of it and how to fix it because any problem, it starts somewhere. And that's kind of what I did with this. It wasn't that easy. I mean, I sit up here and talk to you today. You have no idea how many times I knocked on Senator Paxton's door and they were there sometimes in Austin or whatever, and I was in Dallas knocking on their door, and how persistent it was. I can't even put into words how hard it was to be able to live your life, to go through this, have your family and everything else. There's a whole lot of stuff that went with it. Trial, error. If you want to get a hold of your legislators, if I want to talk to, let's just say, Ken Paxton, Texas Attorney General, super hard to get a hold of. Can't really talk to him. So I was like, okay, how do I do this? Because I need to figure out how to talk to him. So I figured out where he was going to be, and they post things. And so same thing with all the other legislators. They don't want to talk to you, or, it's not, and they don't even know, right? Because other people don't tell them. Or anybody, you find out where they're going to be, where they're going to be speaking, who they're going to be nominating, or election time, and you go talk to them. But again, if you're trying to get legislation passed, if you don't have a solution, don't speak to them. And same, oh, that's one thing I want to talk to y'all too, was if you have a litigant that you know is going through this and you're getting your retainer, I would ask for you to get them a therapist with like maybe 3 hours with a retainer, right? Like once you get a retainer, 3 hours of that goes to a therapist. That way they emotionally throw up on them and not you. It will save you so much time and trouble and heartache and headache and everything else. Let them throw up on the therapist. Take some of that retainer and say, you get 3 hours of free counseling, okay? Right, you do that and then you come talk to me. That will save y'all so much time and energy and trouble. And you will have a reserve to actually listen to other people and whatever else. So anyway, that was just.
So I'll touch on that a little bit. So that's one of the things that for me in my role as a client consultant at the law firm is it's really great because I don't do therapy with them, but I understand parental alienation. I understand where it comes from, what it looks like, how a parent presents and how they're going to show up. And so they get to do that with me in a sense, and I get to walk them through, and then we hand them to Brian and, then he does his deal, but it is beneficial. And I get to give them some of the ideas that I was really glad to hear you share, like go do this with them when you do have access. If you're doing supervised visits, take them to those places that you did those fun things together, get those neurons to fire again, and just talk about the different things that you did. And so I was really glad that you talked about that. And it is important if they have some place that they can go and vent, because if not, you send them to the reunification therapist or to the child custody evaluator or to the guardian ad litem, and then they present exactly the way the parent is potentially saying they present. Oh, he's upset or she's upset and angry and she's just, she's anxious all the time. And so then it kind of feeds that narrative about their behavior. So I'm really glad that you gave that advice and, that opinion.
Another thing I
Yes.
wanted to say was, when someone goes to the military and they're away from their child, have you not seen those videos that when that parent shows up at the school, how happy that child is? That child's been separated for months. Why would you stair step a child, put them back, and you will see that reaction unless there was, abuse or whatever else. But look at that video and think about that next time, or use it as an example to a judge. A military person comes back, you don't stair step them back into that child's life. Oh, and we the parents. I was on Dr. Phil 2 days ago. It just aired yesterday, actually, while I was out with them. They filmed a couple of months ago, but they found me on a documentary called We the Parents. It's an amazing documentary, and you should suggest it to all of your people going through family court before they do it, if they're thinking about it. If you retain them or not retain them, make them watch that movie. It will save you a lot of time, trouble. It's 50 minutes long. It's on YouTube.
Just a quick comment to piggyback up on what Sandra was saying and Robert was saying. If you are a lawyer and you have a client complaining of alienation, and that client is going to undergo a custody evaluation, meet with the guardian ad litem, or meet with a third party, one of the worst pieces of advice you can give to your client is to just be yourself.
Well, that's true.
And I see lawyers doing it all the time. Just be yourself. They will see who you are. No, they won't. The client is going to go angry, agitated, anxious, afraid, full of anger against the system, against the judges, against the lawyers. And he or she is going to present exactly how the alienating parent has been trying to portray him or her to be. So having a parental coach to calm down the anxiety does a huge thing.
That reminds me, so when I was going through this, if your clients are going through this, I had Tuesday dinner nights. I had a bunch of friends because that broke up my week. It's one of the most heartbreaking things going through this. And when you're dealing with people like I was, you need something, an outlet, friends, family, everything. And when the child comes back, there's nothing that your client can say to them to make the parental alienation go away or to get them to adhere to anything. So don't address it. But if they can have friends and family there when the child comes back, seeing the friends and family edify you will make that child understand how they're supposed to treat you. Because all they've seen was the alienator or the ex badmouth and whatever else. And so when they see people that they respect you, then that defeats a lot of the alienation also.
Do you have can everyone hear me? Oh, okay. Okay. Do you have ideas on how to improve the Texas Family Code so that to increase the stickiness of the Children's Bill of Rights, to improve compliance with it by both parents, ultimately the goal being to improve the quality of the child's life?
There's a lot of things that I found over the 14 years to stop a lot of these games and to, where there's not so much like it says shall in mine. Basically, when you return the child, you shall return the time. So yes, there's a lot of things that I found, but I think, and even in mine, when it said in my own, by the Department of Family Services, I wanted to put a Band-Aid and stop the bleeding on what was happening, and that was the biggest one. There's only 15 to 18% of all CPS cases in the US that are reason to believe. The rest of them, when you call CPS, the first thing they ask you is the parent that you're reporting or child in a custody battle? Why would you say that? Like, what's that? Because they know where most of this comes from. So this bill will hopefully since it was done in September 2023, the next census that they done, hopefully the CPS cases on reason to believe will rise because it gave more resources back to the department to be able to investigate the real allegations. But yes, there's a lot of things that need to be amended.
I want to say one quick thing about that too. Dr. Burnett talked earlier about accountability. That's how you do it, right? Accountability. We have a Children's Bill of Rights. We got the Family Code. We have orders that are written down because we thought it was so important. We had a judge sign it. Why don't we just follow it? Accountability, and it's incumbent upon the litigators to go to court, hold feet to the fire. Sometimes, and no present judges in this room, including this statement, sometimes the judges are a little reluctant and find you to be tedious because you're there asking for accountability. That's your job. Keep doing it. Okay, that's how you do it. We're going to take a quick break. Everybody give Mr. Garza.
Brian, I have a quick comment. Sorry.
It's okay.
Mr. Garza, I just wanted to commend you for sharing your story. Brian took my little comment I was going to make. It is about accountability. As a third person, a guardian ad litem, it's our responsibility to understand that he's going to be angry or that she's going to be angry. They're going to be upset, and to understand the situation they're in. I work protective order cases for the majority of my casework. Just because they were not okay as a husband, not okay as a wife, doesn't mean they weren't a great dad or a great mom. Completely different roles, and it's our responsibility, accountability for our own filters and our own biases to ensure that the kids get what they should be getting. Again, thank you so much, Mr. Garza.
Thank you.
Okay.
So there was one more thing. So I'm part of the board for Texans for Judicial Accountability, and we're trying to get cameras in the courtroom. And it will protect the judges, but it will also protect the litigants. And I think with this one piece of this one act of, the cameras are already there. You can see them. The microphone's hanging down there. You can already see them. They're just not for your use. But with those I think it's Michigan, that when you go into their courtroom after a case, they give you a DVD when you walk out. We're hoping to get that here in Texas, and Texans for Judicial Accountability's trying to pass that legislation.
Thank you, Mr. Garza. I agree. We'll do 15 minutes. Actually, we're going to do about 12 minutes.
Sorry about that.
I need a solid 15 is what I've been told. We'll do 15 minutes. so we come back and do the panel. Those of you that are on the panel, if you come up here real fast.
Okay, so next we're going to do the panel. And what we have is a case study, and it's called Meet the Flintstones, and it has Fred and Wilma, and it has Pebbles, Bam Bam, and Dino as part of it. And so what I've asked is for the participants to read the case study, and the way we're going to do this to maximize time with all our local professionals and give them the opportunity on how they would work this specific case if it came to them and to their office. I know there's still a few attorneys left, and so I want to be careful that if you are okay, if you are by chance on a case currently with one of the professionals up here, I would ask that you not ask a case-specific question or something similar to a case-specific question. I want to be protective of your clients and your role, and I also want to protect my colleagues and make sure that I don't put them in that situation. And so they all had my word that I would do that, and I want to stick to that. So if that happens, or one of them can kind of wink at me and be like, oh, I think this is sounding too familiar, then we can address that, but I'm not worried about that. Okay, so how we're going to do the case study is we're going to start as position. What would she be looking at? What would she ask next? What would she think would be important? Then Dr. Mary Alvarez will do the same thing. What does she look at if a case comes to her as a parent coach? Or how does she look at it? How does she train the parents? What information does she provide to the parents about brain development and how the high conflict negatively impacts and affects the children? And then Dr. Eichler is going to talk about reunification. If she has this family in her office, what does she do first? What's important? If you have the parent that's the alienator or the favored parent, what should you as the attorney maybe prepare them to participate in coming into that environment? And then Loretta Mace is going to talk about assessments and how she assesses for parental alienation to rule it in or rule it out. Dr. Amy Baker is going to talk a little bit, I'm sorry, Dr. Kelly Baker, not Amy Baker. Dr. Kelly Baker is going to touch on that some also. And then Loretta is also going to talk about the interventions. What happens when it is a severe case and there has to be that removal? What does that program look like and why does it work? And information about that. So, all right, with that, Mr. Eggleston.
Thank you, Sandra. I appreciate that. I want to start, I guess, this case just appears that there's already been an order entered. They were divorced 3 years ago. There's already been a custody arrangement put in place, an order to follow. There's been findings. And so I want to kind of give that background for those that don't know. Basically, having read through this case study, I think you're going to see that there's some facts in here that you would see in a normal intake. There's some facts in here as you see in a normal intake, probably as if you got this as a PNC. I'm going to talk a little bit about one of the first things that I think is most important as a litigator and an attorney, and it's expectations, period. And it starts in your consult, in my opinion. Because see, they gave you these facts and they're there. You may not have all these facts. You'll have some of these facts, but in some capacity, you're going to have a gist of what just happened. And they're going to be telling you that this is a parental alienation case, or my ex is abusive and shouldn't be around the kids, or my kids don't want to go see my ex. And I think it's very important that you tell them, you start talking to them in the intake, or excuse me, not in the consult, about what those expectations are. Oftentimes I hear from clients that they have talked to other attorneys and they were told, oh yeah, sure, we can do that. Oh yeah, you're right. There's no way that your ex should be around your kid. These types of statements lead to really bad outcomes as far as the attorney-client relationship is concerned. I think it also puts you in some pretty bad space as the attorney on how to navigate the case itself. So with that being said, I think in the consult, you start with the expectations, but once they've been hired, you then need to sit down and do your due diligence and make sure that the allegations in which they are engaging in or which they are providing you, that you've got some sort of basis and you can start to put that, the data together to support it. When doing this, you know, one of the things about it is that you are gathering this data from initially the client, and you've got to manage their expectations of what that data means, right? Tell me what happened last weekend. Oh man, my ex showed up and she was a raging bitch and the kids got out of the car and they were crying and, you know, I had the kids and then they came over to my car and they didn't want to go. And so they went back. I told them it was okay. So that's parental alienation. You got to stop them right there. That's a lot of data points, one for you as the attorney, but two, you need to address what just happened. And I think it's important that you do that and you start giving them reasonable expectations that that statement by in and of itself is not enough to get you where you need to go. But they're going to have to continue to show up and do their visitation. Even when they're being told by their children, I don't want to go with you, mommy or daddy, you still got to do it. Because it's about accountability, like we talked about earlier. I think those expectations need to be set up front of what their data or what their statements mean. I think you need to set the expectations about what you're going to do as the attorney. And then I think you need to set the expectations as to what the outcomes are. No offense, there's only one judge in this room, and so probably it does not apply to her, but none of us know what a judge is going to do, period. And you start telling them with certainty that you know that a judge is going to do X, Y, and Z. I can guarantee you that they will make you a liar, or at least that happens to me. I don't do that. I don't engage in that, but you have to set those expectations. I think once you've set the expectations, then you continue with the data gathering, and the data gathering is important. I think PA cases in particular, but I think all family law cases can be distilled down to data collection, data organization, and data presentation. That's all it is, boys and girls. There's a lot of feelings behind that, and that's why I hired Sandra. And as Mr. Garza said earlier, and I think Ashish sort of piggybacked on it, you should get your client to a therapist or someone to help them with the feelings. But feelings aren't necessarily data points. Your job is to sift through that, pull out the data point, organize it, and then go to court and present it for your client, in my opinion. And so you've got to figure that out. And those data points come from a lot of places. They come from your client. They come from the kids. They come from therapists or professionals. They come from extended family. They come from OC sometimes. And you've got to figure out what all those data points are and then organize them. This is an interesting case study. It brings up a point that happens a lot in the PA cases that we see at my office, where you have someone who's a client and comes in and says, my ex is up to it again. She's alienating me again. She's engaging in these behaviors again. And as a litigator, that should be an enormous red flag, because that means more than likely there's been an order. And more than likely, the offending parent has had this behavior prior to the last order. And as we all know as litigators, that is the figurative line in the sand that you cannot go back behind. Unless, this is the hard part, you have to reprove that that behavior is occurring on this side of the order. And what's interesting, at least in my opinion, is that the offending parents get smart and they learn. And so oftentimes, the more orders that get put in place, they get smarter, they understand how to be more manipulative, use proxies, as Mr. Garza found out 43 times. So it makes it difficult to start to show it on this side. More importantly, your client is going to look at you and say, but we already have this evaluation. We already have this report. My supervised visitation person already wrote this and told the court. It doesn't matter. Because unless you prove it on this side, you can't go back behind the order. So you're stuck with the data that's in front of you. And it's important, again, to go back to those expectations and help your client understand that, hey, look, guys, I get it. And it's important, but right now what's more important is what we can prove on this side of the order. I think as you're collecting the data, I think the other thing that comes up, you have experts. And as we talked about earlier, you need to go get the experts, you need to vet them, you need to do the things, but more importantly, you need to hold them accountable. I'm sitting on a panel with nothing but experts and they're all mad at me right now. I said that you have to hold them accountable because they're the greatest wealth of data points that you can take to court that aren't supported by your client's own words. It's important, right? As Ashish said earlier, you don't just go in and make an accusation of parental alienation. You have to prove things. And all of these experts that are sitting on this panel right now, they're it. And you need them on board and you need to hold them accountable and you need to address them and talk to them and help them better understand your client's position. You need to give them the data, right? You need to help them sift through the data. If your client is the proverbial fire hydrant and he or she is coming at you full force and you say, okay, go talk to the guardian ad litem, go talk to the reunification therapist. They've got to sift through all of it as well. It's not helpful. So what you've got to do is distill it down and make sure that the experts properly see the things and understand the things and are able to sift through it. I think that being in contact with the experts is important. I think maintaining that contact and ensuring that your client is doing the things that they need in order for them to get the data to give you the report or the evaluation. I think it's important, as I said earlier, to tell them up front that this is an X type of case. In this particular case study, we have the oldest child who's saying, I don't want to go with dad. I think it's important to get on the phone and tell them, hey, the child's saying they don't want to go with dad. And guess what? Dad says he can't come up with any reasons at all. And then I called OC and OC told me it was because dad doesn't have any food in the house. That's it. That's all I got. Now, you don't say that as if it's gospel because you don't know that. You just gave them 2 data points. It's what you did. And you need to tell them, I could be wrong. You may figure something else out. The expert may come back to you and say, well, it kind of has something to do with the physical abuse your client has been engaging in. And you need to be professional enough to say, wow, thanks. Greatly appreciate that. Because that happens. And you need to understand that your job is there to help them get the data points, but your job is not necessarily there to keep data points away from them either. And before I pass it on, and I think I've got a question maybe, but the thing about it is that the other piece that you have to deal with is your client. As we talked earlier about sending the client to go do an evaluation and say, just be yourself. It is extremely important as a litigator to help the client better understand what it is that you're trying to accomplish. And each one of these professionals, by the way, represents a different piece of this story. and they solve different pieces. And sometimes they solve different pieces themselves in what they're doing. And so what you have to contemplate is that you need your client to be on the same page. And you need your client to be prepared to give them the data necessary to help the professional do the report, do the evaluation, or more importantly, help your client. And sending them in there blind, I think, is a huge disservice. That amount of prep work will pay off in dividends in my mind. As far as this case, if I had Fred, the dad, we would engage all the things that I just talked about. We would get with Fred and we'd work through those things, but more importantly, we'd sit down and try to get to the sort of the origin of what's going on, what he's doing, what his possession access looks like. We'd work through those pieces and help him ensure that he's doing everything he can be to be the best parent, best co-parent he can be, which will help you as a litigator because then you've got a really good litigant. We would reach out to all the professionals and talk to the professionals about what we expect our client to tell them, what we think the issues are, and what we're specifically trying to solve for, and have those open-ended questions. Once we've got the data and we've got the experts and they're moving in that direction, then you've got a situation where you've got to start to organize all the data and start to present it. And that really starts to get to the space of trial strategy. And so once you've got all the data, right? I said it's data collection, then it's data organization. That's really the big part there. Now, what do you have and how are you going to present it to the court? And I think once you've done that and you start down that road, you start to look at how you're going to approach the court. You need to know what your judge is, who your judge is, what your judge ruled on last week in a contested case with similar facts. You need to understand your client's limitations on testifying. Hey guys, not all my clients are great witnesses, and some of them shouldn't be on the stand. It's something you need to think about, and it's something you need to contemplate in your trial strategy and the things that you're going to do. I think once you start to build that strategy and you understand what you're trying to accomplish in your presentation, then you can start to look towards effectuating that, getting the hearing and going in front of the judge and doing the stuff. I was talking to someone earlier, I believe it was Mr. McCall. I could be wrong, but all of these cases are different, but they're all the same. And when it comes to a PA case, the amount of data and the amount of organization is just unruly. It's almost to the extent of a very difficult tracing property issue. It's data intensive. And you have to understand, you're not just saying, hey, look, mom or dad did A, B, and C. You're going through years of behaviors and manifestations, and you're trying to prove all of these pieces. And you're trying to do that at a level of telling the court why those pieces matter. And so you don't just do that by saying, okay, I've got some files, here we go. And if you're looking at maybe close to 50 to 150 exhibits, you need a way to expedite that presentation and get that data out there and do it in a way that's effective. And so if you're not familiar with how to handle that level of data, I think you need to, as a litigator, contemplate that before you take on at least this type of case. I think that I've answered and said just about everything I can. Probably talked for too long. I think I only offended the panel, which was good. Ms. Rodriguez, I believe you have a question. I got it. Oh, perfect. I believe Ms. French in the back has a question. She'll need a microphone though before she talks because I get in trouble.
For Zoom.
I don't have a question so much as a challenge to you on the res judicata aspect of it, because we can get around res judicata with pattern of behavior. So, right, it's a hard sell, but we can do it, and particularly with the help of experts who might be hearing this information and say, hey, this is a pattern. Now, of course, we have to assess the situation of, is this going to be detrimental to us to bring up this was happening before and yet the court still ordered it this way? Or do we say, which I would think we would, hey, we gave them a chance, judge. You heard them last time. They said, oh, I'm so sorry. I didn't know. I'm going to change my behavior. And yet here we're back again. They've already been given their opportunity. They wasted that opportunity. We need to switch it. And so I think that's where the expert's going to help too, because they get to hear all of that. They're not like, oh, hey, that's res judicata. You can't tell me about it. So mine wasn't so much as a question as it was a challenge.
I agree with you. Michelle's gonna bring the microphone back up here. I will tell you that, I agree with you, Ms. French, and more importantly, it brings up two quick things just real fast. The first is, my experience with PA cases is that every one of them is an absolute dumpster fire when you get it. Okay. And it's unimaginable the lengths that people will go to screw one of these cases up before it gets to you. You will have litigants who have agreed to 50-50 when they had everything that they needed to go to court and prove parental alienation, including but not limited to reports from multiple experts that said the other parent is alienating. So they went to mediation, and guess what they did? They got a 50-50, and there's the order. Now that those reports are behind that line, and you're back to the res judicata, and now you got to prove ostensibly, and it depends on the judge, but ostensibly you've got to prove PA all over again. Now that leads me to this part, and this is an interesting thing that I think is important, and I believe it was Ashish that said it. It's important to have the orders and have some of these orders have a lot of specificity when you get to experts. And if you've got a case, a brand new case comes in and it's a dumpster fire, and you've got orders that precede, or you got reports that precede or data that precedes the last order, you're not precluded from having the experts look at that data. And you need to specify that if you're going to want them to do that. They won't do it just because you said, hey, do you mind? You're going to have to put in a court order that says, hey, here's, I want you to go look at all of these false allegations of abuse for the last 5 years. I know the order was entered last year. Sometimes you get agreements. Sometimes you don't. You may have to go tell a judge why that's important. But it's important for you, if you're trying to accomplish proving that the same type of behavior is happening over here, that the experts see that it has previously happened. And so don't be afraid to say, hey, you know, guardian ad litem, hey, you know, psych eval, hey, a reunification therapist. I want you to see all of these things. And more importantly, it's also important that you go get those things and bring to the expert. And it may mean you need to go highlight, tab, bookmark, put a highlighter to it, put an arrow. Hey, please look at page 2, paragraph 1. Because oftentimes they're busy sorting through that data and they may not see it. So that's all I've got.
Thank you. All right, Dr. Baker.
Okay. All right, this is work.
Yes, so the thing with the mic, it picks up for people on Zoom, so you need to project as much as you can.
Okay.
And then, so tell us a little bit about you and then run with it.
Okay, and let me know if you can't hear me. Sometimes my voice is very low. My name is Kelly Baker, and I office in Georgetown, but I work frequently in counties from Bell County to Bexar County. I am primarily appointed as a guardian ad litem or a custody evaluator. I also do parental alienation assessments, and I also serve as an expert consultant on cases involving PA. So that's a little bit about me. When I am appointed as an ad litem from a very broad perspective, I think of my work as being kind of an investigative process around the concerns of the parents, as well as the concerns that are mentioned to me by the child. And that's really the focus of my work, as an investigation to see about the concerns mentioned by the parents and the child, and what evidence there is to support those concerns in terms of how they affect the child's well-being. When there are issues of contact refusal, one of my primary goals is to determine the causes for that contact refusal, and to eventually be able to make recommendations to improve that issue. In this particular case that we were given on the Flintstones, I know based on the information that I was given that I have competing allegations of abuse and alienation to explain why the child is refusing to see the parent. And so my evidence gathering process is going to focus on the clients and the child, and the attorneys providing evidence to me and documentation to me to support their theory of why the child is resisting contact. In a way that follows the 5-factor model that's been mentioned earlier, because that model allows for me to, and requires that I assess allegations of abuse, and also requires that I look at parental alienation behaviors in the alienating parent, and also in the child. In addition to that, though, I will assess the child in terms of their unique personality and characteristics, and any unique or special needs that they have. Anything that might also help explain why they are resisting contact that may not be have anything to do with the parents. It may have to do with particularly and uniquely who they are. And I would want to understand that, because eventually I'm going to want to offer a treatment plan that addresses all of the contributing factors. And so in this particular case, my immediate concern is that the treatment in place is not working, is ineffective in affecting any positive change in the child's attitude and relationship with the father. And so I have several things that I'll want to consider when I look at why the treatment is ineffective, right? And so one of those things will be, is the therapist properly trained in alienation? Are there signs in their treatment protocol and the way that they have conceptualized the problems that tell me they do not have the appropriate training? In this particular case, there were some red flags, particularly about, I thought that the therapist made some premature assumptions about the father. I thought that there was not enough focus on perhaps the mother's contributions. There was a lot of focus on treating the father and the children, but there was not a lot of focus at all on treating the mother. And that is a common thing that I see in these cases, where the alienated parent gets a lot of focus, because all of the complaints about why the child's refusing contact is about things they do wrong. And then the alienating parent is just, a quiet observer in a way, and they may be a significant piece of the problem, and then their contributions not even being addressed by the therapy. I also saw some gender bias in the therapist's assumptions about the dad. And let's see, I think that maybe that's about it for the therapist. But the other things that I think could be going on is, well, I mentioned there's not a focus on the mother being involved in the treatment to the extent of the father. And then I'm also going to be wondering if the daughter can make improvements remaining in the primary care of the mother. So that's one thing that could be interfering in the success of the treatment, is that there's outpatient therapy occurring, but there's no there's no contact between the father and the daughter outside of therapy. And so there's 1 hour a week maybe being spent on reunification work. And then the rest of the time, the daughter is remaining with the mother. So I may have to consider as a guardian that the daughter cannot make any improvement if she remains in the primary care of the mother, or if there's no court-ordered visitation at all. I will also consider that perhaps dad hasn't done the work he needs to do to change something in his tone or in his parenting or in his communication with the daughter. And I'll look at all of those things when I'm evaluating why the current treatment's not working. I would think that my interim recommendations would be a treatment plan or a treatment intervention kind of proposal that would identify the appropriate professionals to work with the family, that would also identify the appropriate type of counseling to occur. Perhaps it is family counseling, but perhaps it also includes some psychoeducational work for the mother. And then I would also consider asking for court-ordered time between the father and the daughter, so that therapy is combined with actual experience and time with the parent. As a guardian at this point making interim recommendations, I would hope that the treatment plan would be implemented by the court and would be put into a temporary order so that everybody has to follow it. I would stay on board as the guardian in a similar role as Dr. Burnett mentioned earlier. He called it a parent coordinator, monitoring the family, making sure everybody's engaged in the treatment plan in the way that it is ordered, and then reporting back to the court every 30 to 60 days. My reports at that point are usually written, and they go to the attorneys as well as the courts. And I always ask for review hearings like was recommended by Ashish. And then we go back in, and in case there are things that need to be tweaked about the intervention plan, we can do that quickly. We get back in front of the judge and ask for changes. If somebody is sabotaging the success, then we have a way of presenting that information and asking for changes to address that. And that eventually treatment intervention informs assessment, is a saying that we have, where seeing how people respond to an intervention plan tells you a little bit more about how capable they are of change. And so those things inform my final recommendations when we get there about final possession and access and schedules and custody and any further treatment that needs to continue after final orders.
I have a question.
Okay.
Let me go first. So my question is, if attorneys are wanting to appoint you, or I'm going to say the general you, a guardian ad litem, is it more helpful for you if there's allegations on either side about parental alienation or domestic violence, that language be something that is in your order that has you also go look at that, or maybe it's substance abuse? If it's a concern about substance abuse or making a recommendation about residential treatment, is it helpful if that language is in your the order appointing you, or does that cover people? I think people make the assumption that it covers it in a global. if we want you to look at something, is it better for that to be there from the get-go? And also, because I loved what you said about the points of reference to follow up with status reviews, because then that protects you from having to then put that in writing and try to go get it if as attorneys, they jump on that ahead of time. Does that make sense? Is that helpful or not?
Yes, so I think the more specific the order can be, and in general, I think that's helpful to guardians. It is to me to know what is it that the attorneys or the court is asking me specifically to investigate, if it's not just a broad, look at the family. However, I think you can phrase it in terms of to determine the cause or the causes of the breach in the parent-child relationship. It could be something more general like that, rather than specifically identifying domestic violence or PA. But it could also be very specific.
Yeah, I'm glad you said it that way. Yeah, I like that. Questions? I can run back there with the, do we run with the mic? Oh, yeah, and then you run it back? All right. Okay. There was a, right, right there.
So when you were talking about the treatment plan and you were talking about visitation, would you encourage that to be supervised or unsupervised visitation for dad with daughter?
So it would really depend on the facts of the case. In this particular case, there's been no abuse. There had been, what I think, 7 CPS or allegations or reports, and none of it had been founded. I have had cases where I just refuse to ask for supervision because it implies there's something wrong with the parent, or that parent's doing something hurtful to the child. And yet, in a few of those cases, the child then made false allegations against the parent. And had we had a monitor there, we would have avoided a big mess after that, because there was no way. It was basically the child saying that mom or dad did something that mom or dad said they did not do. And then we're in court trying to prove who's lying and who's not. And so I see it both ways, and it just really, it really depends. Yeah. Thanks. So it's a good question. It's something that the courts and people like me struggle with.
I think Mr. Rodriguez has a question.
Yes, I'm walking over there. And if you'll keep the mic, Dr. Baker, this is a mic now. So that way we don't have to do the running back and forth.
Oh, yeah.
So far, we've been focusing on Pebbles, but there's 2 other kids that are involved. As a guardian ad litem, would you make recommendations different for the 2 younger kids after doing your assessment? Or would you recommend the same visitation for all 3 kids, since only the oldest one is having an issue?
Right there. I think there was something in the write-up that indicated one of the siblings was beginning to distance from dad. And so in that case, I would include the siblings to be involved in the same treatment. However, it also can depend on age differences, and what's appropriate for one might not be appropriate for the other. And so again, and I'm not trying to avoid answering directly, but a lot of times it depends on the details.
You're not opposed to making different recommendations for each child if the case calls for that?
Not at all.
I have a question for you.
Okay.
You said that you kind of thought that, let me borrow that. You thought that the therapist had some gender bias, maybe a little bit, particularly towards dad. You also, I think you mentioned that dad whether dad had done the work, right? Yeah, he kind of probably needed to continue to do that work. And it says that during his interview with the therapist, dad appeared anxious, angry, and intense. Let's say hypothetically, dad is my client. And let's say hypothetically, he hasn't talked to you yet, but you've read the therapist's report that says dad's angry, anxious, and intense. And let's just say hypothetically, I am aware of this, I get up front of this, I take dad aside and say, Dad, I get you're going through a lot, but you're hurting yourself. And we clean dad up, right? That's my term. We clean dad up to where he understands the purpose of what your role is and what he is trying to do with you. And he appears not anxious, not angry, not intense. And he's doing things that you would want him to see him do, right? He's doing the work, as you said. How does that change your assessment moving forward?
Well, so what I meant whenever I said that I would want to make sure dad was doing the work, I didn't mean to imply that he wasn't. I would just meant to say that when I'm looking at what could be causing the treatment to be ineffective, that would be a piece I would look at. And so I don't know for sure that he's not. I would not, because of my experience with alienated parents, I would not immediately jump to a parent who exhibits those characteristics as being a problem, or that those characteristics represent the reasons why the child is resisting contact, just because I've had so much experience with parents who are frantic and they're desperate and they're terrified. And I really am sensitive to that, to not make premature conclusions about that kind of behavior from a parent who's lost contact with their child.
I want to ask you one more question real fast. You said there was a phrase that you said, something about information leads to assessment, or tell me what that was.
Intervention leads to assessment.
Leads to assessment. And you need data to get there, right? That's sort of the intervention is go do work, and that leads to your assessment. Is that a fair statement?
Yeah, it provides data.
Okay. I love that you said that, because it's literally, you know, when I was talking earlier, this is what we talk about with clients. Is the litigator, we have to help our clients through engaging the guardian ad litem. And when the guardian ad litem gives you your client work to do, you gotta say, hey boss, you gotta go do it and be good at it. Not just go do it. It's not homework, right? But be good at it, because then that leads to your assessment, right? Loved it. Thank you.
You're welcome.
Any other questions?
Yeah.
Okay.
I have a question, and maybe from a therapeutic framework and not necessarily for this case in particular. Is there, in coming from a therapy side of it, we see a lot of times childhood and adolescents respond well to group work. Is there group work being done for children experiencing parent alienation that's beneficial to the process?
Can you repeat that?
Yeah, basically, Ms. Doggett wants to know, is there any group work that's being done for children that are experiencing parental alienation, to your knowledge?
Not well. So there are a few therapists who do teen groups, and within those groups, the topic of divorce and separation can come up, and it can be that someone in the group is resisting contact, but I don't know of any groups that are specific to parental alienation or the experience of that in the child.
That was a good question. I'm not aware of that either.
Mhm.
So,
I did follow the question.
Francis wanted to know that, just like, let's say Al-Anon, kids, right? So they've all experienced abuse of, alcoholism. Does that exist for children who are experiencing or have experienced parental alienation, that they do group work, like group therapy? And to my knowledge, I don't know that exists. I'm not aware of it.
I'm not aware of any formal groups as such, but there are people who are now adults who experience alienation as children. And they have started to speak out. And they have started to go and lecture and talk about what was it like to undergo alienation, and how did they realize that it was the alienation? And I think Dr. Amy Baker has written about it too, Adult Children of Alienation.
Yeah.
She goes into details about that. But yeah, I agree, there's a need for that.
Good question.
So in answer to your question about is there a need, I think there's a point where a child affected by parental alienation is not open to acknowledging that, right? When they're in the mode of severe rejection, to take that on head on, I don't know that they would even be receptive to it or respond well. The group would have to be more, come at it from a softer point of view, maybe about divorce and about, having two homes or going between your mom and your dad or different rules in different homes, those sorts of things, to address what was kind of going on for them. But then there is the point where there is the acknowledgement and the awareness of what's happened. And that's where I think the panel that Ashish is talking about the adult children of parental alienation, watching them and being a part of their group and listening to their stories would be really helpful.
Thank you.
Oh, and one more point I just want to make about the review hearings, because
Yes.
we've talked about that a lot. One of the issues in I think particularly in counties where you don't stay with the same judge, is that if your review hearing is not with the judge who has been hearing it or made the orders for the intervention, that can be very devastating to the case, because you have to go in and basically retry the whole case, and another judge could come up with a completely different opinion, and then you're back on this wheel of not being able to get anywhere and having new people appointed to the case. And it's just devastating to a case that's been making changes and had 3 review hearings in front of the same judge to then get bumped to another judge. So I just want to say it's been really hard to deal with.
Thank you. I appreciate that. Yes, ma'am.
Okay, good afternoon. I'm Dr. Mary Alvarez. I am a licensed psychologist here in Texas. I have approximately 20 years experience in the family law system. Most of that was in the Houston area and the contiguous counties. I'm a former custody evaluator and currently love living in Austin, love the environment here, love the jurisdictional differences between Houston and Austin. Enjoy working with all of these ladies. And I'm going to speak this afternoon about the parenting piece. That's one of the roles that I have here in Austin. Since I no longer do custody evaluations, I am involved in psychological evaluations, parenting work, primarily, and every once in a while appointed as a case manager to oversee lots of moving parts. So I can say that several times I appear in Dr. Baker's interim recommendations as the parenting professional, and want to advocate here real quickly the role of knowledgeable mental health professionals and multiple knowledgeable mental health professionals involved in one case is profound. Okay, that it allows these matters to take a different trajectory with respect to the mental health outcomes of children than involving professionals who unfortunately just don't have the experience. And so I really enjoy getting to be able to work with other experts. So let me just explain a little bit about how I approach parents. First of all, I want to avoid creating a situation where it's he said, she said. Okay, that's not going to be helpful to anybody. The attorneys get to hash that out. The judge gets to hear all of that. All right. My benefit, I believe, is to create an educational milieu and hold parents accountable based on me helping them understand the neurodevelopmental and psychological consequences to children per the research. All right, per the science and research. And so I might start just to understand some of the dynamics with my parents. I always start with a couple hours of intense historical gathering with each party. All right. I generally meet the children involved, not because I'm going to work with them individually, but because I want to hear from them. You know, I want to hear their voice in this matter. I don't want to tax them and create more toxic stress for them. But I use that information when I work with the parents because there's certain elements in each family that are unique and individual to that family. Sometimes if I don't meet with the children, I make sure that I interview or have a conversation with the treating therapist who is almost always involved. Again, I want to understand the child piece. Then let's assume there's no protective order or findings of domestic violence. Okay, let's just assume that for this conversation. I will try the parents together because that's very, very revealing to me. All right, what do they look like together in front of me when they're supposed to be on their best behavior? And that helps me understand, is there any chance that I could work with these people in a group setting, or do I really need to take a parallel parenting approach with them? And I'll tell you anecdotally that the parents that I'm able to work with in the same room or on the same Zoom meeting are the parents who have less psychopathology. When I have a parent who has an access to a personality disorders, or has other, significant psychopathology, it is so difficult, to work with those parents together because of the imbalance in the power. It could be that the father has the power imbalance or the mother does. It goes both ways. And so to make progress, I'll work individually with those parents. All right. Promoting the same agenda, but I want to protect the integrity of some of this, and especially the parent with the less power differential. So one of the things that I do is I need to educate these parents, and a colleague and I have put together a 2-hour workshop that we do virtually, and we are there. It's not a pre-recorded workshop. We do it every single time from scratch. I mean, we start over every single time we have one of these. And in that, my role in that is to present the science and the research of the ACEs studies or child maltreatment. And I help the parents understand that, the ACEs are decades-long longitudinal research studies that have given us invaluable data about long-term outcomes based on adverse childhood experiences. It could be abuse, neglect, it could be a parent incarcerated, it could be growing up with a parent with a serious mental health diagnosis. But I lay the groundwork with ACEs because one of the ACEs is divorce. So just by the fact that these parents have divorced, your child already has one ACE. And I don't know, early on anyway, if there are other ACEs, but exponentially, the more ACEs, adverse childhood experiences that a child incurs, the more physical and mental health outcomes in the future, deleterious outcomes in the future. So I start with that framework, okay? I talk with the parents about developmental trauma. I talk with them about developmental psychological trauma in this case. I help them understand the basics of the toxic stress response neurologically, how that we're all wired to have a response to a threat neurologically, the release of certain neurochemicals that help us react. But our brains are not designed for long-term toxic stress responses. And that's what happens, with children in high conflict families. And so using this information and helping parents understand that there are real, concrete, evidence-based, research findings-based consequences to children developmentally and neurologically, structurally. It rewires the circuitry of their brain, and all of these very sobering facts. That is my backdrop. So to avoid the he said, she said, I take more of an approach after I've educated the parents that tell me how you are reducing the effect of toxic stress right now. What is your behavior? Help me understand how this behavior is helping your child's brain development. And so I keep reminding them and taking them back to avoid going down this, the vortex of no return of he said, she said. It's just a strategy that I use, and it helps parents, it helps me hold parents' feet to the fire, so to speak. Of course, we work on parenting strategies. I don't want to mislead anybody that all I focus on is the science and research and the outcome studies of toxic stress. I do that, but we work on the nuts and bolts of trying to create a better parenting path, for these children with parental behavior. And so just to segue with Dr. Baker, if I'm involved and she's the gal on a case, I'm communicating with her, I'm giving her updates, and she can include that information in her recommendations to the court. And so it creates just a real nice coalescing of professionals, for the children's benefit. And so let me look at my notes here because I want to give everybody an opportunity. I also do one of the other strategies that I work on, because I have found, again, anecdotally, and love to create research projects someday, is lack of self-awareness. That these parents are so entrenched in the litigation process and collecting data, which I am not criticizing data, but what I'm criticizing is that they get very myopic. And so one of my goals and objectives is to pull them back and give them the much bigger contextual picture. And one of the missing elements that I have found, and Jennifer Harmon and I have actually been, figuring out a way to measure this and create a research project out of it, is self-awareness. All right, that these parents just lack a basic understanding of themselves and their role, in all of this. It's all about creating the data points that implicate the other parent. And so I don't let parents go very far into that rabbit hole. I will pull them back out and say, what could you have done differently? And there's a lot of, eye-popping and hesitations and stammering, because it's not a common thread for parents to have to navigate. And they're certainly not asked by most people, what should you have done differently? And I've heard about all your complaints about how parent A did A, B, C, and D. What should you have done differently? And in this particular vignette that was provided by Sandra, mom, Wilma, is absolutely, she would be, very high on my list of priorities, is to take that approach with her, who has, taken that approach with her. I didn't get any indication in this, and maybe there was somewhere along the way, but that's another strategy that I use to discuss communication, negotiating, compromising, all these other parenting skills that they need in order to meet their child's needs. But I take it from a different perspective, a brain-based toxic stress response. What are you doing to reduce the known outcomes, to your child's brain development, in this milieu?
I have a question. Your SWERV class, would you suggest that attorneys and clinicians take your course, or sign up and be informed about what that looks like as part of the class and what maybe their clients would be participating in?
Yes, so my colleague and I welcome professionals gratis. Okay, we want people to come and experience the 2-hour parent workshop that we have put together based on the science and research of everything I've just been discussing, so that if you have a parent who has attended that class, or you're going to consider sending your parent to that class for the research-based process, that what they're going to be exposed to. You've heard it yourself. You can see not only the sobering statistics, but we have some pretty powerful videos that we use that really illustrate from the child's perspective what it's like for them. And it's heartbreaking. I've seen these videos 80 times, and it still affects me as I'm sitting there watching, these children, communicate to the audience, parents, adults, professionals, what it is like to be involved between parent conflict.
I have a quick question for you, Dr. Alvarez. In regards to this little fact set, you talked a little bit about Wilma, and because I represent dad hypothetically for some reason in this, I don't know that anyone said that. Maybe I just made it up. what would your approach be with dad, and what would what would you be working on with dad in regards to that fact set?
So with dad, he has a very defensive posturing, which I understand. You know, he has been falsely accused, several times. Pebbles does not want to interact with him. I get all of that, but he has to correct that behavior because that abrasiveness in him is also part of the problem in the equation. So that affects her brain development. That affects the other two children's brain development as well. So working with him is, and then this is the kind of case where I probably would work individually with each parent. Probably would determine that putting them together in the same room was very toxic and not going to be productive at all. That I would definitely work with him on how to dial down his defensiveness and put that in the context of relieving the kids' brains of toxic stress.
Would you kind of give the audience a sense, when you have parents come to you, do you ever find any parents that are sort of well prepared to handle the parental alienation aspect in these cases?
If they're the target parent?
Yeah, if they're the target.
No. No,
And it seems like an obvious question. I was taken aback a little bit by what Mr. Garza had said. And he said, he's gone through a lot of different attorneys and different professionals and did the things. I was just curious, I haven't asked him, did anyone sit down with him and explain to him how to navigate this as a parent, right? Yeah. And my question to you is sort of almost rhetorical, but, assuming that most parents come to you and they aren't well equipped, right? They don't have these experiences. How would you help a target parent?
Okay, so if parental alienation has been determined, which in this case it has, okay, the judges already had findings, parental alienation, then yes, more targeted work with the parent who is receiving the alienation about how to react. How do you manage various child situations in which, you're called names, that, the child resists you, the child wants to spend the majority of the time in their room, et cetera. There is a lot of education about the tactics that are used, why those tactics are successful, and what you as a parent can do to mitigate those tactics. Now, conversely, with the favored parent, like with Wilma, there have been findings of parental alienation. I openly use that term. Okay. I don't shy away and use politically correct terms. She's an alienator, and so I'm not abrasive with it, but I use the correct terminology to describe her behavior. Okay. And my approach with her, besides some of the general parenting pieces that we're trying to accomplish, is a lot more emphasis on the neurodevelopmental and psychological outcome studies, and what she is currently doing to increase the likelihood that her children will be one of those statistics one day. Unfortunately, when you have a favored parent who is engaging in the level of alienation tactics, maybe in this case, or even worse, it's really difficult to make much headway because of their pathology.
If I wanted to take your course, where do I find that?
You can contact me. We offer the course about once a month. And so, just contact me and ask me when the next offering is and get you the information. And again, professionals, attorneys, judges, paralegals, mental health professionals, everybody. We welcome anybody to attend and just experience what we have put together.
Thank you. And we're going to hold questions off so everybody can go. And then at the end, we'll grab questions for Dr. Alvarez, Dr. Eichler, and Loretta. Okay. All right.
Okay. My name is Amy Eichler. I am also a licensed psychologist. I'm also a school psychologist. I started out in the schools. And I work right now. I'm a full-time professor. And I do teach about parental alienation in my college classes, which has been really interesting. Someday I should do some qualitative studies on what those students have told me about their experiences. But I also work as a guardian ad litem, an expert, a consulting expert, I've done a few parental alienation assessments, but I do reunification therapy as well. So that's what the angle I'm talking about here. I wear lots of hats. But usually like in a case like this, and I guess it sounded like there was maybe a reunification therapist at the beginning. I'm not sure what that role was. I usually, once it's up to me to assess what is it, mild, moderate, severe, or what's going on here when I get a case like this. I usually do not get cases where someone has figured out this is a moderate case of alienation and this is what's happening. I usually have to figure that out on my own. And I pretty much insist on a court order. Part of that is I need the parties to cooperate. I need everyone to cooperate. It is, and I think there's been made mention of sometimes it's just the target parent and the child who's going to therapy. That doesn't help. I need everyone involved. And so I really insist on that in the court order. One thing I do that's a little unusual, and I just started doing this recently, was I do collect retainers, not attorney-sized retainers, but I do collect some smaller retainers because I get to the point these parents start fighting over who's paying for therapy, and then we have to stall out the therapy process. And if I have to do that too early in the process, it's very damaging. So that's one thing I do. When I first get the family, I try to figure out what support systems are already there. Is there already a guardian ad litem? Is there already a parent coach or a therapist? Is there already individual therapists for the children? I got to figure that out. As she showed this wonderful model, if the judge would just order this, well, that doesn't usually happen in my experience. And I don't get a package, nice little package. I have to figure it out myself. So initially what I do is I do all the intakes with everybody individually. I saw Pebbles came in with mom at 14. I may indulge her one session like that, but I'm not going to keep, okay, Pebbles, come in with your mom every session. I want to hear from Pebbles alone. I don't want to hear with the Pebbles mom combo. That sounds a little enmeshed right there, especially for a 14-year-old. But so I try to do intakes with everybody. I also work on, one of the things I have, Dr. Allen and I created this parent contract. I used to go over the Children's Bill of Rights with the parents and the children, but I get a parent coach who goes over this parent contract, and it's basically going through these alienating behaviors, how not to put the child in the middle, and the parent says, from here on out, I am not going to engage in these alienating behaviors, and they have to sign it. That is helpful. First of all, now they have the education. They can't say they don't know what they're doing, but also it helps me in my later sessions with the parent and the child. I say, look what your parents have signed off that they're not going to do anymore. And you wouldn't believe some of the responses I get sometimes from that. And the kids will go, or they'll tell me later that, oh yeah, that parent did that. So that's one of the things I do. And then I kind of just give them that preparation. This is what to expect. Sometimes with the kid, I need to do more sessions with the children to get that empathy, because you do need to get their buy-in. Now, I don't spend a whole lot of time letting them tell me how bad parent A is. That's not what I do. I try to find out what their viewpoint is, what's going on. A lot of people like to jump to the conclusion that it's alienation. I've had several cases where it's more, in fact, I've had several where like one child picks one parent, one child picks the other parent because both parents are alienating and they're just sick of it. You know, they're just tired of the whole thing and the stress that they're under. So they would be good swerve class participants there. So I do that. There's also, let's see. Yeah, rejected parent preparation. I try to work with the parents, especially when I'm going to have them in with the child. And I think we've talked about some of these rejected parents aren't ready to do that. I do appreciate sometimes when they have a therapist who has some understanding of parental alienation to prepare them. If not, I can send them to someone or I can work with them and try to explain to them, because some of them are their own worst enemy. When they have the session with the child, they sometimes, because they are so frustrated and they're so traumatized, they then start counter alienating. And that doesn't help the situation. And then I'm having to clean up that. So you do need to teach them how to respond to these children. You need to, and it's not typical parenting. It's just not. You're not going to be able to have your kid have dinner with you and discipline your child when you haven't seen them for 3 months. Like, don't insist they eat their broccoli right now. This is not the time to do that, right? So kind of teaching them that you're not going to be your typical parent now. Your authority has been undermined. We need to restore that. We're not there yet. And that can be hard for rejected parents because they just want to be back to normal. They just want their kid back. So, it's different that way. Let's see what, also, one thing I have definitely learned is action. I do this all the time. Actions speak louder than words. Like, I will have favored parents and they can talk the talk and they are smooth talkers and they sound like they are supporting everything. But you try to get them to schedule appointments and, oh my goodness, something comes up, or, Johnny got sick again today. They come up with all kinds of things. And you're seeing what they're doing in the, oh, I forgot to tell dad about this doctor's appointment. So actions speak louder than words. And she talked about the intervention informs assessment. I think of it in terms of school terms. When we do schoolwork, we talk response to intervention. So what I say is how the parent is responding to the intervention tells you a whole lot. So if the favored parent is not responding to the intervention well, that tells you more than the favored parent pretending they're responding. If you suddenly have some good sessions with the parent and child, and all of a sudden the kid is suddenly more alienated and the only thing that's intervened is time with the favored parent, that tells you something right there. That's a response. She doesn't want, if mom's the alienating parent, does not like how things have been going. Mr. Eggleston talked about notes. I am very careful in my notes, and I'm going to tell you why. If I report to an attorney or to the favored parent that things with the target parent and the child are going great in therapy, it's going to go bad. And I've now just put my child at risk. It can be very harmful. I've had kids who have had to record sessions and get advised on how well they did in therapy and presenting their case. And they get chastised and scolded for not doing it right. I am not putting that child in harm's way if I can avoid it. So I a lot of times will say things like process this in my notes, but I don't talk about what exactly happened with that because I do not want to put my child, the child in harm's way. So that's something. So I do a lot of things like that. And sometimes you get to the point where the therapist is alienated. Like parents don't like you because you're doing good work. Suddenly they start turning the kid against you. And so I've had to work on that too. That can be very difficult. What I do like is when there is court ordered after, so many sessions, child is going to see the parent, or after this amount of days. I get a lot of cases sometimes where attorneys say, well, you decide when the kid's ready to see that. No. And we've talked about how that's just a bad idea. Licensure wise, I can't do that. First of all, I can write, and I have done this where I will write the attorneys. There is no, I need her to have, or him to have more time with the parent for me to have more clinical work to do, because we've talked about past issues and now we're sitting here and we don't have anything to do except more engaging in activities together. And it would be good for them to have more unstructured time for us to process later. So I have said things like that, but I can't make orders or recommendations on possession and access. So that's not an option. And in this case, when you look at all the pieces, I was a little surprised, I will say, that the therapist, concluded after just some intakes. I am very careful about keeping that open hypothesis because I can be proven wrong. And I always keep that in mind because sometimes something will come up later on that I'm like, oh, okay, well, this would have been nice to know like a few months ago or whatever. So I don't conclude, but I have my working hypotheses and I work towards that. And that also, I think, protects against confirmatory bias, because sometimes you may find that you don't know what you're that you don't have all the information. But what I also try to do is I try to disentangle, like try to figure out the dynamics. And that's part of understanding every child's point of view in the equation, trying to understand where they're coming from, trying to understand what they're seeing. And I'm not talking about their narrative, because you get past their narrative at some point and you can start hearing, you know, how it's been for them to be in the middle. And I joke with kids sometimes, oh my gosh, your parents agreed on something, you know, and they're like, I know, I can't believe it. They can't even agree on what shoes I'm supposed to wear. You know, the kids will start getting into that. So if you can really understand where the kid's coming from, there's that power and you have that empathy for them, it can move them to start sharing with you what's going on. And a lot of times I've had kids share with me that they know a parent is alienating them before they'll ever let, you know, the alienated parent know that they got mom's deal or they have dad's, you know, they know what dad's doing or they know what mom's doing. Because they know there's a certain point they do have that reality come to them if you do work with them long enough. I'm trying to go a little fast just because. Oh, also on this case, I think I would probably work with Dino and Bam Bam a little faster, mainly because they're closer to where I don't know, I kind of like to build on success, you know, so build on success of that. And the other part of the equation, honestly, is a really huge one. And I think that's Mary's piece. You get those parents co-parenting a little better or parallel parenting or communicating better, you have a whole, things will cascade down and the kids will stop feeling the stress and they will stop, you know, being so, you know, siloed and against a parent. And so I really think the parent coaching can be such a critical piece if you can get them to do it. And I say if, because sometimes that's easier said than done. And some of them are too busy trying to make their case. And I think we've talked about that. They don't know how to just be genuine with their child. They want to document, you know, and they want to film this and they want to film that. And your kid's done. I mean, kids are not stupid. They know when you're recording. They'll say, my dad didn't know that I saw his phone going, recording me. And kids get really sick of it. You know, they really do. So,
thank you.
Fast.
And then we'll do questions also for Dr. Eichler afterwards. Go ahead, Loretta. Loretta's going to talk about assessments. How does she look at assessments and interventions?
Okay, thank you. And thank you for having us here. I have a multifaceted team here and I will try to project if possible. My name is Loretta Mace and I work in a bit of a different capacity than the others on the panel. I do about, I think, 4 different aspects of my job. And so I'll start with one. I provide expert testimony all around the country, regularly educating the courts on parental alienation, on the science, diagnostics, treatment. And that has a 2-prong goal, which I'll talk about in a moment. So the first role is I'm regularly and I'm in all of the different states testifying as an expert. The second role that I do is providing forensic file reviews, forensic assessments, either a file review or a court-ordered assessment. Most of them are file reviews, but we do get orders for an assessment, which is a really different process, plus a file review. Third aspect is I do the Turning Points for Families Texas Intervention Program. Turning Points for Families has been mentioned a few times today. It was developed by the very brilliant Linda Gottlieb. She was supposed to be here today, but she couldn't get a flight out of New York because of the internet outage a couple days ago. So she sends her regrets. But we provide the Turning Points for Families program. I have Turning Points for Families Texas, and families come from all over the United States, both to Texas and to New York. And I'll speak on that in just a moment. The fourth thing that I do is I have a book that I've written for target parents and a class that I've written for target parents. So I work with target parents as a coach, as an educator all around the country. And so I stay busy nationally quite a lot, and I do all around Texas, but stay
one foot in other states regularly. So I want to talk a bit about the diagnostic procedure. The first way to do a diagnostic, an exam, an assessment, is, as I said, as a generic witness around the country about the science of parental alienation. In educating the court, then that is often used as an opportunity for attorneys to ask generic questions about their case that are probative. So I present the science, and then they'll ask me basically a down and dirty assessment. Does this situation in my case, does that apply to the 5-factor model somewhere? Does that apply? So they're able to run the facts of their case up against the science and get a kind of an on-the-spot assessment. We do quite a lot of that. Every time I testify generically, there is some component of providing a generic assessment. And it is generic. I don't speak case specific on those cases unless I've done a thorough assessment. The other way is that I do most of what I do are the forensic file reviews, and what that involves is a very complex, time-consuming, involved, multi-layer assessment of everything that is going on in the case, and that includes what I'm going to apply it to this case. In this poor, sad family, the Flintstones, is there is a lot of information about what's going on in the family dynamics in this case. But okay, louder. What's going on in the family dynamics in this case, but there's no probative evidence of what's going on. So I could, which is needed in order to make an accurate determination of the family dynamics. There is a lot of description of the dynamics, but no probative evidence. And my job is to come in and to look at the evidence and look at it from a scientific perspective, utilizing the scientific method, and assess the dynamics. And that means I am looking at not only all of the legal, the motions, orders, text messages, communications, therapy notes, everything that you would have in a file is included in an assessment. And when I get a file, I give very specific instructions on what I need in order to do a comprehensive assessment. And I always tell parents, what I need from you the most is what the other parent would tell me if they were here. I need their motions, everything that you have in your file, especially what you don't want to show me. I need that in what you sent to me. And I get asked a lot in court. We get a lot of challenges. That is that file review from one parent. Is that really a fair file review? Is that really a fair assessment? And we always say that it's not the source of the information, it's the breadth of the information. So if I have a full range of information, all the depositions, all the trial transcripts, all the texts, all the communications, all the prior, everything that I need, then it's not the source, it's the breadth. So I make sure before I ever get on the stand, I can answer that I've read those 5,000 documents that the client has sent me. And so that aspect in this case, in the poor Flintstone family, is something that I would need to look at before making a determination on any aspect of this, what was needed in this. In order to do the scientific method, very briefly, I cannot make a statement about that without also mentioning my dear friend and colleague, trainer, Dr. Steve Miller. And he wrote the book basically on our clinical assessments. He was a brilliant man. If you ever met him and talked with him and went down the rabbit holes with him and then came back out 4 hours later, you would know what I'm talking about.
I've somehow called him for a 5-minute phone call at 10 in the morning, and at 9 o'clock at night, we're still talking. Anyway, he was a cardiologist, and he taught at Harvard and Brown University for years and years. And he was also he had a degree in psychology. He was very well known in the medical malpractice field. And he and I flew to Boston many, many times to spend time with him, trained with him for years as a mentor and a colleague, and then worked on cases with him. But he brought into our field our parental alienation. We were very lucky to have him while he was here. He has since passed, but he brought into our field his process that he used on medical malpractice cases. And he used to tell me all the time, you can't interview the decedent. They won't let you talk to the doctor, so you have to be able to really read a file. You have to look at the x-ray called this file, and you have to be the radiologist and pick out the most minute fracture, the most minute piece of this file. And so that's the process that he taught both me and Linda Gottlieb, and who also does the forensic file reviews. And so in this clinical reasoning, he developed and he brought in the scientific method. And in order for us to do evaluations, we have to adhere to the scientific method, which keeps it consistent in court in terms of the Daubert criteria. We stand on solid science and clinical reasoning. It keeps the science in the courtroom. And in order to do the clinical the scientific method, there are some fundamental truths that you adhere to, is that this is an entirely counterintuitive, complex issue. We can't rely on intuitive reasoning. We can't rely on observations. We can't rely on our own allegorical understanding. We have to rely on the fact that there are ways to assess this information, and a lot of it is going to be counterintuitive. And so there's a very structured process for doing that. One of the processes beginning generating all the different hypotheses you can generate from the information in front of you, all of the different processes, and look at and apply in the generation of these hypotheses the probability of what these hypotheses tell us about everything the scientific community agrees on in this hypothesis. Given the evidence, what is the probability, given all the evidence, that it could be parental alienation? What is the probability, given what the scientific community agrees on? Is that estrangement, or is that a hybrid, or is it your fourth or your fifth hypothesis? And so relying on the scientific method and the probability requires understanding prior. That what is the priors? What I was just describing is when you have a constellation of symptoms and you are assessing how these constellation of symptoms fit within the criteria. What we know that has already been agreed upon. For an example, using medical model, if you have chest pain, or shortness of breath, and a pain in your arm, the scientific community says you probably need to have an EKG and look at a heart attack. And we have that same process looking at when we have the symptoms. We have the 5-factor model that provides a good process for looking at that. When you have these constellation of symptoms, is that prior going to tell us that the community science tells us you have many of the 8 manifestations that have been discussed today. You have many of the alienating behaviors. There's a strong, good relationship before any of this happened. Their divorce happened, and no evidence of abuse or neglect, bona fide abuse. And you look at this constellation and say there's high probability you're probably looking at some degree of parental alienation. So there's a very structured process in order to look at that. Dr. Miller referred to it, and others as well, but the clinical reasoning process includes many levels of assessment and the cognitive and clinical errors that people make when they're looking at these. And the first one that I would say, so I couldn't weigh in on the poor Flintstone family is I need to consider the total clinical picture before I can weigh in on any of this. I need to understand all of the factors within the 5-factor model. I need to be able to look at the whole clinical picture. And this is my role, how I work, is that being able to make a determination without having that information in front of me, we just don't do. So we have to consider the total clinical picture. It is a long process. We do that in court-ordered assessments as well. That's a bit of a different process because you're interviewing the children, and we interview the children in somewhat of a family systems, family therapy model, and you're interviewing dyads and getting the family to communicate. So there are different ways of going about the assessment. The other way I do assessments is in-house with attorneys, and I clarify it for them. Before you hire me, make sure you don't have a potential child abuse case here or something going on that you don't want me to expose, because I will find it, I will expose it, and I will make it very clear. So before you hire me, you're taking the risk of me being able to really see that hairline fracture in your case, and I'm going to find it in the file and in the assessments, and I will expose it. So I question them and I tell them, be very sure you want me to get involved in this, because it doesn't always work out. This last year, I would say, I try to screen them very well, but many attorneys advocate for their clients and they want an assessment done anyway, and I try to screen them, but it's somewhere been this last year about a 60-40, 60% parental alienation, 40% child abuse cases. And then I end up having to report those. And those, I think that's a really important thing that we've talked about here today, because Dr. Mueller, and this is going to be controversial, but Dr. Mueller used to say, and you probably have heard him say, that hybrids are unlikely and very rare. And in his point of view, didn't exist because if it is a hybrid, then that implies that the one parent has created justifiable rejection. And if that parent has created justifiable rejection, then the assessment stops and you look at, has that parent been abusive? Has that parent been neglectful? Because that takes priority over anything else. And so out of respect for the DV, those who are on the DV side, the domestic violence takes priority if it's in a case. And so if that is there, I look at that as not being a hybrid, because we have to stop and assess, is that really justifiable rejection and not just poor parenting? Just poor parenting, one of the ways we look at assessments is that if a parent has been engaging in behaviors for the last 10 years of a child's life, and it's just kind of jerky parenting, but all of a sudden they're divorced, and now the child is rejecting the parent who hasn't changed, still engaging in the same behaviors, then you wouldn't say that that is really domestic violence, that is causality, because that's the same parent, the same behaviors. What changed in that child's life? If that's the same parent, they have the same relationship, now they're divorced, why are they all of a sudden after 10 years rejecting that parent? So you really have to discern, is this, and look at the evidence. And it's in the file, that I can say for sure. Doing assessments, it is in the file. I will find it. And if there is any hint of domestic violence, or is it just bad parenting? I think people said, children don't reject parents because they make them do their homework or take away their TV time. They don't reject that. It's not proportional. So we look at proportionality, causality, and we have to consider the total clinical picture in making any of these assessments before moving forward. And then ends up in a report and in a litigation. And so I want to take a moment and then address what Linda was going to talk about.
Yes, if you could do interventions in like
a moment.
So that we can have time for questions, because I've had a lot of text messages about questions that want to be asked. So
Okay.
Yes.
So the intervention, the Turning Points for Families program created by Linda Gottlieb is a 4-day program. And I want to explain briefly, somebody had asked, how do you get a transformation in children in 4 days? And I would have to say, and I pointed this out to Linda on our program because I've observed her so many times and worked alongside of her for so many years. She didn't understand this, but as an objective outsider, I could see it. The Turning Points for Family program success rate is really based on the fact that Linda Gottlieb is trained by Dr. Salvador Minuchin, who's the father of family therapy. And she is a true family therapist. And her way of doing family therapy is so unique with regard to anybody else I've ever worked with. She does true Minuchin style. She worked with him for years. She was his right-hand therapist. She was a trainer at the Minuchin Center. And the quality of the family therapy is really what makes the difference in the Turning Points program from my observation. I've always told her, you could be baking bread and you would get the same outcome with these families just because your intervention is your dynamic with these families is so good. So first and foremost, I would say that the intervention is a family therapy intensive program. And it's less important about the things that we teach, the videos we watch, the information, the education, as it is on the process of the family therapy interaction according to the Minuchin style, which is just family therapy. It's just systemic family therapy. So it is a 4-day program. And I've done it many, many times, and as has Linda hundreds of times. And I can tell you at the end of the first day with almost 100% of the families, there was a remarkable transformation in the first day. And we only take severe cases. And the reason why this change happens, it's not just a straight line change, but the reason why it happens is because the first step is getting behind the psychology, behind all of the narratives into connecting the child back to their instinctive, powerful drive for that parent. So it's a systematic process of getting them into that relationship again. And then the days 2, 3, and 4 are dealing with the narrative. The second part of that, it's a highly successful program, is then the aftercare program. So we get clients from all over the state, all over the country, and then we build an aftercare program into each of those clients' communities, working with their attorneys and the local providers, and develop an aftercare program and then supervise that program for the next 1, 2, 3 years, as long as that takes. So it's the 4-day intervention. We jumpstart that healing. And then the work really begins when the client goes back home to the community and they start chipping away that false narrative. So the intervention is a first step, and then it really is worked out as a long-term treatment program.
Perfect. Thank you, ladies. So I'm sure we have some questions. Who wants to go first?
Starting your mic.
Okay. Thank y'all for the information. I don't know if this applies to anybody else in this room, but I know it does to some of the people on the Zoom. What if you live in an area where you don't have any type of professionals like you folks, and you might have one therapist in the area that, maybe is previously counseled with the mom or the dad or did something on the divorce. And so you don't have all the resources that y'all do here or wherever y'all live. And, or there's a long waiting list and you have to hurry to, stop this alienation pretty quick. That's my first question. My second question while I have the mic is, ever since COVID, so much has been done through telehealth, Zoom, and all that. A lot of the children that are in my court are seeing their therapist. This is just totally, I just have a CPS court. So, but most of my children and family are seeing their therapist via Zoom, telehealth, which I despise, but I realize the practicality of it. It doesn't sound to me like that this Zoom or telehealth would be a good, what's the word, thing to use in a parental alienation situation. So that's kind of 2 questions combined. If somebody can answer those, or y'all can remember the 2 together. Sorry.
I'll take the little piece of it if it's okay.
Yeah,
I'll take the little piece of that before Brian does, but If you have a severe case and you have somebody like Dr. Eichler who's maybe doing some reunification and maybe early in the introductions between the parent and the child, you could utilize Zoom or video conferencing to start to have some of that exposure. So, but as far as for therapy, I'll let one of them answer it or.
And I'll let the experts talk about the telehealth. I want to say this in regards to your first question. Having had an opportunity to not only be in your court, but be in the area in which you preside, I agree with that. And it is problematic when you have cases where you don't have a good pool of providers. I will tell you though, that also having practiced in a very large area, a larger populace, you oftentimes get what is referred to, and this is not my term, you get your frequent flyers. And frequent flyers sometimes get a reputation. And it's sort of similar to not having very many options, as you have with your court in your jurisdiction. And we have taken an approach of saying, I don't have to have a frequent flyer. I don't need somebody in this jurisdiction to come do this work. Now, the problem is there's certain pieces that require, as you have touched on, or may require, as you've touched on, some in-person, right, and multiple meetings, multiple sessions, and that becomes a little bit more problematic. But I think as a litigator, and I think even as a judge, respectfully, I think we could look outside of the box sometimes to effectuate the experts that are necessary to engage and help these litigants and these parents. Does that make sense? I'll let the panel answer the other part as far as telehealth. And, oh, fantastic.
The main thing I was going to say about the Zoom situation is I will not do Zoom if a child is in the custody of the alienating parent. That's just asking for them to look over their shoulders. I mean, and it happens a lot. Now, if they are in the custody of, maybe they're in the, there's a no contact period and they're with the target parent, absolutely, if that's necessary, usually that target parent is pretty respectful of their boundaries and does not interfere. But I will not do that. Now, in terms of a case is severe or moderate, usually severe, I have to have a no contact order to get much work done at all. In a case of a moderate case, sometimes I have to get to the point where for the first parent-child meeting, I have the child in my office and I'll have the parent on Zoom because, they're scared to be in the room with the parent, because they're very scary parents, apparently. But I will not do Zoom if they're in the custody of the alienating parent. I don't think that's helpful.
And I want to add that during COVID, we did a lot of the 4-day intensives via Zoom. And of course, the parents would have to be in the state that I was in or that Linda was in New York, but we did the 4-day intensives. And we got to where we really appreciated that process just as much as the live because it kept the therapist in the background and the family dynamic and the family communication in the foreground. So there's a way to do the therapy in your state that can highlight the family system therapy process. And it's not optimal. I still prefer live, but we did find that it actually worked really well.
Sometimes you have to work what you have when COVID happened. Yes.
Is there a cost for the therapy and how much is it and who pays for it?
So I can answer that one. Yes, there is a cost. I don't know exactly what it is, and it depends on what the order says. So I'm not gonna pigeonhole somebody in a specific amount just because I don't know what that is, and it ranges from different practitioners. So yes, sir.
I don't have questions, just some comments. So you want to finish the questions first, then I can share them? Okay. Should I just stand there for the? Okay. So thank you for the wonderful presentation. I will second the thoughts about Dr. Miller, Stephen Miller, who was from Boston. And regardless of whether you are a lawyer, a judge, a therapist, I think it would be very helpful, if not eye-opening, to read Stephen Miller's chapter on clinical reasoning. It's published in the book called Working with Alienated Children by Amy Baker and others. And that chapter is a blueprint about why alienation cases sometimes get so toxic. And he talks about clinical reasoning, talks about confirmatory biases, roles of judges, lawyers, etc. It's a great chapter. The second comment I have to share is about intervention programs. You know, when you start mentioning these programs, which are meant for severe cases of alienation, all of a sudden there is a barrage of demand for peer-reviewed studies. What's the proof it works? Where are the studies? Give us the data, give us the statistics, which is all well and good because we do have those by Dr. Warshak and Jennifer Harmon and others. But no one ever steps back and thinks about quote unquote therapy that was used and which did not work for years. You know, when judges or lawyers or guardian ad litem wants people to go to therapy, it's unspecified. No one talks about data. No one talks about what kind of therapy. Where is the success study outcome for this particular therapeutic outcome? So I think it's unfair that we hold these programs to a very high standard compared to other programs and interventions. And finally, I think this case study, in my opinion, this reunification was doomed for a failure. Because the trial judge made specific findings which are very heavy on alienation and ordered reunification. And I think when a reunification therapist says, well, I'm not going to review the court findings, and I'm not going to review the evidentiary rulings, which the judge worked pretty hard to make those findings, and I'm going to remain willfully blind to those findings and then give treatment, it doesn't make any sense to me. It's a complete waste. And what it ends up doing is to entrench alienation further and lose precious time. I think when a judge enters a ruling after a trial and makes findings of fact, whatever they are, the reunification counselor or the intervention provider must review those. Otherwise, you're flying in blind and it's a waste of resource.
I think we have time for one more question, maybe. I texted her. Yes.
This question is for Dr. Baker, Eichler, and Alvarez. In your testing, when you've done psychological evaluations, have you noticed any correlation between personality disorders and then participating in parental alienation?
I'll answer that since I conduct psychological evaluations along the way. The short answer is yes, and the research supports that the alienators who, if left, unfettered to their alienating behaviors, result in severe alienation, almost always have one of what we call the high conflict personality disorders, borderline, narcissism, histrionic, or sociopath. So yes, and that's what makes that group of parents so difficult and challenging to work with, because it's really not about the child. It's about enacting their rage towards the other parent, and the child's just a conduit or a weapon that they can use.
Yep. I think that's it. Well, you want to close, Mr. Eggleston?
I want to say thank you to everybody that was here today. More importantly, I want to say thank you to the panel for coming up here and giving us your insight. I greatly appreciate that. I appreciate all the questions that we got, not only from y'all here today, but also those of you that were on Zoom. It's an absolute pleasure to be able to have provided a space to have this discussion today. I think it's extremely important simply because this is going on. This is going on in cases that are pervasive across the state in family law. This is going on in courtrooms across the state as well. I think the more information that's out there, the better, the more education, that all of us have, from professionals to attorneys to judges, the better equipped we are to deal with these situations when they're in the courtroom. I can guarantee you that you will have more questions than answers probably when you leave today. And that's okay. I think that's part of what we do. And I expect and I hope that all of us, particularly with our roles inside these cases, we take it upon ourselves to try to get some answers to those questions, but more importantly, help our clients get those answers. I think that without everyone's participation in that, we're going to continue to have these problems, have these issues. And the problem is that nobody in this room, respectfully, is going to be harmed more than the children that are not in this room. And so at some point, I hope that we can come to a space where we can work through these cases. They don't have to be litigated at the level in which they get litigated. They become easier to navigate as professionals, attorneys, and judges for the sake of the children. I greatly appreciate everybody putting up, more importantly, with me than anything else, and all the words that I've said today. I have to do one quick thing. I want to thank, again, Dr. Burnett, Mr. Robert Garza, Ashish Joshi, for being here today and talking. I want to thank again Sandra Aguilar for being the impetus for this. I greatly appreciate that. I have to thank my entire firm, my team. Thank y'all for all pitching together, coming together to make this happen. I know it's been countless hours. I have people that are manning a lot of things that are not here today, that are doing it remotely. I greatly appreciate y'all. Thank you, Michelle, for being here and helping with everything as well. Last but not least, I have to say this, and if you know me at all, if you've had one conversation with me, I have to do this, and I'm going to do it this way. I want to thank my beautiful wife, Janice Eggleston in the back, for spending the time and effort to help put this together and do the things. Thank you. I appreciate it. Y'all be safe. Don't have too much fun. Thank you, guys.